Friday morning. I am Debbie, your host at Alternate Juror, and we are going to jump right into it. We are going to get through the final day of the Matheau Moore trial. So we will do, there's some arguments we're going to do from, that were left over from day 6. Then so she's going to, the defense attorney is going to ask for basically a directed verdict. I think it's called Rule 29 in Ohio. I wondered why she didn't ask for a directed verdict when the state rested, because that's generally the rules, but every state is different, so you never know. There's going to be some argument here. That was at the end of day 6, so I stopped that because I wanted to hear the arguments, and then the judge is going to issue his ruling at the beginning of day 7. So I have those geared up to go. I haven't watched it. I just think from people that did timestamps, they put like a fire emoji by it. So I guess something happens. So I'm curious to see what that is. We have one witness left for the defense. We'll fast forward through jury instructions, do the closings, and then we'll get to the verdict and we'll be done. Hopefully it's a good outcome. I don't know where everybody stands, but I am standing at, I would not convict this man at this moment. So if you feel differently, please let me know, because maybe you saw something that I didn't see. Also, I should probably backtrack, because if you're just joining us for this first time for this trial, Matheau Moore is on trial for allegedly unaliving his wife, Emily, and staging her self-deletion. If you look back through the history of both of them, especially Emily, she is surrounded by a lot of death. Her first husband took his own life. She had friends that took their own lives. She had friends that were dying of illnesses. Her father died, and then her mother was tragically killed in a car accident. And then Matheau Moore's son took his own life in a similar fashion as Emily. Was found in the woods as Emily was found. USB cord. Some guy like, well, if you didn't suspect him of doing something to his son, why do you suspect him of doing something to his wife? They were going through a very hard time. They were both grieving in different ways. Wasn't a good time for them. COVID hit, which wasn't a good time for anybody. And as we all know, that being locked together with your spouse or significant other for a very long period of time resulted in a lot of people going their separate ways. So maybe that was going to happen here. They obviously had some circumstances, that were compounding to the whole pandemic situation. So we're going right into, the jury has just walked out at the end of day 6 that we watched on Wednesday. One thing I can never, there it is my cursor. It's kind of, all right. So we're going to hear these arguments of the defense basically asking for an acquittal. And because I had to look up what Rule 29 was. I didn't know. And that makes sense to me now because she did not ask for a directed verdict. So audio should be good, I hope. Let me know if it's not, and I will do my best to fix it. And I have slowed it down from 1.25 speed to normal because they speak a lot faster when they're just talking to the judge versus somebody on the stand. So here we go.
The presence of the jury, all parties, including the defendant, are present. Stand up or sit down, whatever you'd like to do. It's up to you. I've been keeping some notes on exhibits. I'm not going to say I'm totally complete here, but I'm sure you probably have as well. How would you like to proceed? You want to just go through each exhibit as the numbers come up and letters come up and address whether you want to admit them? I could go through the numbers and the letters as I have them, and hopefully they correspond with yours, if you'd like me to do that.
Yeah, and honestly, I mean, I think that before I can formally say one way or the other on some of these, I might need to look at the exhibits again, because we've had a lot of things where, you know,
That's fair.
mark for identification, or maybe not put the whole thing in, like, there's a lot of that I think we're gonna need to.
I totally appreciate what you're saying, Mark, so I'm with you on that one. I mean, we'll do whatever we need to do to go through these, and I do appreciate it'll take some time, so.
Your Honor, I'd like to, I mean, I think the fact that we move forward, I know where the court's, I would like to make my Rule 29 motion now.
All right.
I mean, I understand that the court,
I know you want to get it on the record, so rather than have to keep you leashed up, go ahead.
I don't think you can keep her leashed up. I like her.
pause and not respond to the leash comment.
Oh, you've been anxious to get this on the
Well,
record,
because
that's my
Judge,
comment.
it's actually not, this isn't about me just preserving the record. I mean, I understand Rule 29, viewing that evidence in the light most favorable to the state. I think even there, it's still, we're looking at the elements of the offense, and one of the elements of the offense is intent. I just think the record is completely replete with that. I do.
I'm sorry, on what?
On the issue of mens rea, of intent. I just don't, I mean, we have text messages that, by the testimony of the witnesses, never even say, I hate you, I want you dead. The worst is, if you want to divorce me, divorce me. And that's in December of 2019. I mean, we have testimony, certainly testimony as to what Matt Moore said. There's no confession. We have testimony which is corroborated by cell phone data that Emily was last seen on May 25th leaving for a walk. But I don't, even all the facts of the case, Your Honor, it's still looking in a light most favorable to the state. Where is the mens rea? And with respect to motive, I understand that they don't have to prove motive. I also understand that the absence of motive, how it can be used by a jury. So that's a separate argument. Where is the intent to kill? Where? And if they are going to stand up and say, Your Honor, the intent to kill is based on Dr. Smock's this finding that this is a manual strangulation, there is zero evidence connecting any manual strangulation to that. Zero. On its best day, there's zero. Forensics, eyewitnesses, cell, text messages, there's nothing. So I don't make the Rule 29 because I want to preserve my client's record for appeal. I in fact think we should never get to appeal because of the lack of the strength of the evidence in this case. But I really, the intent, that you still have to look at each and every element at a Rule 29. Where is the intent to kill? And the felonious dissent is cause or attempt to cause serious physical harm, as this court well knows, and I just say it to say it. Where is the cause or intent to cause? Where is it? Where if, let's just say that there's sufficient evidence of a manual strangulation based on Dr. Smock testimony alone. Oh, okay. Where is any evidence connecting this man to a manual strangulation? Literally saw videos of him. There's nothing on him. No eyewitness, no forensics, no trace, nothing. And so I usually actually make my Rule 29 more long and complicated, but I think with respect to the mens rea, there's nothing there. And in the absence of anything, it doesn't even get over the hurdle of when viewing the evidence in a light most favorable to the state.
Oh, that was short.
Thank you, Your Honor. As the court is aware, this is charged as a murder case. It's not charged as an aggravated murder case with prior calculation and design, which is what defense counsel is requesting basically in her argument regarding intent. But Your Honor, you have to go through and think about what every single witness told you. But you have to take what they told you in the context and the inconsistencies with what the defendant told officers in his interviews, and he is the last person to see Emily alive.
Wrong. Wrong, wrong, wrong. Neighbor was.
And that should weigh heavily. And we know that because of his statements. Now, when you talk about intent, Your Honor, the law and even the jury instructions say
Don't we
because...
also have evidence that Mr. Kramer saw it?
Yes, but by the defendant's own statements, Your Honor, it says that they were in bed by some timeline. So,
I think they were in bed, and then the next day, the following day, Mr. Kramer saw it.
but he also retracted that on the stand.
I appreciate that as well.
Okay. So when you're looking at the timeline and you're looking at the inconsistencies, and there are, you have to
There's not a
also
lot
look
of
at
inconsistencies. There are a few.
Schmuck's testimony regarding this being a staged scene, Your Honor. That is the state's argument, that is what occurred.
I'll tell you what, I think is, for purposes of the motion, you have satisfied your burden for the purposes of homicide. What I'm really looking for is the evidence that you are relying upon to say this individual is the one who committed that homicide.
Exactly.
So please focus on that. I mean, I'm not telling you what to say, but I don't need you to argue the homicide because I'm with you on that one as for the purposes of this motion.
And so focusing on ID, that element, Your Honor?
Well, the men's actus, mens rea, the ID.
I won't pause this very much, but I think the reason that he is asking that, at least I would be asking that, and I am asking that for my own, opinion, is because of the neighbor, right after she went missing, he said he saw her that morning, described what she had on, and then said, "Oh yeah, I think it was the day before. Sorry, couldn't have been because that's been proven she was not home. She's on video. Her and Matt were out doing some stuff. It was her birthday, Memorial Day weekend. They were out. He could not have seen her the day before when he said he did. So chuck that out. They put 2 bloodhounds down on 2 different days, and both bloodhounds tracked to the same place, which is not where Emily was found. Doesn't seem to be a whole lot of investigation done at that spot. What happened there? That's where she's last tracked to. That's here. She's found over here. 4 months later. When did she get here? Who put her there? Did she put herself there? How'd she get from here to here? Did she fly? Was it a crime of opportunity? Did the neighbor do something? There's too many questions about who did it that don't connect the defendant. The police don't know when she was here, and nobody can say definitively how long she was here because they did not do one simple thing, which was walk into the woods. They looked because they could see 15 to 20 feet into the woods. They did not. It's summer, it's hot, it's briars, whatever, for whatever reason, they did not walk into the woods. Had they have walked into the woods, so she was found in the woods down, they never have called it a ravine, so I've not said that. I've just said down a hill. In September. She went missing in May. Found in September. It would have been nice to know if in May, if they would have walked into the woods, was she there? No? Okay. Well, she's not at their house. Their house is not messy. There's no signs of a struggle. There's no rolled up carpets missing. There's no smell of bleach. There's nothing in the house to indicate anything has happened there, except her bed was made. Big deal. She probably made the bed before she left. Hello, Kim. Thank you for joining. I appreciate it. Thank you for saying hi. So, I don't care that her bed was made. My bed's made right now. I make it every day. If my bed wasn't made, that means something's off. So, for me, they have not connected him. We have no idea when she was put into the woods, if she was there that day, if she was there a month later, if she was kept somewhere. What happened over at this driveway? The dogs went there, both of them. Something happened there. Her scent disappears. She's found over here 4 months later. Explain it, and they can't. Does he have a little bit of inconsistencies in his timeline? Yeah, they had been out drinking on her birthday the night before she went missing. Tell me somebody, if you've had a little too much to drink, or maybe a lot too much to drink. I don't know what state they were in. Give me a timeline of your night. It's not really possible. So I believe that's why he's asking, and they have not proven this at all with his so-called inconsistencies. So we'll see what they have to say and how they're going to try to prove he's the one. And nobody's even sure if this isn't just her deciding to exit on her terms. Nobody can say that one way or the other, that she did or she didn't. Not a single person. Also a problem.
Your Honor, you have to recall the text message the defendant sent his friend. His marriage is over. That provides motive sent 2 weeks before, or is it 2 weeks? May 5th? May 7th. So not even 2 weeks before his marriage. He tells his friend in a secret app, my marriage is over. That is his motive for killing his wife, Your Honor.
Okay, so we got a motive.
All right. And
All
that
right,
goes
don't
to
get
his
divorced.
intent. Their marriage is
Grief.
over. Now, when you're talking about the purposeful intent, or the defendant and his intent to kill, you have to go from that date of the text message and then move forward. All right. They go out for her birthday. They come back, and you have to remember the defendant's own statements, Your Honor. Immediately afterwards, he calls and says to her sister, the day, May 25th in the evening, she's gone. He
Yeah,
tells
she
law
was
enforcement,
gone.
I love her.
Oh my
He's using
gosh.
past tense. He is telling her sister that she is gone.
When was that?
May 25th.
Okay.
She's gone. May 27th.
If you can't find somebody, what are they? They're gone. You can't find them. He called her sister. She's gone. Do you know where she is? Big deal that he said, I loved her. If their marriage is over, maybe he doesn't love her anymore. They are grasping at straws, and I would apologize for that pause on that detective back there, but he's one of the reasons we're sitting here watching this right now. So he gets a bad pause. I don't care. This is ridiculous. And they are totally grasping at straws right now. Like, it's sad. This should end. This should have ended. We shouldn't even have a day 7. Like, this should have ended after this ridiculous argument she's already putting up. And I'm sorry. It's just, sorry. It is frustrating to me to listen to prosecutors do this just to try to prove something. If you can't prove it, you can't prove it.
I loved her. No one else, Your Honor, would have the incentive or the motive to stage a suicide. A suicide, by the way, he describes to law enforcement while being interviewed. She would go down somewhere. That's exactly where she was. He's the only person who knew that because he did it.
I'm sorry, he's the only person who knew what now?
That she, where her body was at because he put it there.
Sure he did. And let it sit there for 4
Okay,
months.
What did he say? I apologize. He said what now?
That she, if she was suicidal, she would go down into the woods. Would go down somewhere.
Oh my gosh. Seriously?
And who's that spoken to?
Law enforcement
Okay.
on May 27th.
So he told law enforcement she would go down to the woods where she was ultimately found.
Yes,
Okay.
because he put her there.
You have no proof of that. Zero. He's like, The little prosecutor's like, here's another straw, take it.
Your Honor,
take
his
it.
other actions immediately when she goes missing and afterwards indicate that he knows she's not coming home. And don't forget the manipulation of the crime scene, or the house, I should say, the day she went missing. He is moving courts while law enforcement is there. Magically, a flashlight arrives. And of course, Your Honor, he's manipulating and controlling what law enforcement does from the very first interaction. He doesn't even call 911, all right? So they arrive to the scene.
I thought he called 911.
Well, strike that. You're correct, Your Honor. He calls 911 after Emily's friend tells him to do so on the evening of May 25th. Law enforcement arrives to the scene. He's immediately controlling what they do. Well, I've done this and I've done that. He starts to give a timeline that is not supported by the forensics from the phones. We went into the bedroom. We fell asleep. 5 seconds later on the body cam, we see the bed is made. And then he continues to talk about what happens that evening when they get home. You know, he gets up, he goes to pee, he goes to the other room, and then, Your Honor, he comes back, and in his other statements, he starts to change his story. It's those consistencies, those material inconsistencies, I should say, that call into question not only what he's telling law enforcement, but it circumstantially shows, and not only did he have the intent to kill, he had the opportunity because they came home. There is a 4-hour block on his phone where nothing happens. Nothing. And then we know.
So y'all know right now, if your phone is not moving, you're dead. Or you're unaliving somebody, right? Or if your phone is moving, you are also dead or also unaliving somebody. There's no middle ground here. They will pick each up whatever they need to try to do this. He did not try to manipulate his scene. He let the officers into his home. We watched the whole body cam footage. Look wherever you want to look. Here's this, here's that. Go to the attic, do whatever. Again, I'd like to take her out. Well, I don't want to take her out because I don't want to spend any time with her because she gets on my nerves. But let her have some drinks. Let something stressful happen to her, and let's see how her timeline is. Right? Because you add alcohol, you add stress, again, nobody's going to remember. And if you do, that would be more questionable to me than if you didn't. He hid nothing. He contacted the police. He went to talk to the police. He did everything. The thing he should have done as soon as they read him his rights at the police station was shut his mouth and get an attorney. Detective back there had already admitted after the body cam footage, which I didn't see anything on, but I guess I'm not a detective, so my eyes probably missed something. And the officer's report, it was him, period. Didn't look anywhere else. Didn't look at anything else. It was him. No matter what he said, it was going to be wrong. And they were going to twist it and turn it just like she's doing right now to fit their narrative. Evidence, don't need it. We'll make our own. We'll make it fit. This is a problem. And I will try to stopping this. These people get me so riled up because of what they do to the information that they have that he willingly gave. They're trying to, it's crazy to me. And the things that she's saying, just some of them just aren't true. We just have not seen that we just haven't seen it in the trials. So I'm glad the judge is questioning her. She deserves it. She needs to get questioned harder, in my opinion. I don't know.
He is up for hours after that, and there was no movement. Nothing on Emily's phone after 9 something.
Yeah, after the neighbor said he saw her and she went for a walk,
Your Honor,
like
this
she
is a
does every
circumstantial
day.
case,
I'm with you on that one.
all right? But the court has heard testimony from, I don't know, 20-some witnesses who have provided the opportunity, who have provided the intent, their marriage is over, and even the defendant himself providing statements, how he controls the scene, manipulates the house.
How does he control the scene? Explain that a little bit more for me.
Because when law enforcement arrives, he starts to tell them, you know, everything that he's done. And so by controlling and telling them, well, I've looked in the attic, you know, we don't need to look here, I've looked here.
But he let them.
And then Hollis goes out to talk to another officer. And then when Hollis comes back to the garage, the scene has changed.
But when you say scene, you're referring to the home.
The garage, yes, yep.
A cooler
Okay, go
was
ahead.
slid across right
He's
here.
moving the cord. He moves the cooler. There's magically a flashlight
move the
there
cord.
now.
What is the significance of that move?
Nothing.
Circumstantial. I mean, direct evidence is the cord and the container were moved. What is the circumstantial conclusion of that, other than the fact that it was moved?
Well, immediately he lies to law enforcement, Your Honor. Whoops, excuse me, can you have a little bit more water and get my head?
Okay.
I need a little bit more water for the
Law
lane.
enforcement. He's like, "Oh, I didn't touch it."
Is
But
that
he
lie
is.
significant?
Yes,
Other than the fact that it was just a lie that he moved it?
he's looking for a cord, Your Honor. There is a USB cord wound around his wife's neck. And then there's an orange cord that he's manipulating and lying to law enforcement about moving.
She is straight
He is
up
setting
freaking lying
up
right
a
now.
staged suicide from the moment law enforcement gets there. I don't know. I didn't touch it. We know he touched it. Maybe she did. It's all of those simple
Wow.
actions of staging the suicide from the moment law
Well,
enforcement
listen,
gets
how
there.
does the orange cord have to do with this? And I say this honestly, how does that connect to the stage suicide?
Nothing. It doesn't. It was there. He didn't touch it. He didn't move it.
It's one-on-one here. I just want to say something, if I may, about the staging of suicide. By
Well, I'll tell you what,
your
you'll get an opportunity to respond. I will give you an opportunity to respond. Let me finish
own-
up the safe thing.
Just so it's one attorney argument.
Your Honor,
You take all the time you need. Take the time you need.
She's ridiculous. He did not, all he did, he slid the cooler over. The orange cord is there. You can see it on the body cam. Before the cooler was slid over just a little bit. He was not told, don't touch anything. He was not told to stay out of the house. This is a crime scene. He was not taken out of the house. Nothing. They did nothing. And heaven forbid you tell somebody your marriage is over. That makes you
if he's going
guilty
to
of
stage a
killing them?
suicide, he needs a cord. It is significant that he moves a cord that he could have used to stage a suicide.
Your position is he used a USB cord.
To stage a suicide.
And he moved an
That's already-
extension
Are
cord.
you saying that the stage had already occurred? The act had already occurred when Officer Hollis was there?
We have alleged between May 24th and May 25th, Your Honor. So when Officer Hollis arrives, yes,
Okay, so the cord was already gone. The USB cord was gone already. Okay,
yes.
so I go back to what's the significance of moving the, I mean, I appreciate the fact you say that he lied. Okay, I understand that. How does that move it forward? I mean, other than the fact that he lied to a police officer. I accept that.
Because he moved the cord.
Oh no, don't move cords in your
While
house,
moving
people.
a cord for the staged suicide.
No.
Oh, you mean when it was originally in a position?
Yes.
No way. USB cord. I don't have an extension cord in here. Y'all know what extension cords look like, especially those big orange ones. They're huge. That wasn't getting a cord. Oh, and hey, dude behind Lady Lion here, had you just walked into the woods, we would know if she was there that day. That's all you had to do. Walk into the freaking woods, and we would know. Was she there that day? Or did somebody put her there later? He didn't have her. You guys are freaking ridiculous.
So you're suggesting the cord came from that location?
Yes,
Yes, maybe.
He had
I
to
don't know.
move the orange cord and the container of the water they got the previous day in order to access the cord, is that?
we're asking, we're just saying he moved a cord that he could have used in a staged suicide and then decided to use a USB cord that is the size of fitting in your pocket. So
Wow.
moving a cord
That makes you
and
guilty.
choosing a different one because he needs one to stage a suicide.
Well, your position is he took a cord, I
Oh my
presume from the
gosh.
house, in order to stage the suicide.
Yes.
And that's your position.
Yes, and the cord, Detective Grubbs, I believe, testified, fits into phones that were found at that house.
Oh, be still my heart.
I did hear that testimony.
I hate for
Okay,
y'all to
but
have
I'm
extra
s-
cords around your house.
I confess, I'm just not following the orange cord situation.
Nobody is. It has zero significance.
Oh,
Zero.
and I have another question for you too, and I apologize for breaking your train of thought here, but you said there were 4 hours on the phone and nothing happened. What were those hours?
9:45 and 1 in the morning roughly.
That would be on the 24th,
Yes,
approximately 9:45 to 1.
to 1:11 a.m.
Where they might have been sleeping.
Okay.
And Your Honor, it's our theory that the staged suicide was occurring.
During those hours?
Yes, he is on the phone then from 1:11 until, I mean, does he ever get off the phone?
Is he still on it today?
How do you reconcile that? And I appreciate Mr. Kramer came into the courtroom here to withdraw a statement, but flyers were even put out saying she was last seen at 9 a.m. based upon his statement. How do you reconcile that? I mean, we're just going to ignore that he saw her at 9 and accept, your position is, accept the fact he was in error, he didn't see her. I assume that to be your position, right?
So, Your Honor, for purposes of the Rule 29, assuming the facts and the light most favorable to the
And that's
state,
what I was suggesting to
okay?
you.
John Kramer came in here and said he could not say for sure he saw her that morning.
Okay.
So assuming that fact and most favorable to the light, that means he saw Emily. His testimony was the May 20, I'm getting my dates confused, 24th at about 8, between 8 and 8:30. Because in the garage was his testimony. That's his testimony. The defendant's statements talk about them being in the home. We know the functioning on Emily's phone ceases at 7:30 or 8.
On the 24th.
I don't want to misquote that because we can pull it up at the court.
Okay, but ballpark.
Yes. So immediately after her phone stops, when she is with the defendant, there is no other activity saying that she was using the phone or the phone was being used ever again until he picks it up and starts using it. And that's by his own statements. During that 4-hour period, there's nothing on his phone.
I can't with this woman.
Provides the opportunity, Your Honor, to commit strangulation, which the doctor testified to takes 152 seconds. It is a quick crime. It is a purposeful crime by its very actions. What happens after that is the staged suicide.
Okay, for her theory to work, here's how I see, just by their own words, of what would have had to happen. They go to these springs or whatever, it's in Ohio. They fill up these water bottles. That's how the neighbor can't see her the day before because that's where they were when he said he saw her. They go out the night of her birthday That made up all the same day. I don't, because she's getting dates mixed up and I'm getting mixed up now. They come home. They go out drinking. Yes, they went to the springs and they went to some memorial garden where they had a bunch of flags up for fallen soldiers. They have pictures there. They have pictures at the spring. They have pictures at the restaurant they went to. They go to his dad's. They go to some place called like Old Nail something. I don't know. They're drinking there. They have receipts. They have been drinking most of the day. They go home and they go to bed. Hence, her phone not moving. She is found not in the clothes that she had on that night. She is found in the clothes that the neighbor suddenly didn't see her in the next day. If he did something to her, why would he change her clothes? Also, moving, dead weight. She weighed 100 pounds. Through the woods, they were all talking about how thick it was. Through all that, not a single scratch on him, not a bruise on him, not anything from when he was strangling her and her grasping. There's no scratches on him. Nothing. People that found her had to crawl back out underneath the briars and the brambles, whatever they were calling them, to get back out of there. They said the only reason they didn't have any scratches on them because they had long sleeves and long pants on. Maybe he did as well. I don't know. Her clothes were there in the laundry that she had on the night before, as were his. There's nothing missing. All the stuff she is saying is like taking spaghetti and just throwing it at the wall and hoping a piece of it stays there and the judge picks it up. Because she has said nothing. She's speaking word salad. That's it.
Okay, is that it?
I feel like he was talking to me.
I'm listening. You were pausing.
Are you
I wasn't
done,
sure if
ma'am?
you were finished or not. It's up to you.
Okay. Can I have one moment, please? Your Honor?
Absolutely,
I feel like
absolutely.
Take all you need.
right into this after going at this since 1 o'clock. I need water.
Aww.
Ma'am. All right.
I'll tell you what, why don't we do this? Let's kind of take a break for you to get water, for me to use the restroom. And maybe you could also spend a little time, because I have to make my decision without waiting, but I may think about it overnight because we're going to start up again tomorrow. But I would like to go over the exhibits, so if there's admitted exhibits, I can take a look at those in making my decision. So if you'd like to spend some time talking about what exhibits you can agree to, that might help that a little bit.
Sure.
Because I want to get that accomplished tonight as well, regardless of what the court's decision is on the motion.
No, I understand that, but Your Honor, I know I've been, there's a few other things I'd like to say with respect to Rule 29. Are you asking us to not make those arguments? And I can be
We
less
will
than
do that
60
tonight.
seconds.
We'll do this tonight, absolutely.
Okay.
We're just going to take a break for the moment.
Okay, all right.
Okay? And if you can let me know, let the staff know when you're ready for me to come back in, but if you want to spend a little time talking about the exhibits, that might help too. Because once I hear all your arguments, I'm going to digest, not make a decision tonight here on the record. I will tomorrow on the record. But I'd like to still get the exhibits done so I can take a look at admitted exhibits as well. So I'd like to get that addressed as well. So we'll just take a break. Let me know when you're ready, okay? And you can continue on with the state's argument. And then we'll look at it.
He's probably like, ladies, why don't you just go settle it in the parking lot? Just get all your aggression towards each other out. That'd be okay, right? I think the defense attorney would win. I've said that a lot. I think, yeah. All right. I'm not going to go through exhibits. I really just want to hear arguments. and I know he rules on this, he does not rule on this on this day. He rules on it on days. Oh, there we go. There she is. She's got her water. Or did she get vodka?
Okay, we're back on the record. All parties, including defendant or president, we're outside the presence of the jury. The state's still making any comments you wish regarding the Rule 29 motion.
Thank you, Your Honor, and I appreciate the opportunity for a much-needed brain break to gather my thoughts. Your Honor, this whole case has started with suicide or homicide. And there certainly is enough evidence in light of the criminal Rule 29 for the jurors to determine this was a homicide.
I've already crossed that bridge.
I'm getting there. I'm getting
You
there.
good.
All right. So you have to start there, Judge. And everything must be viewed through the lens of this is a homicide. Okay? So the evidence admitted must be viewed to support the homicide.
Somebody killed her.
So if you
Somebody.
do that, then
Maybe.
you have to look at the way in which the homicide occurred and the staged suicide that was set up to try and make it look like it was a suicide, not a homicide. And there's only one individual that needs to make that look like a staged suicide, Your Honor, and that's the defendant. Your Honor, there is no one else that needs to string Emily Noble up like that in Westerville, Ohio, to make it look like a suicide. And the reasonable inference jurors can draw is that that's the defendant. If the evidence is viewed in a light most favorable to the state, Your Honor, and you look at the evidence from a lens of a homicide, then you have to look specifically at his actions that May 25th window. What is he doing in the condo? Because a homicide that has happened, and he needs to stage a suicide.
But your position is, I believe, on May 25th, in the daylight hours, it's a fait accompli. It's been accomplished, right?
Yes.
Okay.
Yes. So his actions, he tells law enforcement, well, one, he has to sleep. One moment he goes to sleep. He has to say that, Your Honor, immediately, because his wife, he's got to start building the story that his wife has disappeared, right? He has to tell law enforcement that he doesn't know where she's at because he was asleep. The next instant he says, I slept in, and by his own words, that's abnormal for me. So he has to say that so that he can say that he doesn't know where she's at, that she's disappeared and she's wandered off. And then, Your Honor, he wakes up in an 800-foot square condo, texts Emily's phone at about close to 12 p.m. He doesn't get up. Then he uses Find My iPhone. He doesn't get up. He doesn't go look for her. He does nothing. If this is a homicide, Your Honor, he's taking those steps to support the suicide, that this was a suicide. He has to start creating those physical records that he doesn't know where she's at. And that's why that evidence immediately afterwards is so important. Now, most telling, no, I won't say most telling, it's a decision for the jury.
I wouldn't say most telling either,
He
because you
tells
don't have
Officer
anything
Hollis
to tell.
when he gets to the scene later that evening about this walk that they go on, this path that they forage. But he says to Officer Hollis, he's never checked.
No, so you never went?
Checked. He never walked that route that day. He, the defendant himself. If your wife is missing, has disappeared, is engaging in what he even says is uncharacteristic for her, and to the point where you call law enforcement and you've done nothing, and the inference is, Your Honor, he's done nothing because he knows she's dead. If your wife is missing, you are scouring the earth. You most certainly are walking that path every single minute until she's found, unless you know she's dead.
You guys
So,
didn't.
Your Honor, you have to view that behavior in the light that this is a homicide. He doesn't go and look for her, even immediately after saying she's disappeared and called law enforcement.
There was a point in time when Officer Hollis was there. I don't know how significant this is, but I'll ask you the question. When I believe Celeste drove up, and Officer Hollis said, "Is that your wife?" And he goes, "Yes." And then he goes, "No." If he had killed her, would he have said yes in the first instance?
Because
Your Honor,
Celeste looked like her
that
at
is
first
a
glance.
fact for the jury to determine, and what weight to give to that, Your Honor. We're at, talking about the overall picture for purposes of Rule 29 and whether the evidence can support a rational juror making these inferences. And that is a point that's in the video. But, Your Honor, I would argue that his reaction is something different. And I don't want to make every single argument in this Rule 29, Your Honor, about our case. And I mean that respectfully.
Because we don't have one.
I'm not sure I follow you. What you want to make every argument?
I don't want to give my entire closing argument, Your Honor. Should we get there? Okay?
Okay, sure, absolutely.
All right. And then you have to also consider.
We know
the
you won't
defendant's
believe it, but the
behaviors
jury might.
Immediately after the next day, and the following day, also in the light of a homicide, continuing that he needs to push this, it's a staged suicide. I don't know where my wife is at. John Kramer says he noticed he was smoking in the condo. And John Kramer said he knew in that instance Emily was not coming home because the defendant is smoking in the condo. He continues to refer to her in the past tense, which
Sorry. Do smokers really smell smoke? Right? Their senses are dulled from smoking. And that is just, well, I went over there the next day and I smelled smoke in the condo. They're not allowed to smoke in the condo. So she's dead. That's what she's saying. Maybe he was pissed off at her. So he's like, I'll show you, I'll smoke in the condo. Guess what was never found in the condo? There's no ashtrays. There's no signs that he was smoking in the condo. That's on the body cam, and then all the still images that they all took. There's nothing to say that anybody smoked in the condo. And I'm sorry, neighbor guy has been proven to not be super credible. Maybe you should have looked at him.
I belabored before, so I'm not going to say that again, Your Honor. So those two things also, Your Honor, point to the fact that he knows she is dead and that she is not coming home, and the reasonable inference is because he killed her. And it's important when he shows up to the interview with law enforcement, if he truly had no reason to know, he had just woken up like he wants law enforcement to believe, he has no reason to think she's dead, but yet his first words are unprompted, "I didn't do it."
Well, hang on a second. He's just been taken down to the police department in a cruiser. He's behind doors.
Your Honor, I'm
He's
making a
given his
rule
Miranda
statement.
rights.
Your Honor,
Exactly.
I
Thank you,
understand,
Your
but I'm
Honor.
making an argument for the facts in a light most favorable to the state, okay?
Fair enough, fair enough.
In a
My
light
bad.
most favorable to the state, all right? His actions and statements are that of an individual who knows his wife isn't coming home. He refers to her in past tense. He is smoking in the condo. He says, "I didn't do it." Your Honor, this is a staged suicide, made to believe manual strangulation is like a suicide, and his behaviors immediately after that demonstrate that he is an individual who already knows his wife is dead. He's acting like she is dead, and his behaviors indicate that, and he won't can't act that way if he doesn't know she is dead, Your Honor. He is the only individual that has the need to make this death appear to be a staged suicide. And, you know, we talked a little bit about his words, and I just want to remind the court, too, that John Kramer also indicated that he overheard a loud argument shortly.
Oh, dear Lord in
days-
heaven,
I
don't
know
any of
the
you argue
exact
with your
time frame right
significant
now.
other.
I think a couple weeks.
Yeah, he
earlier.
didn't know what it was. It was a couple weeks
2 weeks.
earlier. Can say what it was about.
2 weeks
Couple weeks.
before, yes.
So John Kramer is the neighbor that I keep going back to because John Kramer seems to have a ton of information about this couple. Kind of weird, kind of creepy. He smoked in his garage. Seemed to watch them quite a bit. That's why I keep going back to him. He seemed to kind of know a lot about Emily. It was weird. And then he starts retracting stuff and really, really, really wants to throw this defendant under the bus. Just my opinion. Not saying he did anything. Not saying he didn't. But I wouldn't, if I was them, I wouldn't be relying on him at all for any of my stuff to make stuff credible. Like statements to make my statements credible. I would not rely on him at all because he wasn't credible on the stand. He's not credible now in her statements because he's changed them so much. Seemed like he was kind of making up the whole smoking in the condo thing. I mean, they can take the smallest thing you do in your life and put you in that defendant's chair if they want to. And that is scary.
Thank you.
Thank you, thank you.
All right, come on,
last word?
defense attorney.
Judge, as you know, one of the elements for the murder is purpose. It's the mens rea. You need to have specific intention to cause a certain result. The court is right. There is enough evidence in the light most favorable to the state with respect to the issue of was there a homicide committed? Don't disagree with that. With respect to is there any link between Emily's possible manner and cause of death to that man? No. It's one of those things where we can
I
say
think we've conceded there's no direct evidence at all in this case.
there's
It's all
no direct
circumstantial.
evidence, but circumstantially also. To say an individual who already knew his wife is dead, Your Honor, that's not circumstantial evidence either. That is inference stacking, and the court well knows that there's an instruction literally against double stacking of inferences. Can you draw one inference from a set of facts? Yes. Can you draw an inference upon an inference upon an inference? No. This case, Your Honor, with respect to connecting any manner or cause of death of Emily Noble to Mathew Moore is completely void of evidence. And I don't say that, and I want to say this because I know how defense attorneys are perceived sometimes. I am not saying that to preserve the record. I am saying that because this is absolutely, under no circumstances, a case that should go to jury. It is literally nothing to tie him there. You talk about the stage scene. This stage scene, well, first of all, I know that Dr. Smock issued a report and testified, but let's just go to that scene. They want to say it's staged. Okay, they have Dr. Smock saying that. Who, where, what, when do they have to get Matt Moore to that scene staging? Now, I've just heard the prosecutor say that there's a 4-hour window of time during the night when most of us are sleeping, and when, by the way, he said he was sleeping. That is a time when nothing is going on. The cell data certainly supports that. It's during that time that the state is arguing, based on speculation, that that's when he killed her. That's what they just argued, and they certainly implicitly argued that through the testimony of Detective Grubbs. But we know, Your Honor, that John Kramer sees her at 9 or 10 a.m. And I want to say something interesting is that the state just now, in its Rule 29 argument, used John Kramer twice at the end to support the smoking of the condo, right? And I forget what other point about John Kramer. They just can't have it both ways, Your Honor. John Kramer did not come in here and retract his testimony. That's not what it was. He said he cannot be positive that he saw her on the 25th. But we know, Your Honor, from the cell phone records, that on the 24th at 9:39 a.m., she's in Butte, Ohio. Not only do we know that from the cell phones, but we even have photographic evidence of her there as well at the Springs. We know from the testimony of Detective Grubbs that it's an hour and a half each way. So when you look at what John Kramer said and then his testimony that he can't be 100% sure, the cell phone records are everything. Because what he did say is it's either the 25th I saw her or it's the day before. And we know it couldn't have been the day before. So she's alive on the 25th. She's alive. And Matt, they want to use Matt's words against him, but Matt Moore said to the police that he woke up late morning, consistent with 9 to 10 a.m., John Kramer saying her. And it's not just John Kramer that says that. We know that from Officer Hollis's video, that that's what he told Officer Hollis. And Your Honor, Defense Exhibit G is literally the Westerville police report, that's the press release that says she was last seen at 9 a.m. That's from the Westerville Police Department. That's not influenced by Matt Moore. That's not Matt Moore. That's the Westerville Police Department talking to the public. She's alive on the 25th. He calls 911. You know there's a GPS on his car as of the 27th. The 26th, he's giving statements with law enforcement. He's taking them to the area and saying, she walks this area. Now, the prosecutor wants to say that did he check that area in the absence of a search means he must have killed his wife? But we know from testimony, even from Amy Thomas, I asked her at the end of her testimony, just because you didn't come to Ohio and search for your sister, does that mean you don't love her? And she said no. That's nothing, that's speculation, that's inferences, and it is certainly not, even when viewed in a light most favorable to the state, enough to put this case in the hands of a jury. Purpose, Your Honor, is the specific intention to cause a certain result. Where does it show he intended to kill her, that staged her? And Your Honor, I want to talk about something that I wasn't allowed to ask about, but now it certainly seems relevant. You know, as a former prosecutor, the state has the power to file charges, put evidence forth in front of a grand jury, and importantly, they have the ability to amend an indictment at any point. This is a case of 2 counts of murder and 1 count of felonious assault. There has been so much about this cooler. First of all, there's no evidence that USB cords were ever kept in the garage. But Your Honor, he's not charged with tampering with evidence. And you know what else he's not charged with? Abuse of a corpse. How does she get to the park if their theory is the crime scene is at the house? And I will tell you that during his testimony, Detective Grubbs actually said, I asked him why you didn't do all these things at the house, and he said, certainly, if I ever need to get there, that it was not a crime scene. Because there's nothing to prove that anyone was killed inside of 46th Avenue Cross. To say someone was killed there is speculation and is an inference upon an inference upon an inference. And then they want to take you that she's killed there, and then somehow, under the cover of darkness or lightness, she's moved to an area where we know you can't drive a car along county roads. We know from the women that found the body, you can't walk through on the other side without crawling under branches. We know he's 6 feet tall. It's just, Your Honor, there isn't even enough. There's nothing to connect Matt Moore to the body in the woods. And they can't just focus on nobody else would do this. That's certainly not enough to go back to the jury, just because they don't have another suspect. Purpose is one of the elements. There is no evidence of purpose. And if the court is unsure, the best they have from his mouth is the text messages. And they have an individual, and if you want to now believe John Kramer about the arguments, that was the other thing that John said that was
I'm sorry about that.
the arguments, that was the other thing they were relying on John Kramer for. The arguments and the smoking. Your Honor, I asked John Kramer, and there was even a follow-up question from a juror. Did he hear arguing the night of the 24th or the 25th? And he said no. Also, Your Honor, with respect to John Kramer and the smoking, I went over the detective of all of the photos of if there's any ashtrays or cigarettes taken from the house, and there were none. Your Honor, this just can't be a case that goes back to the jury. It is speculation, and it is truly exactly why that inference stacking instruction exists in OJI. That's what we have here. Thank you.
I'll consider the case submitted unless you want to keep going back and forth for a while.
I just want to make three brief comments, Your Honor, okay? Defense counsel.
And I'll let the defense respond as well.
Defense counsel has commented quite a bit on the credibility on the witnesses, and
And I
if you
understand,
believe
I understand where credibility falls in here, so I'm good with that.
Okay, so credibility is not a Rule 29 decision, because
Right.
you must,
I'm there already, I got
you
it.
must view the evidence in a light most favorable to the state, Your Honor. No one has said that the state's theory is that this crime was committed at the house.
We have no idea what this crime is, right?
It could have been committed in the woods, Your Honor. where
Or
her
at that
body was
driveway
found.
where her
That's a
scent was
possibility.
lost.
And the evidence supports. And I do want to talk about John Kramer for a second, because
Well, we've already come to the conclusion, I'm not going to consider his credibility. I'm just considering the evidence in the light most favorable to you, which I will do. So I don't need to worry about his credibility. No, I mean, I'm not being demeaning, I'm just saying, I'm with you on that.
so purpose to cause a certain result. Dr. Smock has established the manual strangulation and the elements needed to establish purpose, Your Honor. There's motive, there's certainly opportunity. He is the only individual who needs to make this look like a staged suicide, Your Honor, in addition to absolutely everything else.
Anything you'd like to say?
Yes, Your Honor, 24 years and truly over 150 jury trials, and I can't believe that we're into the defense case and we still don't even know what the theory is as to where she's been killed. And that really goes to my point. This is a case that the state has been trying to develop as we go. And quite frankly, it's just not fair. My client sits here charged with murder, 2 counts, 15 to life in prison. It just isn't, the system has to be better than this. And I really do mean this with all my conviction. How are we here when where she's killed, we don't even know. We don't even know that. And it's not like we know maybe. We don't even know that.
We can have a homicide without a body, right?
Well, we can have a homicide without a body, but we have a body in a wooded area. And nothing to tie Matheau Moore to that. And it's not just the lack of physical evidence. You can't get around purpose. Smock, Dr. Smock, he can talk all he wants to about manual strangulation. There is zero evidence this man strangled her. Zero. I mean direct or circumstantial. And I recognize it's not the court should look at it through the lens of a homicide. The court should look at it, I understand, through the lens of evidence in the light most favorable to the state. It's still each and every element, Judge, as you know, for it to go back to this jury. Where is there even a scintilla of evidence as to purpose? There's none. I would ask the court to grant a reclaimer.
I seriously hate these closed
All right.
captions.
I will consider it submitted, and obviously, since I have to make the decision right away, I will do so on this issue tomorrow morning before we begin anything else in the case. You've had an opportunity to talk about exhibits at this point. Let's at least get that so I can consider those exhibits as I ruminate on this issue. I think I was presenting.
All right, we're not going to do the exhibit stuff. We're just going to go to the next day. I really, I would assume it's because the state has the burden here, but the whole, all this stuff having to be favorable to the state kind of bothers me because, and I get it because they have a burden. I get that. But the defense has no, come on, spinny circle. The defense doesn't have to, the burden's not theirs to prove him innocent. So this is really bothering me. I would think that he would get, to me, it just seems, that it would be in the light most favorable to him. But I'm not an attorney, so I'm sure one could explain it to me. But because he doesn't have, what is going on here? The burden of proof on his side, to me, he should get to be looked at in the most favorable, light most favorable. Hello, Bree. Thank you for joining us. There we go. Hallelujah. It's a miracle. I will try my best to make it through. The prosecutors closing arguments, because if they're going to be what we just saw, I'm going to need help. I'm going to need all the help. Because what she just said, and there's just so much that's not true. There was just so much that wasn't true in that. So he's going to rule. I don't know. Like, something's going to happen. Kim, you mostly missed me. You mostly missed me ranting about the prosecutor and all the crap she was saying. She was just trying to connect him because the phone wasn't moving for 4 hours. So, that's, you're dead or you're being unalived. It's one or the other. If your phone's not moving, if your phone is moving, you're also dead or being unalived. If you speak of somebody in past tense, you've unalived them. If you want a divorce, you've unalived them. If you've moved an extension cord in your garage, you've unalived them. If your neighbor, who is not credible at all, says you smoked in the house, he smelled cigarette smoke in your house the next day, even though he's a smoker, you've unalived him. If you've been drinking the night before and you're not exactly sure of your timeline the next day, also an unaliver. If you let the police in your house and let them search for anywhere and everywhere, also an unaliver. If you go to the police station and say, I didn't do it, after being taken there in a police car, taken behind locked doors, and read your Miranda rights, also an unaliver. I think I've hit all her points. Most of them. You'll hear them. Yes, the old phone data. Ugh. So annoying. He looks happy. Come on, law and crime, get in focus. That's not me. My sound is on. That's them. Make sure. Yeah, I'm up all the way.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff...
Your objection is noted.
So shut up.
Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was put
You're
on
going to sit
notice of
here.
her unavailability,
You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what, if you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
Bye. Big baby. Don't cry. Cry to your mama.
I prepared my remarks and my decision here today. And I am, I guess, I am glad I had the opportunity to spend the night to do some deliberation on this matter and think about it. But I want to kind of begin with a sidebar before I go to the motion itself. And it's an apology I'm going to make to the defense team here. Before you made your motion, I made a few statements that were probably an effort at humor, but I think they could have been interpreted as intemperate, unnecessary, or perhaps even offensive. And that was certainly not my intention. And I likewise did not in any way try to imply that your motion was simply a matter of the record and an administrative act and perhaps without merit. And I say that not only because that wasn't my intention, but your arguments were well-spoken, compelling, well done, and very professional. And in fact, I want to say that both lawyers have been professional throughout this entire case. You're the kind of lawyers that any judge would want on his or her docket trying a case. And I want you to know that. And I regret a lack of reciprocal professionalism for that moment there, and I wanted you to know how I felt, and I wanted to share that with you. It's not reflective, I hope, of who I am.
Oh, that was rare. That's nice of him
The
to
court,
say that.
as I said, has had an opportunity to consider this case for a significant period of time last night. And I note that in my 20 years, both as a sitting judge and a visiting judge, I have rendered decisions on Rule 29 motions in every criminal case, and I've denied those motions and I have granted those motions. But I think I can say this has been the most difficult motion for me to consider. And again, I'm glad I had the time to reflect upon the arguments made by counsel. And I think probably one of the reasons it's difficult is that both the state and the defense have made very compelling and good arguments. Perhaps it's more the state of the evidence presented that I'm working with that I've had to spend a lot of time thinking about. I want to begin this decision by saying what is not a part of the court's consideration. I am not judging the credibility of any of the witnesses who have testified, nor giving weight to any of the witnesses, nor in any way whatsoever injecting my personal opinion, if any, as to what I would think the state of the evidence is. I am certainly not considering this case on the standard of beyond a reasonable doubt. As we all know, the standard is to look at the evidence in the light most favorable to the state without any of those other considerations. And the court has done so, and my job, if you will, is to determine whether or not there's evidence in which jurors could come to even different conclusions, but one which would be a decision in favor of the state. Now, I have already indicated, and I reaffirm at this point in time, that the state has amply satisfied its burden in regard to the motion, in regard to the establishment of this being a homicide and a staged suicide. With that determination, following that, a vast majority, if not the great majority of the elements of murder, both purposeful murder and felony murder, as well as felonious assault, are satisfied by that finding by itself. The issue that's primarily before the court is the question of the identification of the perpetrator. who has committed this homicide and staged suicide from the evidence. What probably has made this case most difficult is that there is no direct evidence establishing the defendant as the perpetrator in this case. Now, the state is not legally required to do that, but it does enhance the decision process at this time to be more circumspect. Clearly, as the state has acknowledged as well, that circumstantial evidence is the cornerstone of this case. And the inference reasonably raised from the evidence that in a natural and logical way would follow and according to the common experience of mankind as to what those inferences are drawn from direct evidence is what the court must look at. And I think consistent with the requirement that the court look at the evidence in the light most favorable to the state, the court must also look at the inferences in the light most favorable to the state. So, the court has considered the circumstantial evidence provided. The state has, I believe, and perhaps a bit ironically, established the question of motive. The defendant is married to the deceased. The evidence is presented that they've had chats and messages to each other that have been classified as difficult, argumentative, including one not to each other, but one on May 7th where the defendant declared that his marriage was over. Evidence that 2 weeks prior to the argument, there was testimony that there was a very loud argument in their garage. Statements made that are inconsistent with some of the facts determined by law enforcement, and misstatements or even lies made to police. And of course, evidence in regard to the argument that Mr. Moore made statements in the past tense, which inferentially is that the speaker would have known that even though the deceased was not discovered, she was not going to be discovered alive. This kind of is the evidence that demonstrates that the defendant could very well have been unhappy and angry with his wife, and the behavior after he reported her missing could circumstantially infer that he knew something that he was not telling the police. The state also presented evidence, largely through the digital forensic evaluation of the defendant's cell phone, which, as we all know, reflects the usage activity and non-user activity of the phones, that reflected for approximately 3.5 hours on the evening of May 24th and the morning of May 25th, that there was no activity for which time period any acts of the defendant were unaccounted for. Now again, several inferences may be drawn from that, certainly, but the inference most favorable to the state is that he could very well have been engaged in the conduct that resulted in the demise of his wife. The argument presented by the state, based upon the evidence presented in its totality, is that, again, under the rule, the court has made the finding that this was a homicide and staged suicide from the evidence in the view most favored to the state. And the question raised from that evidence, by working from that, is who would be a perpetrator, who would take the time and necessity not only of ending the life of an individual, but taking the effort to stage it so it would appear to be a suicide. Now, we obviously know, and the evidence reflects, that within 48 hours, the police provided the Miranda rights to the defendant. So he certainly began this case as a person of interest upon whom suspicion would fall, and that's virtually the case every time when a spouse is missing or is found to be a victim of a homicide. Certainly, circumstantially, based upon that evidence, based upon the conclusion that the court's finding that this is a homicide and stage suicide, is also rather consistent with the thought that the evidence provided the fact that suicide over a significant period of time has affected the difficulty in the lives of both the defendant and his wife, which likewise has a bearing upon why that could very well have been staged by her husband. Again, at this time, considering all of this evidence and in light of what the court has preliminarily addressed regarding the nature of the court's decision, I find at this time that taken in total, the state has met its threshold burden to allow this matter to be considered by the jury, and thus the Rule 29 motion presented timely at the close of the state's case will not be granted. The court will simply state for the record at this time, and particularly since we are coming to the close of the state's case due to our unique agreed circumstances, that the court on its own motion is going to take under advisement a Rule 29 motion at the conclusion of all of the state's presentation of evidence, and will proceed accordingly. Now, with this decision, we are now at the point where I guess we should take this opportunity, if you wish, to go over jury instructions. Are there any, is the state ready or willing to discuss jury instructions at this point?
Yes, Your Honor, I am. Thank you.
All right, what would you, what changes, deletions, additions, or corrections would you seek?
Thank you. Hold on a second. Sorry about it.
Well, I figured the toddler there would have had to at least apologize to the judge for his actions. I figured she would have at least made him apologize. I don't want to do jury instructions. All right, here we go. Yeah, I can't imagine storming out of a courtroom, period. Let alone tell the judge that it's a sham, go marching out, crying like a baby, and then come just walking back in like nothing happened. Well, maybe you just went in and unalived somebody, Mr. Anger. Should we look at you now? Should you take a seat over there on the defense side? Because you would use actions like that against somebody else. Come on, Jerry, let's go.
Thank you. I'll have a seat. As always, everyone, good morning. Have a good night and follow the court's admonition. All right. Thank you very much. We are in the defense case, and you may call your next witness.
Last witness.
The defense, we call Dr. John Bolte.
I do.
Good morning.
Morning.
Introduce yourself to the jury, if you could.
My name is John Bolte, and I'm a professor at Ohio State University.
And before I ask you just a few questions about that, Your Honor, at this time the parties agree that Dr. Bolte is an expert in biomechanical engineering.
That's true, no objection. Thank you.
Thank you. So noted for the record. Please.
Thank you. Dr. Bolte, you just indicated that you're a professor. Tell us about what you do at Ohio State.
I am a full professor in the School of Health and Rehab Sciences, which is within the College of Medicine at Ohio State University. I'm also the director of research for the school, and I serve as the founder and director of the Injury Biomechanics
Let me know if
Research
that's
Center
too fast.
at
I'll turn it back down.
Do you have a CV?
I do.
Showing the witness what has been marked as Defendant's Exhibit SS.
I'm sorry, what was it again?
Sam.
Thank you.
Because it seems like it, when I speed it
Dr.
up,
Bolte,
it
does this look familiar?
goes
When you
super
go to the last
fast and then
page, it
it'll
appears to
slow
be
right
4 to
back.
6
It'll
pages
kind of
long.
slow down a little bit.
That is familiar, yes.
When did you provide this to me at some point since we met?
Yes, when you came to my office to meet the first time, I provided this copy to you.
And if you recall, when was that meeting?
I do not recall, I would say two to 3 weeks ago.
Does this appear to be a fair and accurate copy of your current CV marked as Defendant's Exhibit SS?
It is.
Tell us a little bit about how you became involved in this case with respect to Emily Noble.
I first became involved on October 26, 2020. I received an email from Detective Grubbs requesting if I knew anyone that could help test a tree to see how much mass the tree could suspend. And it was just an open email, and I responded with, I don't have a lot of expertise with the tree, but I might be able to support this.
When you say mass, what does mass mean in that context?
Weight.
And as a result of that initial outreach from Detective Grubbs, what, if anything, happened next?
We exchanged a few emails. I believe there was an email from a tree expert that had a suggestion of how to test the tree. We decided to meet on November 6th at 9 a.m. at the location so I could view the tree and brainstorm what engineering tests we could do to potentially test this tree branch. So the first meeting was there at the scene on November 6th of 2020.
If you recall, who was there at the scene on November 6th?
Detective Grubbs in Alloway, myself, Dr. Yunsiak Kang, who is another professor in the IBRC, along with myself, and Dr. Amanda Agnew, who is also within the IBRC.
Was there another time that you went out to that same location?
We actually went back out on November 11th to run the tests that are in my report.
Which takes me to, did you write a report in this case?
Yes, I did.
Showing you what's been marked as
So
Defendant's
pretty much
Exhibit
all of the state's
VV,
witnesses,
as in Victor, and Dr.
were there,
Bolte, there is
except-
a copy of that same report in front of you.
they must not like what
you.
his test
You
said.
could flip through it, 6-page report, and let the jurors know if that appears to be a fair and accurate copy of the report that you issued in this case.
It is an accurate copy.
Let's go through it if we could. The date of the issuance of the report,
It was January 31st, 2021.
when the report was finished, to whom did you send it?
I sent it to Dr. Grubbs, or Detective Grubbs, excuse me.
Now, let's go through, you mentioned that you went back to the scene again on November 11th of 2020. Let's talk about what you did when you went back. But before we talk about what you did, tell the jurors what you brought with you to do the testing.
So after we visited on the 6th and looked at the landscape to see what we might be able to bring to run the test, we came back on the 11th with several pieces of equipment to allow us to do a couple different tests. One was a camera, a regular camera that could take still photos and video, and a tripod to set that camera up on. We also brought a data acquisition system, which is used to, when you're running a scientific test, collect data, whether that's from an accelerometer or any type of instrument that could record motion or something along those lines. So it just is like a computer. We had a laptop to connect to the data acquisition system to collect the data. We had a inline load cell that I have with me here this morning to suspend from the branch so we can record how much weight was hanging from the branch. We had an empty milk carton basket to hold weights. We had a series of different weights of different amounts so that we could add to it slowly to see what would happen to the branch. And then finally, we had a 5th percentile female anthropomorphic test dummy, which is known as a crash test dummy, which is used to crash test frontal, when they do a frontal crash test in the United States, NHTSA, they use this dummy, and they also use it actually in a couple other tests. It is a size of a small female. It weighs approximately 105 pounds.
Were you given at any point prior to the scene on November 11th a weight with respect to the tree branch, a weight that the Western Gulf Police Office wanted you to test against, if that question makes sense?
I was not given a specific weight. I was just told a small female. And we happen to have the dummy that we could use that is supposed to represent a small female.
And the dummy, the crash test dummy that you used again weighs approximately how much?
It's between 105 to 110 pounds, depending on what instrumentation is inside of it. We did not use any instrumentation in the dummy. We just used the dummy as a weight.
Did you bring a USB cord with you?
I did. I brought 2 USB cables. I had asked Detective Grubbs if he knew a serial number, something that we could try to match the USB cable. And I went out and purchased 2 10-foot long gray USB cables that I thought were similar to the best of my ability.
Going now to what you did at the scene. You indicated that you had a camera and video. Did you run tests at the scene?
We did. We ran 2 different sets of tests.
And before I actually go into the test, from your perspective as an expert, biomechanical engineer, and you walked down there in early November and you first saw the branch, what was your thought?
As a biomechanical expert, I do not know anything about trees. So I don't know the strength of trees. So it's really, I can't really comment further than that. I know the body, I don't really know trees.
Show the jurors sort of how big the branch was in terms of circumference.
I would approximate it to have been maybe 1 to 2 inches in circumference, and it was about an inch over my head, so we measured, and I'm a 6'6", so it was about 6 foot 7 inches off the ground when we tested it on the 11th.
Let's talk through the first test that you did at the scene. Static mass test. What is that?
So we thought the first test would just be something to add weight step by step to see how much weight the branch could hold. I had no idea, as I mentioned, I'm not a tree expert. I know how to run scientific tests to look at boundary conditions or to test something that's similar to maybe what occurred there. And so we thought, let's just start with an empty crate hanging from a USB cable through this device and add weight in steps to see if we could get close to 100 pounds without the brake branching in a very static, meaning no motion, just put the weight, wait a few seconds, add the next weight.
How did you know how to tie or fasten the USB cord to the branch?
I didn't fasten the cord to the branch. I fastened the cable, one end of the cable. So this load cell records weight by pulling on it. It's a tension. So if you pull it, it can measure how much I'm pulling on it right now. So we looped the USB cable through one end of it, and it had 2 wires coming up over top of the branch, and then came down to the basket. On the first stack test, it came back to this, and then we had a separate USB cable going to the basket. We used 2 cables, I believe, on the first test. So it wasn't tied directly to the tree. They were more tied to the load cell. There were 2 marks in the tree branch that we were able to see that we made sure the 2 cables from the USB were sitting in those same 2 marks that were already in the branch. So that's how it was set to the tree. They were in the grooves that were in the branch.
And in the last full paragraph of your report, you talk about the discrete intervals of adding the weights. Tell the jurors what those numbers mean at the end there with respect to the static test.
Honestly, before we went to the scene, we walked around our lab to find weights that we could throw into the basket. And so we have, over the years of doing different tests, we have different weights of different masses, and we found ones that were 33, 15. And I apologize, as I look at this, I know there was a 2-pound weight as well. So we got up to around 96 pounds of total static weights. We put 5 different segments of weight in before the basket slipped to the ground.
Each time you added a weight to the basket, was that captured on film?
It was. We had the camera, I forget if it was our Sony camera, it's probably stated in here, running the entire time in regular motion, regular speed, recording the weights. The camera just ran constantly, and we just kept adding weights to it.
I want to walk through each video.
Unlike
each
when
time
they
the weights
cut
were
her
added,
down,
and, we can talk about them, then I'll
taking
ask you if they're
pictures
fair and
of
accurate copies.
video of that.
We'll play the first one that we've marked as.
Not
We'll
trying to
do
be gross.
exhibit
They just
UU,
didn't
and we'll
document it.
mark all 5 as that, Your Honor. And Dr. Bolte, the screen in front of you works as well, too.
Okay, thank you.
So before we play it, tell us what we're seeing here.
So what you're seeing here, and it's a little hard to see because of the branches in the background to see the gray cables, but it's an empty milk crate that is hanging from one USB cable that's tied to all 4 corners. There are no weights in the basket this time. Going up to the load cell that's in the middle there, and then again the USB cable going up and over the tree. And as I look at this video, I apologize, there was a knot around the tree at this time. It was a knot that was below the tree with the 2 wires on top, but as we placed the weights, you'll see the knot slipped up against the tree, thus my forgetting at the beginning that initially the knot was not on the tree.
You can mark your screen too, but tell us you have something in front of you, and I circled something there on the scene. if you can see it, what is that?
This, what you just circled is this load cell that's hanging in there. There was a turnbuckle hook on each end in addition to what I have here today. I did not bring those, so there was hooks that we could run the wires to, but this is what's in the middle of the red there, this interface tension load cell.
And what, there appears to be something in your hands there.
That is the first weight that we placed in the basket. This is a 33-pound piece of material that we had in the lab from past testing.
Let's go ahead.
I don't know why they're not showing us. It's not like it's a body. It's a milk crate, for crying out loud.
Came in for the second weight. That first weight was 33 pounds.
Correct.
Let's go to the next video, please. Was there a certain amount of time that you waited between adding weights?
It was a judgment weight. We just paused for a second to see if the branch was going to be stable. As you saw when I had the first weight, I didn't know how the weight would fall in the basket and what would happen. But then the knot that was just kind of between the branch and the load cell, as I mentioned, it slid up and tightened, and that's why the basket dropped so much, and that caught us off guard. So then we kind of waited each time to see if there'd be a little more slippage as that knot continued to tighten and tighten. So it was more just a judgment call to say, okay, the system is balanced, the basket's not going to fall, the tree branches are going to break, let's add the next weight.
Let's go to the next one. As part of the static test, are you also measuring the deflection of the branch?
Yes, so we didn't measure the deflection in between each weight. We had the original height, and then once we were done with all the weight that we added to the basket, we were able to pause the film, and we calculated about, I think it's almost 3 inches, 2.96 inches that the branch deflected down from the static test.
And is that 2.96 inches, page 4 of 6 in your report? Or no? Sorry.
It is 2.98 inches, excuse me. It's written on page 3, and the data, the plot that shows it is on page 4, figure 3.
And I will toggle back to that as soon as we're done with the videos. Let's look at the next video. So we're still at the static test here where you're getting near 100 pounds?
The last weight that I just added there was roughly around 14 to 15 pounds, and then
There's one more video. We'll play that now.
the last weight is identical, it's again around 14 to 15 pounds.
And then in that last image, we seem to see actually the USB slips and the basket falls. And what, if any, effect does even that have on that branch?
It wouldn't have any effect on the branch. It was just a matter of we were afraid if the milk crate was going to break. We thought we were already close to 100 pounds. Right before I put the last weight in, which would have taken, I think, to 110, we were at 96. And I felt that was enough to say that, okay, we can hang the crash test dummy on the branch, and the dummy won't break when we initially hang the dummy. So the static test was, one, to see if we could get close to 100 pounds without it breaking, and then also making sure that when we try to hang the heavy crash test dummy, that it also would support the dummy weight.
So I want to go back to page 3 of 6 of your report, where we talked about the deflection of the branch in the static mass test. You indicated 2.9 inches when 96 pounds was statically suspended. Just explain to us one more time what that visually looks like.
So again, the branch was initially 6 foot 7 inches off the ground. Once the 96 pounds was added, the branch at the location of the USB cable had deflected towards the ground about 3 inches.
And that finding, is that what's calculated on test 1, static max basket in your report?
Correct. So this is the data that the data acquisition system sends to the computer that this measured the weight. And so on the bottom, you can see it says time in seconds. And so that you can see how often I added a weight. It starts at 0, and on the left is mass in pounds. And so, we started recording. There was nothing in the basket. I should state that obviously, when the wire and the basket are hanging on this picks up a pound and a half, and we're able to zero that off and say, okay, we're going to call this 0 now. And so then when we start the test, it's at 0, and you can see then at approximately 4 or 5 seconds in, I added the first weight, and you can see it hung there at 33 pounds, and then you see the large jump in the data line at about 13 seconds?
You
Can
mark
I
the screen.
circle?
Yeah,
Oh,
of course.
oh. So that, sorry, that's at which time that slip occurred, and you saw the basket drop. That's what that is. That's that jolt from the basket. And then after that, you can see it's stayed at 33, and then about 20 seconds, I added the next 33-pound, and then the smaller 1 to 2 pounds, and then the two that were about 15 pounds. So the entire test lasted 1 minute and 10 seconds.
And the time interval, is what's indicated by that bottom line right there?
Yes, that's the time that each weight was placed.
You mentioned earlier about the knot that slipped. I'm just moving up page 4 of 6. Can you describe what picture B is depicting? And we'll start there.
So, can I start with picture A?
You sure can. Let me zoom in so the jurors can see it. How's
So,
that?
thank you. In picture A, you can see what we attempted to do at first. So you can see in the bottom of the picture this load cell, and you can see the little turnbuckle that was added with the hook. We ran the one USB cable up, and as I stated, there were 2 indentations on the branch, and so I ran the USB cable through those 2 indentations, and then tried to put a knot below that, and just had the rest of the wire off. So that picture was taken when the basket was hanging there empty, and then as we added weights, my knot slid up against the tree, and that's when it became against the tree. So I obviously did not tie a correct knot to begin with.
And when you talk about the knot, will you circle the knot for the jurors, or how you originally tied it and then how it slipped afterwards?
I think it's just a quick through and pulled once, a very simplistic knot. And so obviously when the mask got added, all the USB cable was able to slide through it and pull that knot up to the branch.
Let's now turn to, after the static mass test, did you do a second test on the branch?
We did, and we called that the dynamic test. It was also trying to be maybe perhaps a realistic scientific test. And we started by just hanging that small female crash test dummy to make sure the branch suspended the dummy. And then we tried to lift the dummy about 6 inches and give it a little bit of a dynamic event so that there was some energy from gravity pulling on the dummy back down.
Did the crash test dummy have its legs on it, anatomically speaking?
When we first got to the scene, yes, it had its legs. When we realized with the height of the branch and with the load cell and trying to get everything to fit, we had to take the legs close to the knees off. A female, well, any crash test dummy, a frontal crash test dummy, has a fixed pelvis because they're seated in a vehicle usually, and so that pelvis is at about 90 degrees. And then the legs come out, and then you have knees that come down, and obviously ankle and feet. Unfortunately, dummies are built to survive crash tests of vehicles, and so they don't move like we do. They're very stiff. They're hard to maneuver. And so once we had the dummy in place, we realized the legs, as they came off the knees and down, would be resting on the ground. So we took mid-shaft femur just above the knees off. I think the report says knees. It's very close. And then once we hung the dummy without the knees, we then put the knees in the lap of the dummy and just held them there with, I believe it was tape, just to make sure we had all the mass of the dummy there. It looks funny though because the legs were not attached. No, they were just sitting in the lap. And
this test, like the static mass, was this captured on camera?
It was. We ran video for all the events. In this event, it's critical because there's motion and that tree limb's really going to bow down, perhaps break. We didn't know when we ran the test. We wanted to have the camera rolling so that we can go back and analyze the film and try to see exactly at what point, if it failed, what point it failed, or how much it deflected.
And before we play the video, tell the jurors what we see here.
So we actually ran a video while I was attempting to suspend the dummy in a manner that we felt was similar to how the remains were discovered.
And for the dynamic test, was the USB cord placed in the same or similar spot or different?
For this case, or this test, excuse me, we used one USB cable and we tried to simulate what I knew of how things were found. And so I'm staring and kind of pulling down on the limb slightly there to ensure that the 2 cables are running through those same indentations when we set up this test.
And any information that you had at that point in November as to the remains or even the branch, where did that information come from?
Detective Grubbs brought with him one picture that showed the USB cable kind of coming off the back and how one end was hanging down. I asked because I really wanted to try to mimic exactly how the remains were discovered to make sure the test was realistic as possible.
Playing what's the
He brought one full
6th
picture
video
for him to
Defendant's
look at.
Exhibit. You, Your Honor? you're doing right there with the USB cord.
So in this case, we used one, what we purchased, gray 10-foot USB cable. Once we got out of the package and measured it on the scene, we discovered that a 10-foot USB cable is actually, I think, 126, almost 127 inches. It's actually longer than 10 feet. And so what we did is there was this hook, remember, on this load cell. So we just doubled folded the USB cable in half, hooked it around the hook. So you had two wires coming off, ran them through the indentations on the tree. And then there was a hook on the bottom. As we came down, I used the one end of the USB just to latch in that hook, just the normal end, and it hooked. And so there was this loop then, two coming off the top around the tree, one cable coming back to the hook. And so the loop was there, and my son, who assisted on this test, helped me place the ATD then with that loop under the chin, and the second end actually then freely hung down. So the entire setup was only hooked with one end of the USB cable. So at this point, I'm trying to make sure the one end is hooked and that the dummy would actually hang before we unhook the other end to mimic the one picture.
Let's watch the rest.
Yeah, I hope they
We can
put
pause
that.
it right there. What you were
USB.
just doing at the branch there, why were you doing that?
I was trying to ensure that the USB wires were sitting in the indentation.
Like the picture that we saw where it's just in that loop. It's just sitting there to see if that's actually possible.
At this point in time, there's two videos. At this point in time, without the legs, do you know how much the cross?
I do not know the exact number, no.
Okay. And then at some point, did you add the legs to the dummy?
Yeah, if you can go
Yes.
back to the beginning, you can see that the legs, oops.
Right there?
So no, the legs are still not on at this point.
Right.
The next video, just bring it up if you would, please. Try to pause. So you can see, and I'll circle it, that is the shoe and the foot of one of the legs. So if you remember the last video, it kind of stopped with the dummy with just the knees. Here, we've now placed the legs across the thighs of that dummy, and they're in the dummy's lap.
And so initially in the last video, the dummy was statically hanging. The dynamic test, before we watch this next video, tell us what you do to create the dynamic, if you will.
Well, in this situation, what you see here is the dummy, again, is around 105 to 108 pounds, and it is sitting, you might have noticed at the end of the last video, probably 6 to 10 inches off the ground. And so my son and I, and my son worked in the IBRC at this time, we tried to just lift the dummy approximately 6 inches to get the dummy in the air. And so this video starts right when we basically have lifted the dummy up and are pulling our hands out to see what would occur.
We'll start from the beginning.
Was he ducking and covering?
Is this in regular speed or slow motion?
That's slowed down.
When you dropped the crash test dummy, that was the weight that you indicated, I noticed that you ducked down. What happened as you dropped the dummy?
The dummy just ended up falling. The branch did not fail. The dummy swung down, swung up, so you'll see a little bit of motion as it oscillates until it gets back to zero. Unfortunately, I did not know. I did not want a 105-pound dummy falling on my head, so I ducked.
And it's showing you what's been marked as page 5 of 6. The results with respect to the dynamic test, are those included in your report?
They are. They're bold. Kind of this sentence right here is what I thought the most important findings were, given that the branch did not fail. We ran the test twice. In science, we like to run multiple tests just to make sure that we know the correct answer or something close to that. And so we ran it twice. One time we had 6 inches of deflection. One time we had 7 inches total that it deflected before it settled back down. And the difference in those deflections is due to not knowing exactly if my son and I lifted the dummy exactly the same height each time. You know, if we had a mechanism that we could have raised it 6 inches, pulled it out, and dropped it, then you probably would see very similar findings. But you see an inch difference just because of the attempt of trying to lift the dummy and kind of throw it in the air.
And with respect to the findings regarding the deflection of the branch, what is depicted in those two graphs that I just bracketed?
So these are similar to the last figure that we showed. Again, on the bottom is time. And as in what we call the static test, I mentioned it took 1 minute and 10 seconds. You'll see that the time across the bottom is a total of 3 seconds. So this is a much quicker event, even though the video is slowed down. You'll also notice that on the mass, or the weight on this side, you know, I mentioned the dummy weighs around 105 to 110 pounds, and this only reads 90. That's due to the way we had to conduct the test. My son and I had to already kind of have some of that mass in our arms when they hit go on the data recorder, so we don't really know what the zero was. And so you don't get the whole 105 pounds because we were holding some of that mass. And so that's why when it comes out, you see the dummy weighs around 50 pounds. That means my son and I were originally holding about 60 pounds in our arms when we were suspending him, if you will.
As you conducted the dynamic test, though, there's a point when you're not holding any of the weight.
Correct. And so at time 0 is back when we kind of threw the dummy up, you will, and the dummy starts to come down the branch. So the first oscillation, or the first peak, is kind of that initial when the dummy comes all the way down. And then you'll see the oscillations as the dummy and the branch kind of settled out. And so from this point 00 on, we are no longer holding the dummy. It is suspended.
In total, how many tests did you conduct on that same branch that day in November?
So we conducted the static test, which took 1 minute and 10 seconds. We did the first video you showed. I apologize, I forget what exhibit it was called, but the second to last video where I was just putting the USB cable around. We hung the dummy, and then we added the legs. You could call that a test, but we didn't record any data. We were just getting the dummy in position. And then we actually, I think, total ran 3 tests where we did the lift and drop. The one test, the data recorder failed, and we didn't get any data. That's why it's not in the report. So in total, two static tests where the dummy was hanging, and then 3 tests that we added some energy to the dummy.
And of those 5 tests, how did the branch, was the branch able to sustain those 5 tests?
The branch did not fail, so I would say it sustained the 5 tests.
In addition to the graphs that we've talked about in your report, did you also include some photographs of the testing in your report as well?
There are photographs depicting the slipping knot and depicting how page 3, figure 2.
Showing you page 3 of 6?
Yes.
Tell the jurors what we see here in these 3 pictures.
So this is trying to show how we match the one photo that Detective Grubbs brought to the scene. And here in the middle, and I apologize, I'm not very good at this, but there you can see the end of the USB cable just sitting in the hook. And the tension of the dummy hanging off of there was able to keep that USB cable in the hook. And as I mentioned, you can see it up here a little bit. You can see the 2 cables coming up off the load cell going around the tree. The one comes and gets hooked in the hook, and you can see then the other one that was hanging down over the shoulder, which was similar to the picture that I was shown.
A couple questions about these. How is the USB cord around the head of the crash test dummy?
This is a point that's I'm not sure if you've ever seen a crash test dummy before today, but they don't look exactly like us. The neck is metal and rubber, and there's no skin around the neck. So you see the simple, you can kind of see right here the metal going up into the head, and then there's rubber metal. So there's no skin. So when you come down on the mandible, you do not have the skin that kind of attaches your mandible down to your neck. And so it actually gave us an advantage because we could slide the cable up along that metal rubber neck, and it actually hooked. A real person, it would have been much more difficult because of the skin, but on the crash test dummy, it was able to hang based on how it's built.
And you testified about images that you had seen with one of the cords hanging down. Is that also depicted in image 1 and 3?
It is to the best of our ability and my memory of that picture.
In image 3, it seems to be a little more clear than the video, but tell us, do you see the foot or the legs of the dummy in that image?
Yes, so here is the knee of where it was taken off of the one side, and the foot for that one would be over to the dummy's right, and then this is obviously the shoe or the foot on the other leg, and the knee for that one would be over, almost as if the dummy was sitting cross-legged, but with the knees disconnected.
How long would you say you were overall at that scene in November of 2020? I believe it was the 11th.
I would say, I don't recall exactly, but I would say approximately an hour.
And I think I asked you who was with you on November 8th when you first went to the scene. I didn't ask you, though, who was with you other than your son on November 11th.
So November 6th was the first time to clarify. On November 11th, it was Detective Grubbs and Alloway again, and then myself, Dr. Yoon Siak Kang, who was there on the 6th, and then the third person was my son.
Your findings and conclusions with respect to those tests that you administered on November 11th, 2020, are those all in the report marked Defendant's Exhibit UU?
They are.
Fair and accurate copy of your report?
It is.
And the findings in your report, those are made to a reasonable degree of scientific certainty?
They are.
Just a few more questions about the report itself. After November 11th, who did you send the report to?
I sent the report in January 2021, January 31st, to Detective Grubbs.
And at any point after the report was sent, when was the next time that an individual from this case made contact with you, either by phone or email or any kind of communication?
Objection if it's to a statement. If it's to just a time or a yes or no, no objection, but I just want to make sure it's not being a hearsay statement. Thank you.
Just the time. When did you next hear from someone affiliated, associated with this case?
I do not recall the exact date as I stated earlier, but it was an email that I received from you.
And at some point, did you and I meet at your office?
We did.
And was that just a general time frame? I won't ask the exact date, but if you could tell the jurors.
The week following your email, we met in my office for an hour and we went through my report.
The videos that we watched today, the first 5 and the last one, how did you send those videos to me? Did you give them to me?
When you visited my office for that meeting, I gave you the photos and the videos in my report, my CV on USB stick.
Your time today, with respect to your hourly rate, what is your hourly rate?
My hourly rate is $300 an hour.
Prior to me contacting you, as you testified to, has you done any work for the defense at all in this case?
I have not.
And when you conducted the tests and wrote this report, was this before or after you and I even meeting?
This was before we met.
Nothing further, thank you.
That means the state didn't like what it said, I bet you. And I was wondering who was going to be cross-examining him. It's like little skinny dude.
Sir, I spoke with you just before your testimony, but my name is Corey Go. I'm representing the state and just have a few questions. Do you know Dr. Agnew?
I do know Dr. Agnew.
Okay. I told her I'd be nice to you today, so bear with me. I'll do my best.
I'm sure it's going
You
to
ever
be
done a test like
struggle.
this before?
No, we have not done a test like this.
Okay, so the videos, the report, this was kind of a first time trying this type of test. Is that fair?
That is a fair statement, yes.
Okay. First time you've worked with a tree like this, I think you testified to?
That is correct.
You're not a crime scene recreationist or anything of that nature, correct?
I'm not. I'm a biomechanical engineer.
Okay. And your goal in performing this test was to determine whether the tree branch could hold somewhere around 100 pounds, correct?
Correct.
And that was the only goal of this test?
That was the only goal, was to see if the branch could suspend the mass without breaking or failing.
Okay. And we saw that in the videos and some of the pictures that we've walked through so far?
Correct.
Okay. Can you
Thanks,
stand
Bree,
for me,
because
sir?
now I can't unsee it.
You said how tall are you?
I'm about 6'6", if I stand the way Mom said I should.
Okay. How tall did you say the branch was when you went out there and did your initial testing?
We measured it to be 6'7".
Okay, you can have a seat. Thank you very much. A little taller than me, but that's fine. Got an extra couple inches on the ramp there, but just for the record.
Nobody
Again,
cares.
let's talk about, you did two different tests. You did a static mass test, 1, and then a dynamic ATD test, 2, correct?
Correct.
All right. Let's first talk about the static mass test, the first test you did, all right? And actually, before I get there, you talked about the 2 cords you used. You used 2 10-foot cords, correct?
On the static test, we used 2 10-foot cords, correct.
Okay, and those were just USB cords?
USB standard cords, yes.
Okay, so USB on both ends.
Sorry, no. USB on one end, USB printer cable to be exact. So it was a printer end on one end, USB on the other.
And other than the 2 ends of the cord, do you recall anything else being in between those 2 ends other than just the USB cord?
Just the cable itself.
Okay. So if there are pictures of the actual cord used in this case that suggest it was a different type of cord, you wouldn't have any knowledge of that, correct?
I based what I purchased off the numbers Detective Grubbs gave me and the one picture that I was shown. So I tried to match color and as best I could.
Sure.
He
Now,
based it
when
on all
comes
the
to
info you guys
static
gave him.
mass test, again, you
Dumbass.
did that test involving 2 different or 2 separate 10-foot cords, correct?
Correct.
Did you ever perform that test with one 20-foot cord?
No.
So you're not able to render an opinion if there would be any differences to your test based on one 20-foot longer cord versus two separate 10-foot cords, correct?
Correct.
Now, I'm going to show you
I like how you did it wrong based on the info we
previously
gave you.
labeled Defense Exhibit VV. I'm going to zoom out first, but I'll zoom in for a couple portions here. Was this picture taken before you started adding weight to the basket?
Correct.
And there's a red circle in the middle of this picture. I'll zoom in a little bit. Can you identify what we're looking at there?
That is this interface load cell that's shown here.
And can you hold that up for the jury, please? You mentioned that there are hooks that go into the top and bottom, I believe.
So this load cell obviously has, I should know the mechanical term, but screws in a slot that you can hook other devices in. And so in the picture, you can see two turnbuckles with, it's better below the red. Right here, you can see the turnbuckle coming down and then just has a hook, a basic hook.
And that's made mostly out of metal?
It's all metal, yes.
Okay. So I'm looking at this picture for your first test. Is it fair to say this top portion here is a 10-foot cord?
It is, but you can see the tails coming off to the left side of the picture as I look at it. This cable coming in here is this cable that goes to the load cell, but here you can see some of the extra USB cable that we did not use going off to the side.
And then the bottom portion here would be the other 10-foot cord that you described?
Correct, and we use all of that because it goes down to the middle, another attempt at a knot, and then to the four corners of the basket, trying to figure out, or at least the handles towards the corners to figure out how to suspend that mass.
And in this initial test, you described a knot. Where does the knot begin before you start loading weight?
The knot is actually, if you can see it, is right there where those other cables are coming out. So I would estimate it's about 2 inches below the bottom of the branch there.
And that was a knot that was put there so that the cord would...
It would stay and not slip all the way off, correct?
Okay, so again, you have no knowledge whether there was a knot in a similar or same place in our facts and circumstances, correct? Being the case?
Correct.
Okay. Now,
Because
we
you
watched a
only
little bit of the video,
provided him
and
one picture.
at some point, it's fair to say that knot slips up to the tree branch, right?
Correct.
It almost takes you out along with it. How much weight was in the basket, or how much weight did you put in the basket before that knot slipped?
It slipped at the very first weight, the 33 pounds.
Okay, so 33 pounds of weight caused the knot up top there to slip at least what looks like at least 6 inches up to the top of the tree?
It slipped up. I don't know the length, but yes, it slipped up, adding weight.
Okay. And again, looking at the dynamic test, there appears to be another knot right there at the top of the basket.
Correct.
And how is the basket being held by that apparatus, we'll call it?
So as you can see on the front of the basket here, you can see a handle. There's also a handles, the same cutouts on the.
Just a quick question, but is it kind of striking anybody else strange that the state is debunking, it's trying to debunk the test that they themselves had run, asked this guy to do, and that they themselves provided him information or really nothing. One picture. I forget what I don't even remember what the other thing was. They didn't obviously like what he had to say, so now they're trying to tear it apart. But I'm like, you're complaining that he didn't have enough information of the information you guys didn't give him. This is weird. I don't, it's weird. I don't think I have ever seen this done before, but leave it to this case. Trial,
Sides.
whatever.
We just tried to route them through there and up, and to make it more difficult on ourselves, the wire actually runs through, and the wire is actually running across in the middle in here as well. Again, my degree is not in hanging a milk carton, and so it was just trying to figure out a way to suspend this and then add mass to it.
And during this test, again, we're just testing to see if the branch would hold the weight.
Correct.
So it's free hanging as opposed to being on the ground at some point.
Correct.
Except for the part where the tree branch goes down a little bit and then the whole thing kind of collapses.
Yeah, and it's
tree branch
because
is still
the
there.
cables slipped, the knots continue to slip, and so it ends up on the ground before we add the last weight. Correct.
Okay, so the knot continued to slip as you added just about 100 pounds of weight?
Correct.
Okay. Now, let's move then to the dynamic ATD test, is that correct?
Correct.
And what's ATD stand for?
Anthropomorphic test device.
Okay. I'm not going to ask you what that means, but we'll call it the dynamic test, all right?
Or crash test dummy.
Okay. Now, again, let me ask you this, did you use the same two 10-foot cords, or did you use something different when trying to test it dynamically?
In this case, we used one of those same 10-foot cables.
Okay, so again, not one 20-foot cable, but not one 10-foot
It's
cable?
one 10-foot cable, correct.
Hang on.
So if there's evidence in this case that there's a 20-foot cable, that would be different than the test you performed.
Where is the evidence in this case that that was a 20-foot USB cable? When the defense asked how long that cable was that the BCI guy took off of Emily, he did not measure it. Where'd that come in? Who said it? Other than right now, this prosecutor bringing it in now, nobody's measured anything in this. Anytime anybody's been asked if they measured something, they didn't. So where's that coming in at? We have not heard that except for now. Convenient state. Good job. Because you don't look shady when you do crap like that. Everybody trusts you.
I only know what I did with the 10-foot cable.
That's fair, thank you. How about, I guess in a similar way to the static test, were there any knots in the cable as you were trying to try to do your dynamic test?
There were not any knots in the cable when we did the dynamic test. I wish I had more of this for you maybe I can show. Basically, this had a hook on the top, and we just doubled the USB cable over and then hooked this. I apologize, it's so tiny, but hooked that through the hook and then ran the two wires up and around, and then the one end hooked back.
That's what she said joke there somewhere.
Right here. So there were no knots in the test with the crash test dummy.
I won't
Okay,
do it.
and I like where you just circled there, that's a metal hook.
That is a metal hook holding the plastic aspect of the end of the USB cable.
Okay, you'd agree with me that's not a plastic cylinder or tiny plastic cylinder?
On which part?
This part here, the hook part.
No, that's a metal hook.
Okay, and you would agree with me that this is a USB sort of end?
Yeah, I cannot tell from the picture. I don't remember if that's the printer end or the regular USB end, but that is one of the ends.
Okay. And again, even when doing this dynamic test, you're not trying to recreate the scene after looking at that one picture, correct?
We were trying to suspend the dummy in a similar fashion to the one picture that I was given.
And you'd agree with me that based on the one picture you saw, the person wasn't being suspended, correct?
The view of the picture, I could not tell that.
Okay. So again, you're just trying to determine whether even this dynamic test, the tree would hold 100 pounds.
Correct.
You would agree with me that we only provided you with one thing, and now we're complaining that you only had one thing? All right.
Just one moment. You obviously you used a crash test dummy that you talked about on direct, correct?
Correct.
You didn't have anybody willing to be a human experiment in this case, right?
Correct.
I mean,
And you
could've
described
volunteered.
this crash test dummy and the neck. Can you describe that again for me?
Yeah, so the dummy has underneath that rubber type skin, and you can see here there's the back of the, I guess you would call it the skull, is a skull cap. You can pop that off to put instrumentation in the head. So beneath the rubber is a metal skull that is a certain mass to match anthropometry of occupants and vehicles. And then that attaches, a metal interface in the bottom of the skull attaches to the top of the neck. And as I mentioned, the neck is basically a layer of metal, a layer of rubber, metal, rubber that allows for a little bit of flexion and extension. If you can imagine in a forward-facing car crash, your head will come down and come back up. So this dummy's neck allows for front to back. But what happens is, as you can see, I apologize, there's going to be a lot of lines on this, but right in here, you can see that wire pulling up on the edge of the rubber that's covering the head. That's not realistic in a human, and that interaction is going to be slightly different in a human than it would be in this crash test dummy.
Including if a human was alive and tried to move while this was happening, correct? The dummy's not moving in any way unless you're actually implementing it or doing something to make it move, correct?
I will say that I corrected dummy's not going to move. I don't have knowledge of the human aspect of that.
Okay, that's fair. You would agree with me that the crash test dummy's head kind of makes a angle there that I guess you described allows that to sort of hook under?
Correct. The head and the neck angle is specific as if the typical angle of when you're sitting in your vehicle for your eyes to be forward with your seat at 20 degrees. So.
Okay. I think you testified to this, but you'd agree with me that's not realistic to a normal human being when you're trying to run like this type of test.
I've never ran this test on a human, so I probably cannot answer that.
Okay. You agree with me though, just in looking at that angle, you looking at me looking at you, that's not something that looks like a normal person, correct?
I will say the lack of skin going from the mandible down to the neck would change that interaction.
Okay. And so the connection there would be a cord up against metal as opposed to a cord up against skin.
Skin, soft tissue, correct.
Okay.
Duh.
Maybe just one moment, Your Honor.
Man, I hope the jury's seeing through this. And I hope they realize that we've not heard the
I have no
measurement
further questions. Thank you, sir.
of the USB.
No. Tell the jurors why you used a 10-foot USB cord if you could.
Come on, know it. Know
I
it.
believe, I'm trying to recall, either in an email or a conversation perhaps on November 6th that I was told by someone a 10-foot cable, but I cannot tell you who that was, because I know I specifically was searching for a 10-foot cable.
And while you don't know the name of the person, do you know, like, for whom they worked?
Objection. Witness doesn't remember who he talked to, so
Well, it's
how does he
different.
know who he works for?
He doesn't know the name of the person, but he may know, and we don't know what the answer, but he may know who the person, if he doesn't know where they were. If you can answer.
It would have been from when I was meeting with the detectives.
Just one other question about, you were asked if this was the first time that you had run this particular test. Does the fact that it's the first time that you've run this test impact your findings at all?
The fact that we've never ran this test does not impact the science and the outcome. The results are measured, they're real outcomes. No, it wouldn't change that.
Thank you, nothing further.
And sir, when you say the science of the outcome, you're talking about just that tree branch can hold roughly 100 pounds without failing?
That specific test that we ran, those results are solid for that test, which was to see if the branch could suspend the weight.
Certainly not anything specific to the facts and circumstances of this case, just the weight itself in the tree branch.
Correct.
Okay, great.
All right, jury questions. Come on, jury. Ask some good ones. And they have been. I will give them credit. Again, it's so weird that the state's like, well, we didn't provide you with everything, so we're going to complain about everything you didn't have that we didn't give you. Would you agree with me? Okay. And you obviously didn't say what we wanted you to say, so we didn't call you. Yeah, little man, you better be, like, apologizing to the judge up there for your actions earlier. Quite childish. Calling the courtroom a sham. Naughty, naughty. All right. Come on, jury.
A few questions for you, sir. The first question is, for the dynamic test with the crash dummy, to get the correct force or weight measurement, should the force or weight value be multiplied by 2 due to only measuring force only on one side of the USB?
It's a good question. That load cell measures the amount of force that's going between the wires, and so it does not have to be multiplied by 2, I do not believe. It is fine the way it is. So.
Okay. When the knot slipped during the static test, the USB cord above the tree slipped closer together. Would this have an impact on the branch deflection?
Can you repeat the question?
Sure, absolutely. When the knot slipped during the static test, the USB cord above the tree appeared to slip closer together. Would this have an impact on the branch deflection?
So I believe the question is the 2 wires came closer together than were touching on the tree. So we measured the motion of the tree, and so we had the initial level of the tree from the camera without any weight, and then we calculated the total deflection after all the weight was added. We didn't calculate the deflection of each part. So the deflection of the tree branch would not have been altered by that motion of those 2 cables coming together.
Do you know how much weight would have been supported by the USB cord and branch given the remains were found kneeling on the ground?
No, well, repeat that one more time, I apologize.
No. As many times as you want me to repeat the question, you got it. Do you know how much weight would have been supported by the USB cord and the branch, given that the remains were discovered in a kneeling position on the ground?
No, I do not know enough data to be able to calculate that out. And we had a limit of only being able to know what load we added to the tree during our test, so I cannot answer that question.
Would body movement possibly add more weight or pull on the branch?
So body weight, body movements, motion could cause a difference in kinetic energy, perhaps, but mass overall would not have changed, so I don't think it would have changed whether the tree would have failed or not or deflected much more. Because the force, mass times acceleration would be same of the core, because the acceleration is just gravity pulling down, so I do not believe that's the case.
Final question. In your experience, would a shorter cable have more or less strength than a longer cable?
I have not tested cables for strength of length, so I cannot answer that question.
Consistent with hanging milk cartons.
Yes.
All right, fair enough. Questions from the, I'm sorry, from the defense?
No, Your Honor, thank you.
All right, from the state?
No additional, thank you.
Thank you, sir. You are excused. Thank you.
All right, folks. Those are the witnesses. That's it.
Is it? How does this defense wish to proceed?
Your Honor, at this point, the defense rests subject to what I put on the record already.
All right, ladies and gentlemen, again, we are at a point where there are some required legal matters for the court and counsel to do.
Not for us. We are at the point where we can fast forward to the state's closing arguments. Oh, good. I hope he gets up and throws another tantrum. That'll be good.
Now that completes the preliminary instructions I'm going to share with you before closing arguments, and as you see, I will give you further instructions at the close of all the closing. Now in regard to closing arguments, because the state has the burden of proof, they will have the opportunity to speak to you first, and at the conclusion of the arguments presented by the state, the defense will then have an opportunity to provide their closing argument to you. And likewise, because the state has the burden of proof, the law of Ohio permits the state to provide what's known as a rebuttal closing argument. I want you to listen carefully to what all counsel say, utilize it as you feel appropriate, but again, as you well know, I caution you that closing arguments, as opening statements, are not evidence, and you may not use what is said in closing argument by itself, unless connected to a fact found by you to have been presented during this trial in the course of your deliberations. This time, please give your attention to counsel for the state, Mr. Sleeper.
Ladies and gentlemen,
Apologize.
my colleague started this
earlier,
trial
that
all
you
the way
guys
back
didn't
with opening
see.
statement, talking about a book and skipping to the end and looking at things. I'd like to talk about something a little different. I'd like to talk to you about a movie. There's a movie called The Usual Suspects. Came out in the mid-90s, where Kevin Spacey is the main character, and the point of the story is he's narrating or discussing events while he's sitting in a police station. Now, spoiler alert on this 30-year-old movie is that at the end of the day, it turns out that Kevin Spacey's character was the main criminal mastermind the entire time. It only becomes clear
The
as
guy
he
used
walks
Kevin
out of the
Spacey.
police station at the end of the movie
Saying.
that the detective then looks and realizes that Kevin Spacey was weaving together a story based on a word that was on the bottom of a coffee cup and some things that were posted on a bulletin board. Only at the very end of the movie then do you see the revelation. And then you can go back and look at the things that happened early on. And suddenly it all starts to make sense. And you see how those pieces fit together that you missed the first time. Now, ladies and gentlemen, in presenting a criminal case, we, as a state, have the burden of proof, and we have to call witnesses to bring to you the evidence in the case. Each witness brings their own piece or pieces of the puzzle. Now, you'd be forgiven for the first week of this case, wondering what was going on. These witnesses seemingly coming in and just throwing random pieces of a puzzle onto a tape. What's it leading to? What's the point? I submit to you that when you get to the end, it all starts to make sense.
I think hopefully they're
So
still
what's the
asking
first thing
that
you have to
question.
do when you're putting together a puzzle? You got to put together the border. You got to understand what you're working with. What are you looking at? Ladies and gentlemen, there's only two possible borders here to this puzzle. One is Emily Noble committed suicide. The other is Emily Noble died of a homicide. Let's talk about that. Emily Noble died of multiple injuries to her face and neck. That's uncontroverted testimony. Nothing to dispute the cause of death. This isn't a situation where she walked into the woods, had a heart attack, and fell into a cable that happened to be strung up from a tree branch. She's dead because of the injuries she sustained to her neck. And there's no accidental explanation for how they occurred. So there's two options, and only two options. She sustained those injuries to her neck because of suicide, or she sustained those injuries to her neck because of homicide. That's it, period. Those are the two choices. Now, the state of Ohio has a burden of proof. It's beyond a reasonable doubt. And we don't shy away from that burden. And the judge has instructed you, and it's absolutely correct. Just because the defense put on some evidence, and just because they raise this argument of suicide, doesn't shift the burden to them in any way. It's our job to disprove suicide beyond a reasonable doubt. But when you listen to their arguments, when you listen to the testimony they did present, you have to ask yourself, was it reasonable? Does it make any sense in light of the other testimony? Ladies and gentlemen, I submit to you that the evidence is clear and that it proves beyond a reasonable doubt that Emily Noble did not die of suicide. Let's talk about how you know that. First of all, there's no note,
So
no communication of any kind with anyone. Hey, I'm really struggling. Hey, I'm having bad days. Hey, I just don't know if I can go on anymore. No goodbyes to loved ones. No explanation. Nothing.
so
Nothing whatsoever.
not everybody leaves a note.
You'll have search history on her phone for 6 months, roughly.
So
What's on there? Not a single thing about suicide. Nothing. It's about plants and weeds and foraging. Well, wait a second. There is that T-shirt with a quote on it about going into the woods. That's it? That's the evidence of suicide? That she was thinking of suicide, that she looked at a T-shirt with a quote about the woods sometime in February? That's ridiculous.
People have been doing that long before
Nothing
the
on that
internet.
phone whatsoever to suggest
That's a
that she's suicidal.
dumb argument.
Who else tells you that? Her friends. Now, guess what? The only person who could come in and talk about how she was doing the entire time is dead. Emily Noble's dead. She can't come talk to you about everything, so we have to bring in people that know snapshots, pieces, that see her at various times throughout the years. And what they all tell you. Did any one of them come in and tell you that they had concerns that she was suicidal, concerns that she was going to harm herself? No. And you know who else tells you that? You know who else tells you that? The defendant. You know when he tells you? The 911 call. He calls right away. He's talking to the dispatcher, and they say, did you guys have an argument? No. Well, no. Oh, was she depressed? No. He tells the dispatcher right away when he calls law enforcement that his wife was not depressed. When Officer Hollis responds to the scene, he tells him that she was the squarest, straightest person he knows. Now, later on when he's talking about it, he's asked, well, she's an emotional person, but no more than any other woman. Even the defendant doesn't bring forth right away talking about her being depressed or being suicidal. Nothing. Nothing. Now, Emily Noble had been through a lot of trauma. No dispute about that. Awful, awful things. Starting from friends dying of AIDS in the 90s, her first husband killing himself, Her dad slipping and falling and hitting his head and never recovering. Her mom dying in a car wreck less than a year later. Terrible things. But what do you hear about that? That each
Chris Mullen, I agree with you 100%. They often do hide it from their family and friends and those closest around them. So the fact that there was no note means zero. The fact that none of them were thinking that. But her sister, the very first witness they called, said, she asked her repeatedly, "Are you thinking of hurting yourself?" Why? Why would she ask her that if she wasn't concerned that she was going to hurt herself? She testified to that repeatedly. When all these people were dying around her, whether it be accidents, doing it themselves, illness, she constantly said, I asked her, "Are you thinking of hurting yourself?" And so obviously somebody was worried about it. And just because he said, no, she wasn't depressed, maybe he didn't want to say, yeah, she was, and then them automatically just go, well, okay, well, she probably just need to take some time. I mean, you never know how cops are going to react to if you call and say, hey, somebody's missing. You hear it all the time. Well, they're an adult. They can be. You say she's depressed? Okay, well, maybe she just needs some time by herself, and they don't go look anyway. So far, I'm not with him.
each time Emily Noble overcame that tragedy, overcame that trauma, and continued on to see the joy in life and the bright things in the world. She got through it every single time, until she married that man. And now suddenly she doesn't survive the trauma. Who was the first witness you heard from? Amy Thomas, Emily's sister. And she told you about their relationship, about they've been around. And she told you that Emily had seen what happens to the people who are left behind when someone commits suicide. You know that. Her first husband committed suicide. Her stepson committed suicide. She knows what happens. And she had conversations on multiple occasions with Amy where she promised that she would never harm herself, that she would never commit suicide. So what is it?
It doesn't mean she didn't have
The
a
allegedly leader
moment
commits suicide in this instance.
where she
Well, it's
just
Joey,
decided
the
it.
stepson she lived with for a little over a year. That's the one she can't overcome? Now, the defendant, in what I would submit to you is one of the biggest understatements I've ever heard, says in his interview, after my son died, there was some tension and stress. She dealt with it differently than I did. Yeah. How did Emily deal with it? Emily took time off work. Emily went to counseling. Emily told the counselor repeatedly that she was concerned for her husband's well-being.
Completely agree.
Now, you're going to have some records of some of these counseling records presented to you with no context, no testimony, but they contain in there statements that Emily made to her therapist. Look at them. There's not a single mention anywhere in there of suicidal thoughts or suicidal ideation. Not a single one.
This is so frustrating.
In fact, what they submit to you show is somebody who was going there, working through the issues, and reported getting better, who went back to work part-time and then says that she's ready to go back to work full-time. They reflect that she's trying to eat healthy, that she's doing yoga, that she's going out into nature, that she's doing the things that she needs to do to put herself on the right path. And what's the defendant's dealing with it differently? He's unemployed, sitting at home, getting drunk. Just ask yourself for a second. We told you that somebody in that house, that one of these two adults committed suicide.
I agree with you 100%.
Isn't it more likely to be the defendant? The one whose own son committed suicide, who never saw counseling, who never did anything to address the issues, would sit at home and drink. But instead, they want you to believe that the individual.
The thing he's not telling you is she was forced to go to counseling for FMLA. So she didn't want to be there. She didn't want to go to counseling. She hadn't gone to counseling any of these other times that these other people had chosen to exit. Why would she tell them the truth? Why would she tell them, I'm thinking about harming myself? That can wind you up in the hospital by no choice of your own. I mean, if you are thinking about doing that, please get help and please don't do it. But it doesn't mean she wasn't thinking of it. It doesn't mean that it wasn't just I just think people might think about it, but I think when the decision comes right down to it, they are not planning it for days or weeks or months. I think it is just a moment they decide to do that. And unfortunately, if in that moment they would just make it through to the next moment, they might change their mind. I just am not following this guy, and it's really sad because they seem very dismissive of her and maybe what she was feeling. And the stepson might have just been that thing, that person, like, how many more people am I going to have to lose? I mean, she was losing, I think, there was like almost maybe 3 years where she lost somebody. I mean, she lost her parents, she lost her stepson, she had lost a friend. I mean, since I think I don't remember, I had notes and I don't remember when her husband took his life. But maybe that was just that moment. That young guy, that stepson of hers, that just went, I can't take anymore. I can't lose another person. I cannot go through this anymore. Maybe that's what it was, but his arguments are hard. They're hard to listen to. They're hard. They just seem so disingenuous. Like, just I don't know. It's like I don't even know what I'm feeling right now. But I hope that Jerry is smarter than what he's kind of thinking, like putting out there that he thinks they are.
Individual who confronted those issues, who sought therapy, who was doing things to get better, is the one who just couldn't take it. That's not reasonable. That's ridiculous.
It's absolutely reasonable.
You heard repeatedly that Emily was healthy, was working out, was taking walks. She's eating dandelions and weeds and other things, which is apparently healthy for you. Probably better than I've been eating in the last 2 weeks. But you heard testimony that she said she was in the best shape of her life. And what'd you hear? Celeste said that Emily had a pin taken out of her ankle. That she finally didn't have that pain anymore. You can see on the body cam when they discuss that, the defendant doesn't even really know if his wife has a doctor. Doesn't seem to really know or care where she works or know any of her coworkers or any of that. But Celeste does. And wouldn't you know it?
Celeste couldn't even identify him from the stand.
Ohio State, Dr. Agnew, looks at those remains and says, there's evidence of previous hardware in the ankle is no longer there. Emily was in a great place. What about any of this would lead you for a second to think that she was going to commit suicide. She was
The
going
only
to kill
reason my
herself.
husband knows those answers is because we see the same doctor.
And what about the timing? What about the timing? May 24th, Emily's birthday. May 25th, the other day that she and her sister Amy are the same age. May 26th, Amy's birthday. You heard testimony that this was a special time for them every year of their lives, from the very beginning when Emily was brought home from the hospital on Amy's birthday. That they would call and talk and have a special conversation, that they're the same age in those days. This wasn't a random day or a random time for Emily Noble. These dates were important to her, meaningful to her. So remember that sister that she promised that she would never commit
And it
suicide
doesn't-
to?
Help you, sir.
Now Emily, without warning, without speaking to anyone, without a note, goes off and hangs herself during that special time?
Who cares
To do
about a
what?
note?
Inflict maximum pain on her sister? Why in the world, if she was going to commit suicide, would she do it then? That's a special and happy time for her. Not a time when she would harm herself.
I can't do this, man. People don't
Let's
do
talk
that to
briefly right now about
inflict
the
pain
defendant's
on
version of
other
events, and
people.
as you might imagine, we'll come back to this again later. But what's the defendant say? You gotta love the body cam. Gotta love the body cam because it shows you what the defendant's saying, how he's acting, and you can see those interactions inside the house. And I'll tell you what,
Exactly.
I want you to go back and watch this. Officer Hollis is inside the house, and he looks in to the master bedroom, and he says, "The bed's made." I submit to you, the defendant, before he even walks around to where he can see, before he even looks in there, he goes, "Oh yeah, I just noticed that."
100%.
And then he says, "She must have made the bed." Because remember, his version of events is they come home from uptown,
Oops.
they have sex, they go to bed, he wakes up in the middle of the night, has to go pee, goes out in the other room, right? So his version of events is his wife, Emily Noble, was in that bed sleeping around 1:30 in the morning. But that bed is made. So, oh yeah, she must have made the bed. So, ladies and gentlemen, the person who has repeatedly triumphed over trauma in her life, the person who has sought treatment,
Has she?
the person who is, by the defendant's own words, is not depressed or had never said anything that would have caused him to call law enforcement to try to get his wife help that she was going to harm herself, the person who's healthy and in the best shape of her life, the person who just went out to celebrate her birthday, who's celebrating a special time of year in her life. She wakes up randomly in the morning, never touches her phone to respond to any other questions or comment or text that she'd received, makes herself a drink, makes the bed, and wanders off into the woods to hang herself.
It's feasible.
Really? What part of that is a reasonable explanation of what happened?
Most everything you just
What part of that
said.
is reasonable? I submit to you it's not reasonable. It's ridiculous. But guess what, ladies and gentlemen? You don't even have to stop there. You heard from
I
a man
wish
named
you
Dr.
would.
Smock. Let me briefly summarize his testimony. That cord, that ligature, it is impossible for it to cause the injuries to Emily Noble's neck. He says the quadruple fracture pattern, the fracture on both sides of the hyoid and both sides of the thyroid cartilage, has never been documented in somebody under 100 pounds in an incomplete hanging.
Document is the key word.
In fact, he tells you in one study, they didn't even document a single fracture of any kind in the neck for any hanging of an individual under 110 pounds. Even complete hangings where the full body weight is being put on that ligature in the neck. Not a single one. Allow me to briefly summarize the cross-examination of Dr. Smock. He spelled Dr. Hardin's name wrong.
What?
all of the bluster, all of the theatrics, it all crumbled when confronted with the testimony of Dr. Smock, who I'd submit to you is the single most qualified person that you heard from in this entire trial.
That's where I'm at, Chris.
He is the expert on these things. On strangulation, on staged crime scenes. And he tells you, based on his training and experience from all over the world, that this is a staged suicide. And what's the response to that? Dr. Garvin, I'd submit to you she's board certified in garbage in, garbage out. She didn't do a full analysis. She did what she termed a case review and spent a lot of time on the witness stand talking about that case review. It contained earth-shattering revelations that Dr. Agnew didn't use 2 standard deviations when determining the age of the remains, or that she only used one method in determining the ancestry. Who cares?
Oh, I'd put
On
Dr. Garvin up
cross-examination,
against
Dr. Garvin
Agnew
admitted
any
that none of
day.
that impacted her ability to review the trauma in the case. Well, the pictures of the trauma anyway, of course, because she didn't bother to look at the actual bones, but the pictures. For all the talk that she had about best practices of not using hydrogen peroxide, and if you read that, it actually talks about not using hydrogen peroxide because you want to consider the possible hazards to the user of this substance, not of the bones. But for all that talk of best practices, she didn't follow the simplest, most straightforward best practice in forensic anthropology. Look at the bones. Look at the bones. So she looks at 2D pictures of this. And what'd she say? Well, she assumed that they were gone. She testified that she has spent 50 hours researching and looking at things here and talking to colleagues and all that, but never once at any point thought, man, I've looked at these pictures and I don't see the same thing as the person who actually looked at the bones. Maybe I should ask to look at the bones. No. Let's talk about 2 parts of her report that matter. The facial fractures, the nose. One person came in and told you they examined the bones under a microscope. They told you that, as you can imagine, sometimes you have to turn things, look, get it in a different light, look at it from a different angle to be able to see all the detail. That's what Dr. Agnew did. Dr. Garvin took a piece of paper and looked at it and said, I don't see the same thing that person did who was actually looking at the bones, following the best practices. It's one thing to look at a photograph and say, you know what? I see the same thing that person did that looked at the actual bones. And spoiler alert, that's what Dr. Garvin says with regard to the injuries in the neck. It's something entirely different to say, I'm looking at this photograph and I don't see it. And then look at the way that she wrote it in her report. No evidence of perimortem trauma to the craniofacial region. But in all the rest of the report, it's no definitive evidence. No definitive evidence. Not the same thing as saying no evidence whatsoever. Now, ladies and gentlemen, obviously, the facial trauma would be a good fact for the state because you don't get a fracture in your nose from putting a cord around your neck in a suicidal hang. But don't for a second think that that's the linchpin of this entire case. The nose fractures aren't what caused the death. That's what happened in the neck. Now, I want you to see if you can spot the difference in these 2 sentences. 1, I did not see anything inconsistent with perimortem trauma to the thyroid cartilage and the hyoid. Or, I agree that the thyroid cartilage and hyoid fractures are perimortem. The first one was Dr. Garvin's testimony on direct examination. Made it sound like she just didn't see anything to dispute Dr. Agnew's qualifications. But in her report, she literally wrote that she agrees that those are perimortem. So what does she attempt to tell you then about those perimortem fractures? That you can't rule out hanging as the cause. Why? Because somewhere a 240-pound man had those fractures in a hanging? Dr. Agnew excuse me, Dr. Garvin can write, she can choose any study she wants. And writing her report, she's under no obligation to spell out everything she's ever read, or where she's ever gone, or anything she's ever learned. She's not to type it all out. But she chose to type out something in support of her conclusion. She picked one study that she says supports what she's talking about. And ladies and gentlemen, that study says nothing of the sort. The Zetkova study, in reviewing 178 cases of hanging, found the quadruple fracture pattern in 3.4% of cases. So already we're talking about in the study that she cited, 96% of hangings did not have those fractures. 96%. Dr. Garvin believed it was important to determine how many of those were incomplete and how many of them were complete hangings. So she emailed the study author. And they wrote back. 3 out of the 6. 3 were incomplete. But that's not all they wrote. Ladies and gentlemen, I submit to you there's a thing that's called a lie of omission. It's when you give a statement that's true, but you admit the other important facts. You're not outright saying something that's not true. When Dr. Garvin wrote in her report 3 out of the 6 were incomplete hangings, that is true. But what'd she leave out? The next part, that the author of the study in his one sentence reply said, by the way, 2 of them are overweight. She leaves that out of her report, but admits that age-adjusted weight is a statistically significant factor in determining whether or not you're going to see fractures. Even worse, that study cites another study that says in cases of individuals under 110 pounds, they didn't find a single fracture. Not one. When you look at the underlying data of the study she cites, it's clear it doesn't support the conclusion. Even within that study, there's something that directly contradicts what Dr. Garvin ends up telling. Because again, we don't care if somebody somewhere in a hanging had that quadruple fracture pattern. Who cares if it's happened ever? What's important is, did it happen to Emily Noble? Did it happen to this 100-pound female who was in an incomplete hanging?
It does matter if it happened ever, because that
And
means
you'll
it could
recall
have
Dr.
happened
Smock
to her.
testified, and he said, there is no such case documented anywhere. There is no such case. And who agreed with him? Dr. Garvin. I asked her on cross-examination, if in the 50 hours of searching and talking to colleagues, if you'd found a single study that ever had an individual under 100 pounds with this quadruple fracture pattern, you would have brought it with you to court. She said yes. The fact you don't have that tells you all you need to know. Even more evidence that this isn't suicide. That proves beyond a reasonable doubt that it's not suicide. Dr. Hickman, the Delaware County coroner. Now, you've heard some questions that seem to give the implication that somehow the state paid for an expert report, and after that, then Dr. Hickman issues a death certificate. But that's not what Dr. Hickman tells you. Dr. Hickman tells you that when he got the report initially talking about the quadruple fractures, he already in mind was saying, this is not suicide. Dr. Hickman might have been the only witness in this trial that really did a good job explaining what this hanging would have looked like. For as many times as defense counsel was down on the ground demonstrating the position of Emily's body, I didn't see her a single time show what would have had to happen to put the weight on the neck, to constrict that ligature. Because it isn't enough to say, I've got a cord tied around the tree and I just rest my head in it. I'm going to do something to put pressure on the neck. And how did Dr. Hickman describe that? That it's a lean into, that you have to lean into the cord, into the ligature. In a complete hanging, you're on a chair or a stool or something gets kicked out from under you and you can't touch the ground, all of your body weight is in the neck. In an incomplete hanging, not all of your body weight is there. And just having a cord around your neck and staying on the ground doesn't do anything. You got to lean into it. You got to do something to make that pressure.
I
Ladies
never
and
took it
gentlemen.
as that's what she was saying. I think she just
Photo.
was asking if it had moved because she'd been there for so long. She had
No end of the
decomposed.
cord is tied around the tree.
And that she doesn't know because she doesn't know where it is.
One, what I call the traditional USB is down on the noble's back. The other end of the cord, what I call a micro USB, the Detective Grubb said fit into some of the old cell phone devices in the house,
Oh no.
has this fat plastic piece on it. And you'll have the real cord. Get it out, look at it. The only thing holding that entire contraption together, loop tied in the middle of the cord, hanging down from the tree, fat plastic piece caught, just like that. Not tied, not knotted, just that. This fat plastic piece caught on a loop. Ladies and gentlemen, you don't need to be a doctor. You don't need to have any specialized knowledge to look at that and say, that's ridiculous. That's not a manner in which anyone would hang themselves. It's not a way that somebody would commit suicide. Emily Noble's death was not suicide. Would submit to you, that's what the evidence proves, beyond reasonable doubt. It was not suicide. Dr. Smock tells you that. He says this was a staged suicide. No one else. Dr. Hickman tells you this is a homicide. This is manual strangulation. The defense witness isn't in a position to opine on that. A forensic anthropologist doesn't tell you cause or manner of death. The only thing that Dr. Garvin is saying is that you can't rule out hanging as a mechanism. Not suicidal hanging, not anything else, just saying a hanging can't be ruled out. And again, I'd submit to you that her opinion is not supported by anything that you've heard of any of the literature, and it's not supported by the only thing that she cited in her own study. So, ladies and gentlemen, if this is not suicide, what is it? It's a homicide. And to be held criminally liable in the state of Ohio for a homicide, we have some statutes. And the ones we're talking about here are murder. And I wanted to give you a little piece of it just to help orient and understand what we're talking about. Count 1, murder. Count 2, murder. They are both called murder, but they have different elements, different things to look at. Count 1 of murder is for purposely causing the death of Emily Noble. And you heard the definition of purpose. Purposely is when it's your specific intention to cause a certain result. Now, what do you have that reflects on purpose? Dr. Smock tells you what it takes to strangle someone to death. It's not an accident. It's not a brief process.
I agree. I think
In
they
order to
screwed up.
strangle someone to death, you must maintain continuous pressure for somewhere between a minute and 2 minutes to cause death. That's purpose, ladies and gentlemen. It says, the purpose with which a person does an act is known only to him unless he expresses it to others or indicates it by his conduct. Anyone who is causing a death by manual strangulation must maintain that pressure for more than a minute. That's done purposely. Count 2, the other murder statute, doesn't require that proof of purpose. It requires proof that the death was the proximate cause of a felonious assault that you'll see in count 3. So 2 and 3 go together. If you find the defendant is guilty of felonious assault for knowingly causing serious physical harm, then you have to look and see if that serious physical harm led to the death. That's what the difference is between count 1 murder and count 2 murder. And again, you heard the testimony of Dr. Smart about the dangers of strangulation, about what happens as you put your hands or arm around someone's neck and squeeze. What happens to blood flow? What happens to oxygen flow? What happens with risks of hospitalization and death? That's serious physical harm. So even if you weren't convinced that this is a purposeful murder, if you're convinced that the defendant knowingly caused serious physical harm to Emily Noble, and that as a result of that offense, as a proximate result, she died, that's still murder and count 2. Now, ladies and gentlemen, we put together the border. We put together the outside of the pieces of the puzzle. This is not suicide. And now I ask you to look at the other pieces. Look at the other evidence now through that lens. Now that you know this is not suicide, let's look at the other pieces. This is a staged suicide scene. Who on planet Earth would have an incentive to stage a suicide other than the defendant?
But what is it?
Random, unknown suspect, the Westerville strangler who's manually strangling women in the woods.
I can't with
Wouldn't
this
take
man.
the time, the effort, the care to stage a suicide. What would be the point? Who else, a random other individual, would have the tools and the items nearby or ready at hand in order to stage a suicide?
I don't know. The guy smoking in the garage?
The only person that would have any incentive to do that is the defendant. But it's
Don't
not
think so.
just staging the scene in the woods. I'd submit to you the evidence shows he was staging the
I
scene the
agree.
whole time. What do I mean? The defense version of events is that his wife, sometime after 1:30 in the morning, because that's when he saw her when he went to the other room, had to get up and go hang herself. Now, what do you need first? You need an opportunity for your wife to get up and leave the house without you knowing about it. Right? If you're awake, she couldn't have left without you knowing. So what's he say? Well, I went to sleep in the other room. What's he say? I took a sleeping pill. And he texted that even to a friend of his. Oh, I'm about to be out. I took my pill.
He took an Ambien, to be
And then
exact.
he says he slept in unusually or abnormally late. How convenient. How convenient. That the one day you sleep in is the day that your wife decides to get up in the morning and wander off into the woods and hang herself. So he's staging that scene with the text message he sends to his friend, and he's staging that scene with his story about, whoop, I can't possibly know what happened early in the morning with my wife because I was sleeping later than I normally do. What else do you need? You can't know where your wife is when you wake up. They live in an 800 or 900 square foot condo. You saw how small it is. You wake up in the morning, you go to the bathroom, and look out the door, and oh, hey, my wife's not here. But no, that's not the testimony. What's he tell you that he did? What's he tell you? I woke up, and I was laying in bed, and instead of getting off the couch and talking to my wife about our plans for the day, I texted her, are we going to this party or what? In an 800 square foot condo?
There are people nowadays that text each other in the same freaking room. So, who cares? There are people that, if one is upstairs and the other is downstairs, will text. I mean, we're lazy. Right? If I woke up and my husband wasn't there, the first thing I would do is I'd probably look on the app that we have that I could see if he was home or not. Before I ever got out of bed. Like, okay, he's here, he's not here. I'll get up, go see where he is. This is just a ridiculous thing. Everybody does it. I mean, yes, like ugh, this guy just makes me want to pull my hair out. And the worst thing about it is, after the defense, I think we're hearing from Jen Psaki's mom. And she's worse. She's angry. She is just an angry lady. I may not have any hair left by the time this is over.
Hey, are we going to this party or what?
Yeah, that's not an unusual
You know what
thing
to
to
It's
text.
that Find My iPhone ad, right? Because it'll give you, look, now when I pull out my phone records, if anybody ever looks at it, see, I sent her this text. I didn't know where she was, and I did Find My iPhone.
Yeah, because we're lazy and
But
we're
then he still
nice
never
and
gets
we
up?
try to be considerate too.
He
Like,
still doesn't walk around. 3 hours later, he texts to this phone that he knows he's got no response on, that he knows is sitting in the house. I guess we aren't going? And what's he say about that in his interview? He says, oh, I guess we aren't going. Where are you? Oh, well, I didn't say the where are you part. Yeah, he forgot that. But again, it tries to leave a record, a stage scene to say, look, hey, I was in this other room. I woke up at 11 something. I sent a text. I had to Find My iPhone. I had no idea where my wife was. What else do you need? You know that you've staged a scene to look like suicide.
she always
know
looks like she's ready to
there's a core.
pounce. I love it.
So Emily Noble, if she was going to go kill herself, what did she need to be looking for? Something to hang herself with. Right? My wife got up, wandered off in the woods. I know that I've staged it to look like suicide. I know that she's hanging by a cord. What does she need? She needs to have found a cord. What's the defendant draw Officer Hollis's attention to? Where does he take him?
An
Right
extension
into the
cord,
garage.
which is
And what's he
quite
point out?
different.
An orange extension cord. And he says, this is out of place. This isn't where it's supposed to be. This used to be here. Watch it again in the body cam. Officer Hollis immediately says, can she even reach that? Watch the defendant as how he has to reach to get that cord even off that hook. And he says, oh, I didn't do it. I didn't move this. But you know what we do know? He was moving things right in that area, even while law enforcement was at the scene. Even after they'd already responded, even after he's already trying to talk to them about what happened, supposedly to his wife. That cooler is moved. There is now a flashlight there. And it isn't just that he moved it. It's that he, at the end, Officer Hollis and the defendant are standing out in the driveway. And he says, maybe I'm crazy, but you just got to come look at this. He leads him right there. He wants Officer Hollis to see it. Hey, look, here's this orange cord. My wife must have been looking for something to hang herself. But we know he's
I
the
don't
one moving
think he
things around
said
area.
that.
And it's not just the cooler. He even says, watch it. He even says, he shakes it, wobbles the cooler a little bit. He says, oh, even this isn't where it should be. Or she wouldn't like that.
Yeah, she has a place for everything.
And he's the
she
one that
did.
moved it.
One of the cleanest garages I've
Ladies and
seen.
gentlemen, he keeps staging the scene throughout. What else is important? When was the last time Emily Noble was seen?
Careful.
Here's the testimony of John Kramer. John Kramer said, when he first saw law enforcement, after he brought his dad home that he was taking care of, he sees the officer there, and he says, I saw Emily Noble on the morning of May 25th. And he tells you he goes inside, gets his dad situated, and immediately comes back out and says he's not sure. You heard that he told that to law enforcement right away, that he told that to law enforcement later, and he told you that from the witness stand. And this isn't a situation that a year and a half or 2 years later he's changed his mind about what he saw.
Well, I think
He
it
told
is.
them that immediately, that he wasn't certain.
But knew what she was wearing.
And
Weird.
how do you know that? How do you know that John Kramer had already said that right away? Because it's in the interview with the defendant. In the interview with the defendant, the detective says that no, the neighbor's not sure he saw her that morning. And what is the defendant's immediate response? Not concerned for his wife. Not wondering what that might mean for where she is. So that makes it look bad for me, I guess. So that makes it look bad for me, I guess.
Pretty sure he was reading the room there,
Right.
sir.
Because he was hoping to hang his hat on the fact that somebody saw Emily or thinks they saw Emily after he.
Oh, no, they did. I guarantee it.
Ladies and gentlemen, you look at the timelines on the phones. I would submit to you the timelines of the phones conclusively prove that the defendant lied repeatedly to law enforcement about what happened. Repeatedly. Emily receives messages at 6:30 in the evening on the 24th that are not read until 4:40 p.m. the next day. There's nothing on Emily's phone to show any user-initiated activity after 7 p.m. on the 24th. Nothing.
That means, you know what that means.
Until the defendant's on. The defendant's phone shows that after they came back from Uptown, out celebrating his wife's birthday, that he has a 34-minute phone conversation with a friend of his. A conversation that is never mentioned a single time in all of the different versions of events that he talks about. We're told that, although the defendant says initially, I told Officer Hollis she wouldn't go out by herself at night. But then he thinks about it, and in his interview, he says, well, and he was like, does she ever go out at night, by herself? And I'm like, no, she doesn't. That's something but she does. At times now that I think about it, especially if she's got a little buzz and she's drinking, she'll get that, and she'll grab a flashlight, and she'll go on this walk and come back with
She
the phone.
had been.
Who told you that Emily Noble went for a walk that evening? That he was sure about? John Kramer. Emily Noble comes home, goes on a walk, while the defendant's on a long phone call and playing around on his phone. After he gets off that, there's a 40-minute gap of time where there's no activity on his phone. Between 8:42 p.m. and 9:23 p.m. 40-minute gap. Defendant knows the place where Emily goes to forage, knows where he can find her. Ladies and gentlemen, I submit to you that's an opportunity at that time for him to go, leave the house, and to go confront her in the woods. And where the physical evidence shows she was struck in the face, causing fractures to her nose, and she was manually strangled, causing 4 fractures to her neck. After that time at 9:23, the defendant's phone screen turns on once or twice, and then between 9:45 p.m. and 1:11 in the morning, there's a 3-hour and 25-minute gap of time when there is no activity on his phone. Time to stage the scene. And then the uncontroverted evidence. The uncontroverted evidence is that he is on his phone pretty much the entirety of the night. You'll have the timeline, look at it.
With what he just said, if he followed her to the woods, and confronted her and did it all then, obviously he had a plan. Why would he not just stage it right there? What did he have to go home and stage? That doesn't make any sense. He obviously, he had a plan already, right? Oh, the other person that saw her that night? Yeah, that same one that you guys didn't look at all. Maybe you should have. He's kind of in this a lot. Oh, he's out in that garage of his watching.
And it's not just loading apps or doing other things, it's sending messages, orientation changes on the phone, plugging in the phone. He's on his phone all night.
I think I have like trauma
Until when?
from orientation changes.
5:52 in the morning,
from
he
Murdoch.
starts a YouTube app. And you'll see on the timeline that runs until 8:40 in the morning. 5:52, he's still awake, activating something on his phone. What happens 8 minutes later? Emily's alarm goes off. Do you think it's reasonable that the defendant, after being awake the entire night, loaded up YouTube at 5:52 and was totally asleep by 6? Remember, if Emily got up and she made the bed and made herself a drink and went off to commit suicide, she's got to be moving around sometime in that morning. And the
Okay.
defendant's awake right up until that time. What else is there, though? At 8:40 in the morning, the defendant's back on his phone. And what happened at 8:41?
Me too.
Amy Thomas sent a Facebook message in a chat that included both the defendant and Emily.
I'm with you. It happens to me too.
I want you to think about that. Come back to that in a minute. Emily's device shows no user-initiated activity until 4:40 in the afternoon. None. The health data shows no movement. The phone doesn't go anywhere from the time when they get back from uptown in the night until 4:40 in the afternoon. And what do you remember happens at 4:40? How do you know that all this stuff in the timeline is what it says it is? Messages that Emily Noble received in the evening of May 24th were not read, did not show up as read on the phone until 4:40 in the afternoon the next day. What happens at that time? We know the defendant says that phone has been there. His wife has not been there. At this point, he's allegedly searched around. At this point, he's the one on her phone. And if you go into the timeline and look, at 4:41 in the afternoon on the 25th, the SMS app, the text messaging app, is activated on Emily's phone. That's how those messages show up read. It wasn't because of anything that Emily Noble did. It's because of the defendant. And what else is important about that? This Facebook message. Remember, the defendant, here's another thing he tries to latch onto. Oh, Amy Thomas says the Facebook message that I sent shows that it was viewed by both of you. It was viewed by Emily and the defendant. Right? And the defendant says, well, then she must have been alive 8:40 in the morning. Now remember, to be on her phone that doesn't move, that doesn't leave the house, that would mean Emily Noble would have to be at home at 8:40 in the morning. And because there's a bunch of user activity starting at 8:40 on the defendant's phone, the defendant would have to be awake too. So there goes the, I was sleeping in the other room and don't know anything about my wife getting up and leaving the house. But more importantly than that, look at the timeline. That Facebook Messenger app on Emily's phone is not activated until late in the afternoon when the defendant gets on the phone, goes into Facebook Messenger, and sends a message to the guy whose house they were supposed to be at on Memorial Day. That's when that message shows up read. Not because of anything Emily Noble did. Look at the phone. The Facebook app flicks on when you receive a message, but it doesn't show any other user-initiated activity. And you heard that testimony from the cell phone forensic specialists. The only time that that app is open and manipulated and a message is sent is when the defendant's on the phone. That's not evidence that Emily was alive that morning. Ladies and gentlemen, look at the other statements of the defendant. Again, I would submit to you, know that he's lying to law enforcement based on what is on the phones, because it does not match his story. Defendant tells you they were in Uptown, they came home, and they made love. So he tells the officer, so he wants people to believe. What's he saying on that Signal app? What's he saying in that chat to his buddy? 2 weeks before this. 2 weeks. My marriage is over. We don't fuck anymore. 2 weeks prior, he's saying his marriage is over. That they don't have sex. And then he wants the officer to believe, well, no, we went uptown, we had a good time, came back, had sex.
Totally believable. They were drinking.
Again, love the body cam. We came back, went to sleep in our bed. Our bed. Really? You ever called the bed that you sleep in with your spouse somebody else's? Not yours? Not ours?
It would be if they didn't sleep together all the
I'll
time.
tell you, how else do you know he's sleeping in that other room? How do you know? He's got a blanket in there. The hamper for his dirty clothes are in that bathroom, not over in the master bedroom. In fact, go back and when you listen to his interview, he refers to that as the master bedroom, her bedroom. Ladies and gentlemen, let's submit to you the evidence is clear. Neither one of them was ever in that bed on the evening of May 24th. When Officer Hollis looks in there and he sees that the bed is made, that stands out to the officer. It ought to stand out to you too. Because either that bed is made because it was made in the morning of the 24th and nobody ever got back into it, or that bed is made because on the morning of May 25th, right before she decides to commit suicide, Emily Noble made the bed. That's
Well,
ridiculous.
I'd probably make mine because I
No
make
one
mine every day.
ever
So.
got into that bed that evening. Ladies and gentlemen, what else do I want you folks on and think about? The defendant's behavior shows that he knows she's dead. He knows Emily's
Yeah.
dead. What's he do? First of all, you
I
hear
loved her.
testimony from John Kramer that he's smoking in the house.
No proof.
He's
That's
smoking in
old
the
John
house.
Kramer.
That Emily would never allow that. And you heard a lot of questions about, can you see ashtrays on these different photos or anything else? You know what I submit to you that shows? The lack of those formal ashtrays is that people didn't smoke in that condo. They did not. That was routine. It was not a routine practice to smoke in that house. Well, there's no ashtray in this picture, no ashtray in this picture. Well, guess what? There's a bunch of empty beer cans. There's a sink, a trash can. I mean, let's not pretend that the only thing you could possibly ash a cigarette into is a real ashtray.
Those were Emily's cans, sir.
What else does he do that he tells you? Did he know she's
That's
dead?
what Emily drank. He's
Ladies
a
and gentlemen,
vodka
he's
drinker.
asked to rate his marriage on a scale of 1 to 10 over the last 6 months. And he says it's an 8. And he says, well, there's some old texts, or maybe we're about whatever, but, you know, this whole Corona thing really brought us closer together. And without any other question, the question was, rate your marriage on a 1 to 10. I did not hurt my wife. I did not hurt my wife. I loved her. May 27th. May 27th. Speaking about his wife in past tense. If your loved one is missing, if you don't know where they are, if you're trying to find them, how would you ever be referring to them in the past tense after such a short period of time? And he does it in other places too. Oh, she loved me. He talks about her in the past tense because he knows she's dead. And one other thing,
Oh my gosh.
about his
Are you about
behavior on the 25th.
Done with your BS.
Ladies and gentlemen, I ask you to put yourself in these shoes for a minute. You wake up, your spouse is gone. You don't know where they are. Maybe you remain calm for a while. You see what's going on. You don't know. You wait. And the minutes and the hours pass by, and you don't hear from them or see them. And you know a place, a short walk from your residence, where they like to go. And you don't ever walk it? You don't ever go out there yourself? The defendant wants you to believe that he checked to see if his guns were there, that he checked up into the attic, that he's looking all over the house, trying to see where his wife could be. He knows right when Officer Hall shows up. He talks about this walking path that they go on. And yet at no point in the 6 hours, even by his own version of events, he's awake before he calls law enforcement or before he calls Celeste. He never goes and looks at the place where he thinks his wife might be?
We can't hold that against him because neither did you.
There's only one explanation for that. One. That he can't be the one to find her.
Oh gosh.
There is no other reason why you wouldn't go looking in a place where you think your loved one is after they've been missing all day. It's that close to your house.
I guess the police couldn't be the ones to find her either because they didn't walk in that area either,
And then,
sir.
ladies and gentlemen, I'd submit to you, he pretty much tells Westville Police Department where she is.
And they didn't go look.
Let's be blunt. Makes the Westville Police Department look pretty bad,
Yep.
those initial days of searching. Nobody got in that part of the woods where Emily Noble's remains were eventually found.
Yep.
It does. It looks pretty bad.
Because it is bad.
But you know who it looks worse for?
Not him.
The defendant.
Nope.
The defendant, even on the knock and talk, when he goes out for a walk with the detectives, and he says, I don't know, you'd have to go in there to look. Not that I'm thinking she's in there. When he talks in his interview, what would Emily do? Well, she'd go into the woods and hang herself. What a lucky guess. What a lucky guess. He gets where she'd be
His son
and how
had
she'd
just
do it.
done that.
And remember, this isn't a suicide, this is a staged suicide. So how much even luckier would he have had to have guessed where she was and how she'd look if it was some other random stranger who had committed the murder? Ladies and gentlemen, the defendant in his message said that his marriage is over. His son committed suicide.
And
If Emily's leaving him, if he's getting kicked out, he's got nothing left. Nowhere else to go.
this wasn't a money issue.
Ladies and gentlemen, there's one last thing I want you to think about. And that's the defendant's words in the last part of the interview with Westville Police Department. What's he say? I know I did not hurt her. I didn't do anything to her. So the other thing that I can think of is that she did something to herself. I know I did not hurt her. I didn't do anything to her. So the only thing I can think of is she did something to herself. Ladies and gentlemen, I want you to consider that statement in reverse. Because I submit to you that the evidence shows, beyond a reasonable doubt, she didn't do anything to herself. Now, I submit to you the evidence shows that the defendant did hurt her. That Emily Noble died of a manual strangulation. That her death was staged to look like a suicide. And the only person who would have done that is the defendant. And we respectfully ask you to return verdicts of guilty on all three counts.
If this does not show you that they will take any little thing that you do, I know I've said this 100 times, and twist it and turn it and make it what they want it to look like. They can take the most simple routine and make it this. Make you sit there. And if they're going to make you sit there anyway, have an attorney. Get an attorney immediately. As soon as they read him his Miranda rights, he should have said, that's it, I want an attorney. He was going to go sit there anyway. They had already decided that. But they wouldn't be able to do what he just did of using his statements against him and twisting and turning and doing whatever with them, because there wouldn't have been any more statements. They would have also used that against him, even though they're not supposed to, but they would have. If it's you, they're going to make it you. If they think it's you, they're going to make it you. That's what I should say. All right. Ugh. Come on, defense attorney. Lay
Lady
something
counsel, please
good
give your
out
attention to
here.
counsel for the defense.
Ooh, look at all those papers. I'm going to say those are probably all the text messages, maybe. She did a really good demonstration with all those. Or demonstrative, I guess, what I should say.
Your Honor, thank you. I want to be really clear about something. Really clear, because nothing could be more important. And what I'm about to say in the next 45 minutes or an hour is what I'm about to say right now. The state of Ohio started their closing argument saying there's two options, suicide and homicide. They just sat down and said that they've shown by a reasonable doubt that this was not a suicide. That is not what this case is about. This case is about whether Matt Moore killed that woman. The state of Ohio wants you, and you know what? We picked you because you were the right juror for this case, and you were smarter than this.
They want you to go into that deliberation room and treat it like a movie or a puzzle, or I guess we're talking Unusual Suspects and books now. They want you to go into that jury room and talk about, did she kill herself or did somebody kill her? That's not what this case is. What you have to go into the deliberation room and discuss is the charges against Matt Moore, the elements of the offenses, and whether or not they have proved beyond a reasonable doubt, not suicide or homicide, that he killed her. The judge has read you the instructions. And there is an incredibly important instruction that reads, you cannot stack an inference upon an inference. You can draw from one set of facts an inference. From the same set of facts, you could draw another inference. But you cannot draw an inference and an inference. And so what does it mean? Literally, 6 days of testimony, 7 today.
Let me know if I need to slow her down. I've got her
Did
at
she commit
1.25.
suicide? No, she didn't commit suicide. So she must have been killed. Well, if she was killed, it's Matt Moore. That's inference stacking, not supported by the evidence. I literally, as I sat there listening to the closing, and I recognize that these arguments are arguments, and so I'm going to say this. 24 years, over 150 jury trials, I've never had a harder closing argument than this, because honestly, I've got evidence to attack. This case is totally speculation. I watched that clock at 1:50 p.m. on August 25th, 2022. I remember telling you, jurors, that times were important in this case, and when I said that in voir dire, I had no idea how important. At 1:50 on August 25th, 2022, I heard, no, you heard, for the first time, that the state thinks Emily was killed in the woods.
Exactly.
And if any one of you thought, when they heard that now he followed her on the walk, and you said to yourself, oh, so that's their theory? That's reasonable doubt. At 1:50 p.m., we heard that for the first time. Our justice system has to be better than this. And you know why? Let's go through it. And before, and you've come to know me, I am passionate, but I am not passionate without a purpose. This inference stacking that I just talked about, it's speculation. And there is no question that the law says circumstantial and direct evidence are of equal weight. There is no question about that. But here is what is not evidence: speculation. We think he did this. We think he did that. Now we think she went for a walk and mad because of a text he sent on May 7th to his friend, that on May 24th, after they've had a nice day together, that he now is lurking and going and following her and killing her in the woods. That's not just one inference and upon an inference. It's probably 8 or 9 or 10. But it's speculation. Members of the jury, I remember when we did that voir dire so well, we talked about why we had to do voir dire. It's because not every juror is perfect for every case. We went back and forth, and we both asked you questions, and you saw us ask some people to leave because they weren't right for this case. But you weren't. You are smarter than to think a man could be convicted of murder based on speculation. In fact, I think the only thing that has been proven beyond a reasonable doubt is that they think he did it. For sure. Now that, for sure, they've proven that. But let's talk about what else they haven't proven. I want to go, and trust me, I'm not going to show you Defendant's Exhibit D again. I won't show you the map. Okay? I know we've had enough of the map. But I do want to talk to you just about why it's so important. Is the judge is going to, of course, you've read the instructions and you have them. And he's going to tell you that the state of Ohio doesn't have to prove the exact date, but generally around the date and time. But you know from the way that Matt Moore has been charged, and more specifically, you now know from their closing argument that what they're telling you is that he was killed on the 24th. That's what they just told you in their closing argument. Now, I realize that they're arguing, but they have the burden. They just told you she went for that 8 p.m. walk with John Kramer, and he kills her after that. Hold them to that. So the search, why is it so important?
I don't think they meant it that way.
Well, it's important because, well, first of all, if she's not in the woods on the 24th or 26th or 27th or 28th, First element of their case fails. And the judge is going to tell you, when you go back in the deliberation room, you look at each and every charge, element by element, on or about May 25th and May 25th. Did defendant Matheau Moore in Delaware County purposely cause the death of Emily Noble? They're numbered 1, 2, 3, 4, 5. If one of them fails, you're done. You don't even have to talk about it. So if the date fails, you're done. If identity fails, you're done. Identity being Matt Moore, you're done. If purpose fails, and I'm going to talk a lot about purpose, you're done. It's not that they have to prove all of them. Any of the elements fail, they're done. That's the law. So here's why the searches matter. If she's not in those woods on the 24th or 25th or 26th or 27th, you're done. 27th, there's a GPS on his car. And, I always want to talk about the transparency of things, or lack thereof. I know you noticed it. It's like I have to bring up GPS with Detective Grubbs. Like, here's an investigative tool that you use to track my guy, and you don't even want to bring it up. You witnessed how many instances in this trial did the state of Ohio wait to see if I did my job? Not just the GPS, the counseling records, the osteopenia, the list goes on. Never bring up any of these things. They wait to see, what can we get away with? Is defense counsel good enough? So back to the searches. She's not there, the 24th, 25th, and let's talk about it. It's not just humans and dogs. No one sees her, no one smells her, but I want to just talk about this whole theory that they've put forth, that it's just bad police work, that they didn't go into the woods. Members of the jury, you are smarter than that. And I remember I was talking to Sergeant Alloway. Do you remember the press conference? And he refreshed his recollection and came back and told you all that the chief of police told Westerville community and the public at large, we searched that area 3 times with law enforcement and once with dogs. Nobody said the perimeter. And here's what else we know. If I'm Matt Moore, and I think that's the word, the main criminal mastermind, and I'm going to talk about whether Matt Moore is the main criminal mastermind in a second, he takes them to the exact area and says this is where she forages, and then even the state of Ohio in their closing argument just now had to concede that, you know what he says? You might want to go in. Oh, that's a bad fact, right? And you know why he wouldn't want to go in? Is it because he doesn't want to find her? Actually, I agree with that. You know why he doesn't want to find her? Because 10 months earlier, his son was hanging from a tree in the woods.
Yep.
I wouldn't want to go in a wooded area either.
And if he did find her, they'd use that against him.
Judge, of course, has told you they don't need to prove motive. We talked about this in voir dire. Totally agree. That's the law. But what the law also says is that the absence of motive, that is, if you say, I just don't see a motive, is something you can consider when finding that he doesn't have the intent. So here's why it's important. Now again, you notice, of course, that I had to bring up the other bank account, right? There was the one bank account, and then it's kind of like, let's see if Menashe can do her job. So now you know you've got the one bank account with 90 plus that was a joint, and then of course there's the other bank account that's 90 plus, and then of course I had to bring out that there was life insurance, which my client never filed a claim against. So let's get rid of any thought that there was a money motivator. And then with the bank accounts, I talked to you about those checks. Now, there's one person in this jury that thinks to themselves, what about those checks? What about those checks? The burden's here. So where's Arturo and where's Paul? But I also want to tell you about the checks. What's the expression? A slow walk? The check to Paul is dated May 5th. So that's incredibly relevant. And the check to Arturo isn't dated June 6th. So that's incredibly relevant. You have them in the back. And if you wonder where they are, you clearly know that they have all the power in the world to issue subpoenas and get people in. And so just even by admitting those checks, it's like that expression that we all know when you just throw things up and you see what'll stick. So then back to the motive, or lack thereof. They presented 3 family friends, Amy, Sue, and Brandy. And I guess this is what the state calls part of the edge of their puzzle. Well, the friends were so close that they hadn't had contact with Emily since 2019. In fact, Sue was last called by Emily when Joey died, and she never even called her afterwards to check in on her. So I'll leave it to you as to the extent of that friendship. And of course, her sister testified. And it's so funny, too, about Matt doesn't go into the woods and search for her. And so that inference should lead you to the fact that he didn't want to find her, and that should lead you to the fact that he killed her. I remember asking Amy about the fact that she didn't come to Ohio and search for her sister was no indication of whether she loved her sister or not. She said, that's right. Why is it okay for some and not for others? And the counseling records. They want to tell you that Emily was happy, she was foraging, eating plants, nettles, and so there's no way she could have committed suicide. This takes me back to my opening, when I told you that this is a case about common sense. When we talked about suicide in voir dire, and we talked about mental health. And I really mean this. We are all smarter, and I know each and every one of you, truly. If mental health were that simple, we would live in a much different world. It's not. It is not that simple to say, they seem happy. It's just not. And in fact, we know that just from history, right? We know that Emily's first husband, you heard her sister testify that they seemed like 2 peas in a pod, and that he killed himself. And it was a surprise to her, Emily. And so I want to just go to the counseling records. And I don't do this in any way to disparage. I do it because it is an inaccurate statement to say that Emily was happy and eating plants and would never have killed herself. Because the truth is, and you'll see in the counseling records, that Emily had a history of depression and anxiety, that she had struggled with prior loss and trauma. Look through the records and see how many times you see the word trauma and loss and grief and sadness. Also, with respect to motive, flip through all the records, and these are Emily's statements made to a therapist in a safe space, right? They're not text messages sent quickly when you're maybe having a beer in the middle of the night and you're talking to a guy and you're doing bro talk. This is what you say to your therapist, right? This is a safe place. The only thing she ever says about Matt in these records is that she's worried about his well-being because Matt's so depressed too after Joey's suicide. She never says, Matt's mean to me, Matt hits me, I'm being abused, verbally, physically, nothing. And I ask you, these counseling records, you will have them back there. Defendants, notably Defendant's Exhibit S. Pass them around. Look at it. In fact, please, pass them around and look at them, because the narrative of suicide wouldn't happen, she had told her friend she wouldn't kill herself, well, that's a false narrative. And something else about that hit me, if suicide were that simple, right? If you knew when someone was going to commit suicide, by logic, wouldn't suicide not even exist? Because if you knew someone was going to hurt themselves, you'd stop them from hurting themselves. This is the thing about mental health. You don't see it coming, and nor does the person. And you know why these friends and family members had these conversations with Emily about whether she'd kill herself? Ask yourselves when you're back in that deliberation room, are these conversations you have with your friends? Or are these conversations friend checks that people were having with Emily because they thought she might kill herself? Because I can tell you, I don't ask my girlfriends at drinks, are you going to kill yourself? I would only ask that question to a girlfriend that I thought just might do that very thing.
Good point.
The text messages.
And exactly right.
I promise you that my closing will not be as long as a stack of paper. This is why I brought this stack up. 1 year of text messages between Matt and Emily Noble sits right here. This is what they give you. They give you this. They give you text messages from November of 21st. Hi, thank you. On the second page of that, he says, why does it bother you so much? Am I mean? Page 63, not mean, unintelligible. And read the rest of it, how they communicate with one another. Because I submit to you that when the state of Ohio tells you how couples act, right? Like how they told you how Matt should have acted when Emily went missing. We're smarter than that too. Every couple's different. Every couple's different. Every person's different. So to normalize certain behavior and to say, oh, well, if you woke up and you saw your spouse gone, the first thing you do would be to call 911. We're all different. And I bet if you look at these text messages, you might well think, I don't text like that with my spouse. Or you know what you might think is what I think is like, wow, is that enough? I better watch my texts, right? And then going to the next set of text messages from December, New Year's Eve, he says, I don't want to argue. If you don't have anything positive to say, keep it to yourself, please. And he's literally asking her, try and be positive. Read these text messages because they gave these to you. They gave these to you to prove motive. I submit that not only do they prove lack of motive, I want to go to this one, where he says the latest set of text messages, by the way, is from March. She kills herself in May. March. I'm not feeling very well today, Matt says. I'm just going to stay in here today. I don't feel like talking. Are we going to the party or what? That's the last set of text messages you have. Of all those, that's what you have. And with the fighting or the argument, I bet John Kramer was right. He heard a lot of voices 2 weeks prior. And if none of us have ever not raised our voices inside of our houses with our partners, bless you. But every couple's different. And you know what John Kramer said that he didn't hear? was any arguing on the 24th or 25th. And there was even a jury question where I got the dates wrong initially, like I think I said the 25th and 26th, and one of you asked a great question. John Kramer, is your testimony still the same about not hearing any argument on the 24th or 25th? And he said yes. He heard no argument. And we know he saw and heard everything because he's right there, and he was what we call a nosy neighbor.
Yep.
He's right there.
I'd kind of call him a
He heard or saw
creeper.
nothing.
He saw like everything.
50%, and this is common sense, of relationships end in divorce. And those that stay together, well, I submit that some of them shouldn't, and those that do probably argue every once in a while. Here's my point. When you look through these text messages with respect to divorce or not wanting to be together or those kind of things, the only time divorce is mentioned is when Matt says, if you want to divorce me, leave me. Just tell me. Never in here, and you heard me ask the detective, does he say, I hate you, I want you dead, I'm going to kill you, I will hurt you? Nothing. Please, read them. The absence of motive can be used by you in your consideration about whether he has purpose. The house. Well, I guess now that there was all that evidence about the house, now we know from the closing that the state believes she's killed in the woods. And so the attic and the cars and the no trace and the no fiber and the no DNA and the no blood, I guess all of those now aren't as relevant. Still, though, relevant seems to be the fact that Matt is being seemingly prosecuted because of all of the interpretations of the ways he behaved. But he let the officers in, he gave them consent, he gave them phones, he gave them DNA, access to the attic, access to the house, all the things that Matt did. And you heard those women talk about how to get from one side of the foraging section to the other, they either had to crawl or they all got burrs. Remember that? And then you guys asked questions about scratches. Okay, well, of course we know that they have Matt's shirt from that night. And we now know that they believe that he killed her when she went for a walk. Okay, so I guess we're drawing inferences. They come home from the bar. Emily changes to get ready for her walk because she's wearing her walking clothes. And then Matt follows her for an unknown reason. And we don't know if he's, according to the state's theory, changed his clothes or not, but we certainly know what he was wearing at the bar. They have that shirt. No burrs, no scratches, no rips, no blood. Remember that question about might you have a fracture in the nose if you have blood from a fracture in the nose? Nothing. And the shirt from the criminal mastermind is in the hamper. The hamper, and still not washed. I want to just talk about the police work. It's one of those things that no matter how many times you say it, it doesn't make it true. No one else would do this. No one else would do this. Okay, well, no other suspects were ever developed. We know on the 25th he's taken into the police station. He's asked to come down in the back of a cruiser, and you saw one of your exhibits is he was read his Miranda rights. Right? This is on the 27th of May. He's their guy. In fact, they continued to work from May 25th all the way to June 17th of the following year to charge him. Because they kept just looking, until they finally found Dr. Smock. Right? And Dr. Smock arrives in May. Because if all this evidence that they've given you is actually evidence, they charged him in June 2021. So the police work. There's no other suspect developed. And if their theory is he's the only one, well, of course we know that actually, based on the evidence, the last person to see Emily was John Kramer.
Yes, ma'am.
We also know what are the odds that two sets of dogs, almost 2 weeks apart, went to the same house after searching for scent? And I asked the detective, did you interview the man that lived in that house? Yes, we did. Where is he? What are the odds? And that was the purpose of my question about that was 2 different sets of dogs, one in May and one in June. And do you remember when Sergeant Alloway was up there? And I said, so the second set of dogs went up here? And Sergeant Alloway goes, actually, they went right back down to the house, the driveway, where the first set of dogs went.
Yep.
Where is he? Where is that investigation?
Exactly.
Well, we don't have it because of tunnel vision.
Exactly.
Police officers ignored Emily's mental health history, her drinking. We know that she had the situation in 2017 where they found her in Westerville. They just ignore it. Just like they ignore, initially in this trial, they wanted to sell you on the narrative that Emily never left her house without the phone. How many times do we hear that? It's like, and then it takes me, Diane Menashe, like it's our burden. I have to bring the cell data out, and I have to show you, showing this remark as defendant's exhibit 3. She leaves the house all the time without the phone, particularly as of late. And let's just put aside the fact about the walk now that they say she took on the 24th. It seems like on the 24th she left without her phone too. And guess when else she left without her phone? The 22nd, because she went foraging with Celeste. And here's why I mentioned this, and why I put together this demonstrative aid and cross Detective Grubbs on it. Because when you have tunnel vision, and you literally get rid of things that don't fit with your narrative, right? That's not fairness. That's not proof beyond a reasonable doubt. Kind of another example of the tunnel vision was just today you hear Dr. Bolte. He did that report. He went out to that scene twice with the Westerville Police Department. It was odd to me that the prosecutor was crossing him on using a 10-foot cord and was like, why didn't you use a 20-foot cord?
Wasn't just me.
Because your own police officers told them to use a 10-foot cord. And so they're crossing the expert that they got. And here's what's the whole value, if you will, of John Bolte, if nothing else. When was the next time you heard from anyone in this case after you wrote your report? It was me. Because they got the report, they got rid of Joe. Just like they got the report from University of Tennessee. Where's she? And here's what I want to say also about the cell data. And this is critical, and I know you didn't miss it, but I have to say it. John Kramer. It's an interesting thing, the phenomena of excusing some for inconsistencies, but never matter.
And charging others for
their witnesses sit up here and say, I need
He's
my
sitting there
report
for.
to refresh my recollection about dates, and we say, of course, dates are hard to remember. Matt gets something slightly wrong, and he's a killer. John Kramer, for the record, did not retract his testimony or his statement to police. What he said is he can't be positive. He's not positive now that he saw her on the morning of the 25th. That's what he said. That's what he said. And so how do we know when John really did see her? Because if he didn't see her on the 25th, what he told you is he saw her the day before. So it takes me to get the location data up on the screen to show that Emily is in Butyl, Ohio, the day before at 9:39 a.m. Then I have to ask Detective Grubbs, how far is Butyl? Hour and a half each way. This is why it is dangerous for the state to have tunnel vision. I know they want John Kramer to see her on May 24th. I know they do. But guess what? John Kramer saw her on the 25th when she went for a walk. And he was the last person to see her. He was the last person to see her. And we know that from the cell data. We know that from the cell data, that he saw her on the 25th. And now they want to say that he retract that. Members of the jury? You need to look no further than Defendant's Exhibit G to know that is absolutely not true. Another Defendant's Exhibit, Westerville press release, released on May 26th. May 26th. Emily Noble, 52, was last seen around 9 a.m. Monday, May 25th. They just told you in their closing argument that John Kramer right away withdrew his statement. That's not true. It's just not true. It's not true. And you're smarter than that. And you know what else? I wrote down in the sticky note, gotta love the body cam. Couldn't agree more, but isn't it interesting that in their burden of proof, they didn't actually follow and give you the Hollis interview with John Kramer outside on the body cam?
Yep.
I know you're smart enough to notice that. They cut that out. Because remember, Hollis goes outside and interviews Kramer, and he comes back inside and tells Matt, the neighbor says he saw her between 9 and 10. And I'm going to show you that clip. I'm going to show you that clip. If you gotta love the body cam, where is it? Show it to us, because it's your bird.
I bet that little prosecutor is just seething right now.
All this stuff about staging. Staging. First of all, Dr. Smock. I think in closing they said that Dr. Smock is the most experienced or qualified expert that you heard from. I'm gonna let that sit there. Judge is going to tell you that reasonable doubt is doubt based on reason and common sense, and it's the kind of doubt that you would rely and act upon in the most important of your affairs. Heather Garvin, when I asked Dr. Heather Garvin, who is a board-certified forensic anthropologist, how many citations or articles or literature did Dr. Smock put in his report? She said none. So I just compare this as an analogy. If you go to a doctor and they say, you say, I got a pain in my knee. And they say, let's open you up, do surgery. Don't you say, maybe we should take x-rays? Maybe we should do a little investigation? Maybe we should get a second opinion. Not with Dr. Smock, because he says, they say, those studies are meaningless. And then they spent all this time talking to you about how there isn't a study of a 100-pound woman with the bilateral fractures from a hanging. I mean, how much do we hear about that? Well, if that's the case, when you go back in the deliberation room, look through all these exhibits, and look your notes, and check and see where's the article that a 100-pound woman with bilateral fractures died of manual strangulation. Where is that article? Or better yet, where is the article that says that I can have a USB cord wrapped around my throat in a way that we don't really know, and then as I collapse and I decompose and my head drops from the decompression, that the ligature doesn't move, or that the weight of my head, 10 to 12 pounds, is my skull. Remember how much pressure you needed, right, to kill yourself. Less than 10 pounds. The skull alone is 12 to 10, or 10 to 12. And then I guess in closing, Mr. Sleeper said, Miss Menashe got on the ground and she didn't even know how to show you. I completely agree, because I have no idea. Who knows? He said in his closing argument, you probably, during the beginning of this trial, sat there and thought, what was going on? I submit to you, you're still sitting here thinking, what is going on? Who knows? We don't even know how the ligature was around her neck, because there are no photos. And they want to talk about this perimortem trauma. I'm going to go there for a second. We know that perimortem trauma is days, weeks, or months. Within that time frame is September. September is months. That's why it's so important. And here's what else you know. Pull that cord out. It's like this, 4 to 5 inches. It's like this long. Which means that when Chad Holcomb went to cut it, he cut one side first, real close. Because you never heard him say, I cut both sides at the same time, or 2 of us cut. And what happens when one side gets cut, right? The weight of the branch deflects, and now we know 3 inches. Do you not think that the branch pulled her up? And then we had the man, Charlie Carlson, that said, I held on to her with, and that's why I said, put your hand up. And this isn't videoed or documented. We have nothing. We have nothing. And how many times do people say how fragile her bones were? Perimortem is within that month frame time. Now again, I don't have a burden to prove that she killed herself. But that's the significance of the perimortem. And this is the staging. I'm just sorry, going back. Won't surprise you. Jumped around. Please, this picture is everything. It's everything because this has all been made out to be so horrific, right? What really happened is Emily went to nature to find her peace. And you'll see that in the counseling records. That's where she found peace. She went there, and she grabbed her ankles. And you know why she grabbed her ankles? So that she wouldn't stop herself from killing herself. And that's what you do. That's what you do because you know that when you kill yourself, your natural instinct is going to be to stop it. That ankle is grabbed. And here's what else we know. In terms of the mastermind, criminal mind over here, there's alcohol in the water bottle. Her vape pen is in her left pocket. And a vape pen on her left side within her reach. Do you know what we do, what's common sense when we're in moments of real stress? We turn to our vices, right? We turn to our vices. And here's else what we do. So if we're going to kill ourselves, we don't want anyone to know. We don't take an orange cord in the garage because we know she's wearing leggings with pockets. We take something that fits in our pocket so that we can go on our walk with our water bottle and no one will think anything otherwise. And in fact, she was right. Because John Kramer saw her going for a walk, and he didn't see anything abnormal.
Or did he, as he
So
followed
let's talk
her?
about the science and then just about math.
Possibly, maybe.
The credibility or lack thereof is for your determination. Again, I can't say it enough. I feel like this whole trial, 40-some minutes of the prosecutor's closing argument was about how this isn't a suicide. We don't have a burden. But with respect to your job as a juror, it's to determine the credibility of every witness. And the judge has already told you that you can believe, disbelieve any, all, or none of a witness's testimony. That's totally up to you as a jury. I submit to you why this is so important and why Dr. Garvin, not just because she was asked to do the work of reviewing Dr. Agnew's report, but why I went through the age and the ancestry and the other things, is because if someone isn't doing their work, best practices, according to what should be done in forensics, right, that goes to their credibility. That goes to the weight that you should give their testimony. And here's what we know about Dr. Agnew's report and the other experts in this case. We know that there's the Montgomery County Coroner's report, there's Dr. Agnew's report, there's Dr. Smock's report, and there's the death certificate. Every single one of these, Dr. Smock, Montgomery County, and the death certificate relied on Dr. Agnew. They told you that. Every single one of these. And members of the jury, I know how annoying it can be. Sometimes with my histrionics and my garbage in, garbage out, and my things. You know what? This is why I said it. This is why I said it in voir dire. This is garbage in, garbage out. You heard from a board-certified forensic anthropologist who said there are no perimortem fractures to the nose. None. With respect to the perimortem fracture to the hyoid and thyroid, she said that anthropologically they appear perimortem. We don't know when those breaks happened, though. We don't know. And if we don't know and you don't know, that's reasonable doubt. And so here's the thing about garbage in, garbage out. If Agnew goes, they all go. And the judge is going to give you an incredibly important instruction about that. He's going to tell you about experts.
So wrapped up, I didn't change my banner.
Give me 1 second, because I don't want to miss it.
Nobody told me.
Thought I highlighted it. He's going to tell you, members of the jury, it's similar to the instruction that you can believe, disbelieve any, all, or part of a witness's testimony, is that if you don't believe Agnew and the other experts relied upon that opinion, they all go. And John Bolte and Heather Garvin, we have no bird to call them. And I do want to address, in case a member of the jury goes in the back and says, well, Ms. Menashe in opening said that she was going to call some other witnesses. I don't have a bird. And there is no question that I stood up here in opening and said I was going to call other witnesses. But here's the thing. I didn't need to. I just didn't need to. It's not my burden. I don't need to assume a burden. Heather Garvin directly refuted Dr. Agnew and is much more experienced and qualified than Dr. Agnew. And they want to kind of dismiss the peroxide issue. Well, the bones were soaked in bleach, and we know that bleach weakens and whitens bones, and we know that the bones had perimortem trauma. We also know that the bones were moved everywhere. They were moved to the morgue, to a cooler, to the slab, to a cooler, to OSU, and now they're apparently sitting at OSU. And I do want to say, because I just want to say this about how Dr. Garvin didn't view the bones. You never heard any testimony that the state offered my expert to see the bones, or that they made the bones available to my expert. And if you're considering the fact that she didn't see the bones, I ask you to consider the absence of that evidence. Did they make them available? Let's talk lastly about Matt Moore. We heard a lot, I guess, the usual suspects. He's a mastermind. He's the same guy, and we're all, if we're not parents, we're siblings and we're children. And he's the same guy that's writing out a statement and asks how you spell the word couch. He asks how you spell memorial. And Matt, I'm sorry, I don't mean to be disrespectful, but he's the same guy that reads while he's writing. When he's writing, he's reading what he's writing. And we all know, as people that have been around children, what that means. And he is clearly, right, not seemingly the most sophisticated person. You've heard him speak a number of times. He uses things like, well, I mean, she's okay for a crazy woman, right? Like, these are the kind of expressions that he uses. It's this same man, though, that would be able to stage a scene, figure out to put the alcohol in the water bottle, put the vape pen next to her because she's left-hand dominant, would tie her shoes so tight that they wouldn't come off, would put her hair tie around her wrist, would take off one of her necklaces, because there's two in the picture on the 24th. He's that same guy. I also just ask you to think about one of the other things that you heard today from Dr. John Bolte. Because remember in the video how he tied the knot close to the branch? And then the basket slipped and the knot actually went tight. Look at those photos, right? Look at those photos, because we know that the branch is taller than 6'3", 6'4". We know that. The cord is slung over the branch. It's not knotted at the top. And if you're going to actually stage a suicide and hang someone from a branch and you're 6 feet tall and the branch is like right here, you knot it to make sure it stays up, don't you? Look at that. She flung it over. With respect to his statements about I didn't do it, he was obviously in the back of a police cruiser being read as Miranda. I don't know if there's one of us that wouldn't say I didn't do it. The use of past tense and the word gone, I obviously cross-examined the detective on the word gone, and his apparent alleged inconsistencies. He's actually been completely consistent about the fact that they came home, during these hours when he's now at the park allegedly killing her, that he was sleeping, that he got up about 1:31 to go pee, to go to the bathroom, and that he was on his phone intermittently the rest of the night. The cell data shows all that. So the time period they're using against him is the time period when he said he was sleeping, when most of us would be. We know that they were out drinking. It was her birthday, and they'd had a long day because they had gone to Buchtel and then his father's house and then out to celebrate, and we're now home. It goes back to that kind of when Matt is slightly inconsistent, we convict him, or rather we want to convict him. When John Kramer's inconsistent, absolutely not here, but here he's truth-telling. When the detectives are inconsistent, we excuse the behavior. It just can't have it both ways. So I want to play a couple snippets. Well, first of all, before I do, I want you to remember this. The mastermind, showing you what's been marked as Defendant's Exhibit X1. Remember when he did this? Remember when he did this? And this. And then in this one, when he turns his hands over. And then in this one, when he looks him straight on so he can see his face. Now, as I close, I just want to say that there's a lot made of Matt's use of words or the controlling mastermind. But there's one thing that we all know, common sense tells us, is we can't control our spontaneous reactions to things. We see something, we react. Nobody's smart enough to be able to control that. So I want to play for you 2 clips. We're going to play the clip when Officer Hollis comes back in the house after having just interviewed John Kramer. Look at his reaction. Oops, we need volume.
All right. So we found a little bit of information. We still don't know where she is yet. Okay. Your neighbor saw her in the garage about between 9 and 10 a.m. this morning. Said she was just standing in the garage. When he was leaving, he saw her. She was just standing there. He said hello. She said hello. This morning. Yeah, around 9, 10 o'clock. He went about his business. 51. Okay.
Doesn't look scared.
Saw her. She's alive. I want to play a second clip. When Matt comes out of his house, and he thinks he sees Emily. And this is, of course, on the 25th when he's called 911.
Hey, how you doing? This her? Yeah. That's your wife? Oh. Okay.
You look just like her for like a second. Oh my God, there's you.
Okay.
And more.
No, Officer Hollis.
Look at how he was, just for a second, I thought it was you. And you remember asking me to ask Celeste, you look like Emily, don't you? And in that first video, he says, oh, thank you, right, with his hand. And in the second video, it's like The shock almost took him over, and he put his hand on his stomach. Nobody's that smart. And not Matt. But nobody's that smart. Members of the jury, I just want to close. I know that the state will get up here and they'll have a significant amount of time to rebut what I've just said. And that's the way the process works. Nothing they can say, though, will change the fact that what they've given you is purely speculation. And I've honestly, in all these years, I've never done a trial where the judge has allowed jurors to ask questions before. But as I was thinking about my closing and how I wanted to end it, I thought about my ask of you as a jury. I ask you that when you go into that room, you ask yourselves, whomever you pick as your foreperson, write down all the questions you still have. Right? All the questions you still have. Put them on the piece of papers like you did so diligently over the last 7 days, and put them all in the middle of the table. Because that stack of questions, those questions that are unanswered, those are reasonable doubt. Thank you.
That was an excellent way to end that. If her closing argument does not bring back the not guilty verdict, nobody's would.
All right. We'll take a very short break, and then you'll hear the rebuttal from the state. Remember the court's admonitions this time. We'll be back in 10.
That was excellent way to end that. She did a really good job. And I would say that the state over there is, oh, I thought it was going to be Jen Psaki's mom. No, that's good, because this guy is, he's just as angry. She did excellent. Yep. If you still have questions and there's doubt. And she called them out for getting tunnel vision, which was great because they did.
At this time, please give your attention to the representative of the state who will provide the rebuttal argument.
I think I can speed this guy up.
Very welcome.
Now, ladies and gentlemen, I'm not going to stand up here for an hour, 45 minutes.
Maybe.
I will try my best to make it short and sweet, because I know as the last person that you're going to hear from, I'm also the last person you want to hear from, because that means the case is over and you can go back and talk amongst yourself for the first time in this case. But I've been doing this for a long time, maybe not as long as opposing counsel, and when you get up in closing and you say, look over here, look over here, look up here, look down here. That's what that closing was. It wasn't a focus on the evidence that you actually heard from that witness stand.
She kept telling him to look at
See
you.
in all of these documents. This is the evidence, and that's what you are to render your verdict on.
Let me know if that's too fast. I'll turn it back down.
Your judgments based on the credibility, your everyday tests that you use to determine the credibility of every witness. That's your job. That's what you render your verdict on. Now, counsel will hold up giant piles of paper and say, well, you don't know anything about this. Completely ignores the piles of paper here that will be littered on your table as you walk through all the facts and circumstances of this case. The piles of paper in your lap from all the notes you've taken over the last 2 weeks. That's the evidence, and that's what we're going to ask you to focus on when rendering your verdict in this case. Now, counsel got up here and started off by saying, suicide versus homicide, that's what the state wants you to focus on. What she ignored or failed to explain is that the reason we want you to focus on those two elements is because those are the two arguments that have been made throughout the last 2 weeks. You have in your jury instructions a discussion about the facts, the elements of each of the crimes charged. You have part of your jury instruction, a discussion about suicide, because that's what's being argued in front of all of you over the last 2 weeks. So this case is about suicide versus homicide. Because if you find that Emily Noble did not commit suicide, or if you find that the defendant, Matheau Moore, committed the homicide, that's when we're going to ask you to reach that verdict. But the reason that's an important distinction to make is because if you don't find one, you find the other. This isn't an accident, as Mr. Sleeper said in the initial close. This isn't an accident where Emily was walking through the woods, she tripped, and accidentally hung herself. The evidence is clear based on pictures that you've seen from the scene over the last 2 weeks, and it's clear from what you're going to be able to see when you go back during your deliberation. And so it is paramount to understand that difference. Now, again, the focus during the last close that you heard from the defendant is, again, let's ignore the state's experts. That Dr. Agnew's report leads to all these other reports, and so if Dr. Agnew's report is garbage, then the rest of them are garbage. You've heard that over and over again for the last week or so when we've been referencing Dr. Agnew's report. The one thing that apparently, again, didn't feel the need to discuss is that Dr. Garvin, the defense's own expert, agreed with the paramount parts of Dr. Agnew's report. So it's not garbage. It's not throw Agnew, and I apologize, you're not going to get as much theatrics out of me, and you haven't over the last 2 weeks. I'm not going to throw pages on the ground to emphasize my point. That's not me. But to suggest that Dr. Agnew's report is completely garbage, and so the rest of this is garbage, flies in the face of what the argument has been made over the last 48 hours, which is that, Agnew's report, which is that Dr. Garvin's opinion is the only one that matters here. But not only does Dr. Garvin, and you heard her testify, agree with Dr. Agnew's parts of the report, talking about perimortem fractures, bilateral fractures to the hyoid and the thyroid cartilage. That's what we're here for. That's the injury. That's what led to the death of Emily Noble. What you also heard from Dr. Garvin is that she agreed with portions of Dr. Smock's testimony. She admitted to you, yeah, I cited this study, but when asked about the specifics of that study that she based her entire opinion on when it relates to whether this could possibly be a suicide, she folded. You could tell from her body language as she sat in that chair. Again, body language that you all saw and body language that you all should consider. She did this. She put her arms across, one arm across the other arm. She shut down. It was difficult when answering questions. Mr. Sleeper had to ask specific questions, and then eventually she said, okay, I got these details, and it doesn't fit exactly what we had in this case. And then on redirect, all of a sudden, arms are removed. She's turning her chair, speaking to you all directly. And again, these are credibility determinations that you're all to make, and that's your job. Dr. Garvin also said on the stand that she was looking for something to refute Dr. Smock. And I highlight that to you because that's very different than when she first started testifying. They said, well, you don't know what you're going to get. When someone contacts me, they don't know what kind of report they're going to get. Could be good, could be bad, could be otherwise. That's my job. That's very different than sitting there and telling you all that she was looking for something to refute Dr. Smock. And you ask yourself, why would she be looking, or why would the defense be looking to refute Dr. Smock? And I would submit to you that's because Dr. Smock told you exactly what happened in this case. Now, Dr. Smock, you'll have his report. He didn't cite to a whole bunch of studies. Dr. Garvin cited to a bunch of studies that we learned later on during the examination were bunk, but Dr. Smock didn't list a whole bunch of studies in his report, but what did he do? He sat there, answered questions from counsel, cross-examination questions. She certainly asked some questions about his background, his experience. And he sat there and he told you that all these years of his experience, handling strangulation cases, he went through his CV, which is 50, 60, 70, 80 pages, as a lot of these CVs are. I would probably suggest you don't read all of those from front to back, but feel free. Dr. Smock sat there, looked at all of you, and explained to you what he found in this case. What Dr. Smock told you is that this was not a suicide. He explained to you why. He showed you and demonstrated in that chair the cord. It's not possible to cause these injuries. He demonstrated that to you. He said that the cord is about 1/4 of an inch in diameter, and that there's a space in between the two bones where the fractures are from, the hyoid up here, and he demonstrated how you could find it on yourself, the thyroid cartilage, and he explained that to you. He explained to you that the factors in this case, in Emily Noble's case, why we're all here, why we've been here for the last 2 weeks, point to this not being suicide. Her weight, not possible. He explained that to you. That in his experience, over dozens of years, not possible. He explained to you that the ligature, again, not possible. He explained to you that all those factors that Dr. Garvin supposedly relied on in the study that she cited, those are factors that all weighed in favor that this is not possible. And he told you that not a single study in his research, his years and years of experience, ever found a situation where someone under 100 pounds presented with those 4 fractures. Bilateral fractures of the hyoid, bilateral fractures of the thyroid cartilage. Now, although Dr. Garvin wanted to find something to refute Dr. Smock, I think it's clear from her testimony she didn't. She didn't. So not only did she tell you that was what she was trying to do, but she also admitted on the stand she wasn't able to. So we ask you to take that in consideration when judging the testimony of Dr. Smock and the testimony of Dr. Garvin. Now, you also heard testimony from Drs. Richmond, Dr. Hickman. They explained to you their portion of this case. You were just told on the closing of the defense that there are no pictures, nothing to suggest where the ligature was, whether there was a knot. And I would submit to you that's completely false. Look at the pictures. The Montgomery County autopsy pictures, they show you pictures of the neck area. They show you that the two cords that went under Emily Noble's neck were intertwined. One went off her back. You can see from the pictures where the cuts were made by BCI when they went out to the scene. And you can also see in the imaging that they did, exactly where those cords were. You also heard testimony from Dr. Hickman that there was no knot. So to suggest that there are no pictures, and there are a lot of pictures, is completely false.
video.
Look at the pictures. Look at all of them. From the ones that were taken on the
Solved a
scene,
lot.
from the ones that were taken during the autopsy. And yes, you may have to look at multiple pictures from different points in time. I'll admit that. But do that. And what you'll find is it's clear how the ligature went around her neck. It's clear there was no knot. And the reason that's important is because, again, all of the studies, the study that Dr. Garvin cited to, the study that was shown by counsel during the questioning of Dr. Smock as well as Dr. Garvin, the factors in this specific case, the only factors that matter to you all, were not considered in those studies. The unrebutted testimony of Dr. Hickman and Dr. Richmond is that Emily Noble died of multiple injuries to the head and neck. Dr. Richmond told you about the hyoid bone and how at that point, that's when they transferred the body from more, transferred the body to Ohio State to continue to evaluate. And Dr. Hickman's testimony on the death certificate is that the death was caused due to manual strangulation. Something that he told you, he determined this was not a suicide a week or so after he initially reviewed items prior to receiving Dr. Smock's testimony, and it was not until later on when that official determination was made and he sat in that chair and explained to you the process, how that process played out, and that's what caused the delay in the time as opposed to just waiting for Dr. Smock's report. Ladies and gentlemen, those are some of the experts that you heard from. You are going to get and you have in your jury instructions that you are to review their testimony amongst yourselves. You determine credibility as you do with any other witness, and you assign the weight that you think is necessary based on all of those reviews. And I think it's clear that you should be putting weight on Dr. Smock's testimony. Dr. Smock, again, as Dr. Garvin agreed with, his testimony, sitting in that chair telling you that this is not possibly a suicide. Now, it's easy in this type of case over 2 weeks to jump up and down, lay on the ground, do all types of theatrics, and I would submit to you, ladies and gentlemen, that at the end of this case, regardless of the outcome,
It's really
Emily
rude
Noble
to
was
call
gone.
her out because I think that's just her
She's
personality.
gone now. She was gone.
That's just the way she
The
does
defendant
things.
called the police and said she was gone. She was gone when he reached out to her sister and said Emily Noble is gone, and she's gone today. This is a serious case, and I think that's demonstrated by the fact you heard 2 weeks of testimony. Now, making the distinction between suicide and homicide, as I mentioned, is extremely important. And as we diligently outlined in our first close and went through the evidence, and I'm not going to rehash that now, I think it's clear from the evidence, from the testimony of everyone that you heard from around Emily Noble's life, there's not a single shred of evidence whatsoever that suggests she would have committed suicide. Not only that, not a single shred of evidence that she would have committed suicide on that special day that she has between her and her sister. Where is it? It doesn't exist. Because that's not what happened in this case. What happened in this case is that the defendant, her husband, Matheau Moore, murdered her, killed her. And that is why she's gone. So let's talk about that. Now, again, you were shown a giant stack of documents and said, look at all these messages, and they just want to show you these little flimsy handful
Because
of
they
messages.
matter.
And I submit to you because those messages outline what's happening in that 6-month period prior to Emily being killed. But I'd submit to you when you review those messages leading up and just a few weeks before the defendant calls police, calls 911 8 hours after he's awake, is that his words, "My marriage is over." What you'll also hear from the messages you heard from the testimony from Emily Noble is that, "I'm not wearing my wedding rings." Now, I submit to you, those are pretty important statements to consider when reviewing the other facts and circumstances of this case. Not the messages about maybe 8 months later, what do you want for dinner? 9 months later, I'm cooking dinner. Even 7 months later, what are we doing tomorrow? The statements that you were presented are statements that are directly related to this case, relevant to this case, to what happened in this case. And that's why you should give it its due weight. Now, what counsel said towards the tail end of her closing argument is that Emily wanted to find peace in the woods and the forest, and that's what she did. Now, we'll talk a little bit more about some of the other facts and circumstances, but ladies and gentlemen, I submit to you that she couldn't find peace in the forest if she wanted to. She had no light source. She had nothing that could illuminate the area where she was found. And that brings me and want to draw your attention to the scene that was found. When you heard original statements made by Mr. Moore, he suggests, well, I left the room at 1:30, went to the bathroom, slept in the other room, and when I woke up the next morning, 10, 11 a.m., she was gone. Suggesting that Emily, at some point in the middle of the night, when it's dark out, early morning hours when it's dark out, went to this wooded area that you heard testimony from the 3 ladies that found her about how it's dark in there, you can't see anything, and they explained to you what that looked like. You all were in the woods. You all saw the exact area where Emily was found. You were there in the middle of the afternoon. So you can discuss amongst yourselves if it was easy to see, if it was hard to see. It's different when you're standing on the street looking up at the sun than when you're 50 yards in, 50 feet in, 60 yards in, whatever the amount was, in this wooded area. Not only that, but instead of being there at 2, 3, 4 o'clock in the afternoon, you have to think that, according to the defendant's statement, to the middle of the night, early hours in the morning, and nothing was found. There's been a lot of discussion about a water bottle, e-cigarettes, but the one thing you didn't hear is there was no cell phone, no flashlight, no other light source, and that's an important fact. The reason that's an important fact is because...
Did you make up your mind when you think she
I'll agree with counsel. Andy Moore's not a criminal mastermind.
passed away?
He messed up. He screwed up. And the reason we know
Yes.
that is from Officer House's body cam. Now, when Matheau Moore murdered Emily in the woods, obviously he would have needed a light source, would have needed something to find his way out of the woods, to climb that real steep hill, trying to get up out of the woods, make his way back home. And unfortunately for him, the one thing he didn't leave behind, besides the water bottle and all the other things, was the light source. He took the flashlight home with him. And we know that because then when he called the next day, reported that Emily was missing, and was showing the officer and telling the officer this storyline, the timeline, it keeps changing every time he's asked about it. About 2 hours into that, during a time period that Officer House testified, he's out in his car. There's nobody else coming and going from the house other than the defendant. It's during that time period that a flashlight appears in the back of the garage. And again, that's the same area that now Matheau Moore is highlighting, saying, oh, look at this cord. This cord doesn't belong here. I might be crazy, but this cord doesn't belong here. And it's not only the fact that the flashlight is there, the cord is moved, but go back and watch that, and go back and listen to what he says. It's not a situation where, I was moving things around and I realized this didn't belong, this cord didn't belong. Officer House specifically asked him, did you touch anything? Did you move anything? And Matheau Moore says, no. You didn't touch anything. You didn't move anything.
He probably didn't meet,
Now, I would submit to you that that was one lie of many lies that occurred over the period that Officer Hollis was there and throughout this investigation. And the reason that is important, not only because I believe the evidence shows that it's a lie, but that's the information that the Westerville Police Department is getting in that moment. The information they're getting is the information that Mr. Moore is providing them. And counsel wants to make show of a press release that went out the next day and other information that Westerville Police may have gotten wrong, now looking back at it years later. But think about what Westerville Police is doing in that moment on the 25th, the 26th.
they're so dismissive of their horrible investigation.
The only information that is being provided to them at that time is information provided by Mr. Moore because he's the last one that saw her alive. So to suggest that, well, Westerville, they were just shoddy police work, they didn't know what they were doing, they got this time wrong, this date wrong in this press release, I'd submit to you that the information that they were working on to find Emily Noble alive was information that was provided by Matheau Moore. Now, You were also just shown a video of Mr. Moore's demeanor when he finds out information from Officer Hollis that the neighbor may have seen Emily that morning. And a lot's been made about the thumping of his chest, his excitement. And I ask you again, go back and watch the body cam. Closing argument is not evidence, just like closing argument for the defense is not evidence. The evidence is what you heard from that box, what you have in the exhibits. And go back and watch that body cam. And think to yourself, what new information did Officer Hollis just provide the defendant?
That his wife was seen that morning.
Nothing. Nothing was new.
It
According to Mathew
confirmed
Moore's
it.
statement, he woke up at 1:30 in the morning, went in the other room, woke up around 10 or 11, and then Emily must have gotten up and left at that point. So think to yourself, why would now hearing that somebody else may have seen Emily get up that morning, the same thing that the defendant said, that's not new information? Is that the reaction you would have if you were just told, hey, maybe you were right? Or is that the reaction that you give when you find out, well, I might get away with this? Somebody may have seen her this morning or thinks they saw her this morning.
Okay.
So go back and watch the body cam footage. Think about the timing. We talked about an opening that, again, you don't just fast forward to the end, see the ending, and make your decisions. You got to look at all of the pieces as they fit together. And so it's not only important to hear what the defendant said, but it's important to look at his demeanor, his body language, and how those actions, what is happening around that. And that's no different than the cell phone records. What's happening around that? What information do we have, or what information does police have up to that point? Does his reaction seem like it's towards something, new information that was given to him, or something different? And then going forward. So please, diligently review that. Diligently review that timeline. And I submit to you that that's not the demeanor of someone that is excited, that maybe his wife left that morning. That's the information he gave police, but it's something different. You also heard that, or saw a video of Mathew Moore seeing Celeste groan when she came to the scene, and Officer Hollis said, "Is that your wife?" And he, "Oh, I thought that was her for a second." Again, ladies and gentlemen, is that someone that's got the reaction of, "Oh, maybe that's actually her"? Or is that someone that acts like that they may have just seen a ghost?
Are you
They see someone that might
serious?
look like his wife. He knows it's not.
Are you?
If he
Oh
was that
my
worried about his wife coming home, he
gosh.
certainly would have spent the 10, 15 minutes to walk down the street to the walking path that she did regularly.
What a.
But no, he didn't do that. He didn't do that either.
Neither did the police. Neither did
So
the
ask
police.
yourself,
Yeah, I agree.
these are all pieces
It
and
does
things
get another
that
one.
are getting thrown around. Things that are, well, look at this over here, look at this over here, but it's important to look at them sequentially as they're happening. As Prosecutor Sleeper said, last week you may have been looking at pieces of evidence and thinking, how does this all tie
There it
together?
goes.
And that's your job now as the
Yeah.
jury. As any case, and I'm sure Ms. Benaschi will agree that we, in our minds, have an idea of how a case should proceed, and we try to keep it as linear as possible, and sometimes that's just not possible. But the reliance is on the jurors to take notes, to speak amongst themselves. The reliance is on counsel to get up in closing and to tell you exactly what sequentially is happening. Now, ladies and gentlemen, what you'll see in this case, and it's been presented over the last 2 weeks, and you'll see when you review the evidence, is that, again, the defendant's not a mastermind. What you can see is something that you all have probably seen in your normal day-to-day lives. Is that
Your buddy
one
called
lie
him one.
leads to another lie, leads to another lie, leads to another lie. You can see that right away, again, in Officer Hollis's body cam. The defendant comes up with a story about this beautiful day he spent with his wife the day before. And now I want you to believe that she committed suicide that next morning. Spent this beautiful day with his wife. They had sex that night. He woke up at 1:30, and then the next day she was gone.
That's okay.
Again, you can see from the body cam that Officer Hollis, who's been doing this for a long time, is seeing things that don't fit with what the defendant is saying. He looks in, sees that the bed is made, immediately says, and you can see the reaction of
Who
the defendant.
cares?
It's like, I just saw that. I just saw that. Thanks for pointing that out. She must have made the bed this morning. And then you can go in there, he goes in there, takes pictures during the search warrant, going on the body cam, you can see the bed, and we submit to you, it's clear that nobody slept in that bed.
How do you know? Can you go
Just
look at
another
my
example
bed
of
right now
lying.
and tell I
Fast
slept in it
forward,
last
a
night?
short period of time later with Officer Hollis in that same bedroom, Mr. Moore's now saying, well, she made the bed, but the pillows are out of sorts, so she must, the pillows don't make sense. Another line. Sleeping pill. I took a sleeping pill. Sending that to his friends, to Arturo, in text messages in the early hours of that night. And it's clear that it's from the phone records, which you'll have, and we ask you to review again. As painful as I'll admit it's painful, but please review those and looking at the timeline of all the events, that the defendant is clearly on his phone up till 4 in the morning, 4:30 in the morning, and then again at 8:30 in the morning. And the reason these details matter, details are important, because you have to compare that to the story that the defendant has been telling Officer Hollis initially when he first came out, that he keeps adding on to, that he keeps going along, adding different facts. The timing is all messed up. That he then, in his interview with detectives, is going through the timeline, and he immediately comes in and says, well, my time might be wrong, but here it is anyways. And when looking at the demeanor, and again, you ladies and gentlemen of the jury, your sole judges of credibility, look at the demeanor, use those everyday tests of truthfulness, the things you can do when you've got your 2 kids, if you have 2 kids telling you 2 different things, and you have to decide who's telling you the truth. Use all those everyday tests. It's nothing special. What you can see in the defendant's interview is clear. The facts and circumstances that aren't at issue. That Emily Noble, Mathew Moore went to Butte, Ohio, went to a few restaurants in Uptown. Listen to his demeanor as he's telling that to detectives. It's fast. It's sequential. It's clear. He's able to give specifics. And then as soon as detectives start asking him about after they get home, that's when the timeline falls apart.
Because who's paying attention when they're at home
That's
at what
when
time it
it's,
is? Who
well, it
cares?
could have been this time, it could have been that.
You're home.
Well, I don't remember. Could have been this, it could have been that. You can go back and review that. You can see the clear change. Because instead of getting in there and telling the truth about what's happening, now he has to make sure that not only is he saying, but he has to remember what he said before that, and before that, and before that. And it's clear you can see that story change and continue to evolve. You can also see that when detectives ask Mr. Moore about his marriage. He talks about it being an 8 out of 10. And then when detectives started asking him about specific messages, Emily taking her wedding rings off, then all of a sudden it's, well, you know, there were ups and downs.
I'm
Trust
sure
me,
there
you guys,
was.
you wouldn't understand. Tomorrow everything would have been fine. Again,
It's probably
we're talking
true.
about specific things, facts that are not in dispute. There's one way of discussing these things with officers, detectives, and a far different way when pressed on specific facts and circumstances in that time period where Emily's missing and where Emily was killed. There was a discussion about some of the searches that were done in this case as well. And I'd submit to you,
lack
ladies and gentlemen,
thereof.
you did not hear a single shred of evidence from that witness stand, any of the documents, any search the defendant was involved in. Not prior to reporting her disappearance, that 6-hour window plus, where the defendant is sitting in that bedroom doing nothing except for being on his phone. Nothing during that, after the report to police, or any of the months after that. You heard from various witnesses that talked about the fact that they went on 10 plus searches and had never met Emily in their life. And I ask you to consider that when looking at the other facts and circumstances. Why would the defendant not want to be involved in the searches? Why would the defendant, who's pretty clear initially to the officers and the detectives that you need to search this area, you need to look in this area, this is a walking path, you should look in that area. Why would he not want to be involved in that search, and why would he have not searched that area prior to calling law enforcement?
Exactly.
Again, ladies and gentlemen, we're not asking you to use special tests. We're asking you to use your everyday experiences, use your common sense, and put yourself in that situation. What would you do? Your loved one is missing for 30 minutes and you don't expect it. Especially if you get up and you see wallets there, cell phones there, keys. It looks like they just disappeared out of thin air. Do you wait 30 minutes before you do something? Do you wait an hour? Do you wait 6 hours before you even lift up a finger? Not until you call the friend, Celeste, who says, what are you doing? Call the police. Not until that happens do you eventually call police. You don't go on a walk in an area that you know she frequents. You don't want to go check to see if she tripped, hurt herself and can't get up, hit her head, had another medical episode. You don't do that for someone that you're married to, someone that apparently you love. Ladies and gentlemen, use your common sense. The reason that man didn't go on any searches is because he could not be the one to find her. He couldn't.
There is no right answer. Period. None. Zero. If he would have went to look for her, he was trying to insert himself into the investigation. He doesn't go to look for her. He's not going to look for her. So he already knows she's gone. If he didn't call then, he didn't call soon enough. If he would have called right away, he called too soon. There is no right answer if they want you. Just know that. There's not one. If he would have picked up her phone and looked at it and looked at it early and started calling her friends through her phone, which he identified it was him. They're trying to make this thing. It's not a thing. It would have been too soon. He didn't do it till later, so it's too late. They're picking out the word that he used. He used gone. I can tell you, I've been out of town and my husband has told people I was gone. So I will tell him to start picking his words a little bit more carefully. I mean, it is, he has zero correct answers. He can pick A, B, C, or D. He can pick all of the above, none of the above, and it's all wrong. He will not react the way they want him to react. He will overreact. He will underreact. He just, everything is wrong. I'm not even saying that they haven't proved that this woman was not unalived. I think she may have been, not by him. But the way they just twist and turn.
And why couldn't he be the one to find her? Because as he said in his interview, that would make him look bad. And I understand that was in a different context, but he knows.
Yeah, it would have made him look.
How's he going to explain it? I got lucky?
It would have made him look bad. Yes. You guys
Speaking
would have
of getting
nailed
lucky.
him. Still.
How lucky is the defendant that he points Westerville police to the exact
I do
area
not
that she
recommend
commits suicide?
reacting like that. He just did.
All the places, the eastern portion of those woods, anyway, any of the walks that they would have gone on, somehow he knows that 4 months later, that's exactly where she's going to be found.
Oh, sure.
As we put it in the first close, that makes Westerville Police Department look bad. They should have found her. But that makes the defendant look far worse. He knew exactly where she was. And he knew exactly where she was because that's where he put her. That's where he killed her.
Yeah, he
That's where
should
he
not
strung
have
her up to make it look like a
reacted.
suicide. And he knew exactly where she was until she was found in September.
Why would he put her that close to home? He could have moved her 100 times.
Ladies and
in
gentlemen, not
4
only
months.
that, but as we pointed out, and as you've heard from the testimony,
I made it so she
not
was
only
never
did the defendant
found.
not go on any searches, but while everybody else, people have never met Emily, law enforcement is diligently looking for her alive.
Law enforcement.
Because at this
was
point, it's a
not.
missing persons case, a day or two after the report. That's when the defendant is not only not searching, but then suggesting that he's not ready to find a body in the woods. He's giving an interview saying, I didn't kill my wife. He's giving an interview where he's saying, I loved her, speaking in the past tense. The only person that is thinking of Emily Noble in those days after her report of being missing, the only person that is suggesting she's already dead, is that man sitting over there.
It's the neighbor. It's the
Ladies
neighbor.
and gentlemen, I submit to you that the reason he's the only person is because the day that it happened, the day after, the 2 days after, up until the time in September when she was found, the only person that knew she was dead and murdered was that man because he did it. And that's the
Don't fool.
defendant, Mathew Moore.
You're wrong. Are you
Ladies
done?
and gentlemen, please,
Ugh.
I understand this is a long 2 weeks. I understand there's a lot of evidence and a lot of things for you to consider. Take your time. Speak amongst yourself. Walk through the evidence. Walk through the timeline. The timing in this case is extremely important. We asked you to do that in opening, and I'm asking you to do that again. When counsel implored you to write down all your unanswered questions, fine. Do that. But ask yourself, what are the questions that matter in this case?
Good question.
Is the question of, were there bubbles in the water bottle, or was it something else? Are there questions about whether her shoes were tied once or twice? Are those the questions that relate to the elements of the offense, which is your job to go through, the elements of the offenses? Those are the questions that matter. Those are the questions that Dr. Smock answered for you. Those are the questions that Dr. Agnew answered for you. And honestly, those are the questions that Dr. Garvin eventually answered for you. So ladies and gentlemen of the jury, please be diligent in your look through of this evidence. And we are confident that after reviewing the evidence, the testimony of the last 2 weeks, you'll make the only finding in this case that the evidence supports, and that's a verdict of guilty on each count in front of you. Thank you.
Good grief. On his little, yes, and closed caption does pick up Dr. Spock. It is Smock, S-M-O-C-K. I had to push, well, I've pushed back a lot on them, but I had to push back even more because anytime you watch a detective or a police officer or anybody that is in law enforcement type thing, every single time they look at the prosecutor, they look at the jury. They look at the prosecutor, they look at the jury. They're trained to freaking do that. They can't not do it. When defense gets up and asks them questions, they lose their memory. I don't know. They don't look at the jury really anymore until the state gets back up and then they start looking at the jury. So the fact that Dr. Garvin looked at the jury when she was answering and then didn't look at the jury when he was cross-examining her and did cross her arms doesn't mean a thing to me because I watch them do it constantly. It just gets so annoying, just the crap they pull. And people need to know this is what is happening. Because this goes on all the time, every day. And people sitting on those juries are just sometimes, I hope this one, sometimes they just sit in there and they just eat it all up. Like from the state. State can't be wrong. They would never make a mistake, ever. And they will. And they do. They're human. All right. Let me make sure. Whoop. If I can hit the button there, that'd be great. All right. Give me 1 second to make this stop doing the little circle-y thing. We're going to go see what the verdict is. Possibly. I don't know what's wrong with my hang on. Oh, now I've messed it all up. But yeah, I thought her closing was really, really good. And if she didn't convince them, then there isn't anybody that's going to convince them. Again, I honestly, the state's kind of gotten me to the point, yeah, she maybe had been unalived, but not by him. So if you don't know, I know a lot of you have been here. So there was a couple comments about the dogs. The bloodhounds on 2 different bloodhounds, 2 different days, tracked to the driveway. It's a shared driveway, 2 houses there. Driveway's here. That's where both dogs track her to. Nothing else after that. She's found 4.5 months later over here. Don't know how that happened. They did walk cadaver dogs around the perimeter there, and the detective said they didn't go in because the cadaver dogs didn't alert. BCI guy, Bureau of Criminal Investigation of Ohio, said he's never had any luck with the few times he's worked with cadaver dogs. So, I don't know. But you know who did know? The bloodhounds. And you guys didn't do anything. Alrighty, give me a sec. So when they go out to deliberate, that light is red, and then when they're done, it turns green. So they've got a verdict. I don't know how long it takes them to get in here, but that prosecutor that gave the first part of the opening looks like he's about to throw up. She looks okay. He looks, he needs a bucket. Something he can get his head over. See where we're at. Come on, get your people in. I don't want to go too far because it's been really weird. All right, he's not in there. There he is. I cannot imagine what is going through his mind. Because of everybody sitting in that room, he knows if he did something or if he didn't. I mean, he knows. Alrighty. I don't want to go too far. Assume they'll stand. Boy, they got him back there fast, didn't they? Have you noticed how on TV when they read, they're like, we find the defendant not guilty, or we find the defendant guilty, and there's all that big long pause, but really when they read them in court, it's like State versus Ohio versus Matheau Moore, case number blah 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 blah. We find the defendant not guilty. All right, we've got to be getting close here. Here we go. Interesting, the other attorney's standing on the other side of him now, instead of him being on the end.
Good morning. Have you selected a foreperson? Juror number 2. Have you reached your verdict, sir? All right, would you please hand them to one of my staff members?
He sounds like he was running, the judge.
Thank you. The court will now announce the verdicts. Verdict on count 1. We, the jury, being duly impaneled and sworn, find the defendant Mathew L. Moore not guilty of murder as he stands charged in count 1 of the indictment dated the 26th of August 2022, signed by all 12 members of the panel. Verdict on count 2. We, the jury, being duly impaneled and sworn, find the defendant Mathew L. Moore not guilty of murder as he stands charged in count 2 of the indictment dated 26 August 2022 and signed in ink by all 12 members of the panel. Verdict on count 3. We, the jury, being duly impaneled and sworn, find the defendant Mathew Moore not guilty of felonious assault as he stands charged in count 3 of the indictment dated August 26, 2022, signed by all 12 members of the panel. Ladies and gentlemen, I cannot personally enough express my appreciation
show
for
the
the
state,
time and the
please.
attention you have given to this court during
I
the
wanna
course
see
of
'em.
this trial. This is one of the longer trials that occur, and you all were willing to give your time and absolute attention to this matter. And you certainly received the thanks not only of this court, but the community as well for your service. As I said earlier, and I believe it again, your participation has strengthened and fully served our institution of justice in this county and everywhere else for that matter. So we have now concluded your service to the court in this matter. I will, I guess number one, I'm going to share with you, you are released from your admonition. So now you may speak to anyone that you wish about this matter. You may review anything that's been going on. It's entirely your prerogative. I will now discharge you, and you can go back to the jury room. I will tell you that I would like to go back and speak to you privately if you're willing to do that. In other words, if you wish to leave, you're certainly entitled to do that. If you'd like to go back, when I concluded my business here, I'll briefly go back and speak to you, share some moments with you, and then certainly you can go on your way. So it's up to you, but I'll have you go back to your jury room now, and we'll proceed with a few things in here, and I'll be back there shortly. Thank you.
Whew. Oh, he's waving at him. Probably flip the state off, and they'll be like, "Oh, I'll just arrest you again for something." I didn't ask if they wanted the jury pulled.
Mr. Moore, I think from day one, everyone's wanted justice for your wife, Emily. And I've heard that phrase a lot, and I think everyone truly desires that. But I think the jury has also said justice for Emily is not injustice for you, and they reaffirm that. I will just formally say I am terminating the bond previously set in this case, and you will be discharged, and you are free to go. We will do that. We have an entry that we'll prepare immediately to cause that to happen. All right. Anything else from the state?
No, Your Honor, thank you.
Anything else from counsel?
No, Your Honor.
I'm going to ask them if they would be willing to speak to counsel. That's really one of the main things I'm going to be doing. So if any of you would like to do that, I will come back out here and let them know, and then you can go speak to them if you wish. Thank you for your service in this case. You did a fine job, and same with you folks. So we are in recess. We will file the verdicts with the clerk. We'll proceed from there. Thank you.
I liked this judge. He's like, "Don't touch me, deputy." I thought this judge did a pretty good job. The only thing that he didn't really ever do when there was an objection, he hardly ever sustained them, which, whatever, doesn't matter. There's no appellate issue there, so that doesn't matter. I'm super happy for him. I think they got it right. And if they didn't, if he did walk out of there having just pulled off the perfect crime, that's the state's fault. They did not prove their case. So I don't believe that. Like I said, I'm on the fence on whether she exited or was unalived. I don't know. I just don't believe it was him. They didn't. I don't want to get in trouble. Garage guy was pretty nosy about their lives. He's the last guy to see her. Don't ever look at him. I don't even think he lives there anymore. I don't even know that he lives in that state anymore. So, but there's nothing else to look at. There is no DNA. I mean, there's nothing. So, if she did not do it to herself, it'll never be solved. Yes, they have. That's correct. They have no actual time of death. They don't know when she was put out in the woods, if she was put out in the woods. They don't know. So, but I will tell you this. If you do not believe, one, that this can happen to just anybody, it can. He's not somebody, he's not a celebrity, he's just a dude. He's just a guy that was living his life. A horrible one. But I don't think he was working, but if he would have been working, that would have been gone. Job would have been gone. The expense of having to pay for attorneys bankrupt you. So I do have one more thing. If you want to see somebody that really did not like this verdict, I'll play it. It's not real long. I got to get through this little weird part here first. Sorry. If you want to see somebody that did not like this verdict, I'll show you as soon as I get the buffering circle off of here. Also, if you'll hear a lot of people make fun of the court TV and the law and crime chat. They seem to think anybody that's charged is guilty. Very rarely do they ever come off of that. A lot of them did in this trial, but it's rare. But let me just do this real quick because I don't need the video. But I do need my computer to cooperate with me. That'd be great. Because I want to read you something. But I have to make sure this video's not going to start playing. I have no idea what is going on with everything today. So, seriously, I swear this is not my first time using a computer, although it may seem that way. I can't make this any bigger. But if you look at the way that Law and Crime framed this, a man allegedly murdered his wife, A man allegedly unalived his wife and made it look like a self-delete. Matheau Moore, 51, stands trial in Delaware County. I forget, I have to wife Emily Noble, like, so we know all this, that they determined it was a homicide. We know she was badly decomposed. So then it goes into his previous wife's. Matt's previous wife, Lisa Peterson, told WBNS News or whoever in June 2021 report that once he choked her when she was pregnant with their first son. It was New Year's Day, 2001, she said. They had been married 3 months. He came over and he did, for some reason. He ended up, putting his hands around my neck, she reportedly said, and he started to choke me. It was the only time he put a hand on her. Anyway, my point is, if you read down a little bit further, it says, once the details were made clear to me, I started to lean towards his guilt. Why put that in here? I purposely did not put it in here because it doesn't have anything to do with the trial necessarily. So this couple here that's not married anymore had lost both of their children. One by, like it says there, he self-deleted, and I don't know what happened to the other one. So Emily's lost tons of people. He's lost tons of people in horrible, horrible ways. But why frame it like that? Why make him look as bad as you can? Right? Because that's what they do. That's what they say. The Zachariah Anderson case, for those of us that watched it, that was a hard one. It was a really hard one. And all I kept thinking was this defense attorney needed to be there for him to do his closing arguments, and he would have walked free. But the obsessed boyfriend, he wasn't at all. It just didn't make sense. But they have to you're right, they sensationalize it, and it's disgusting. All right, I've got to reload this page because it's not working at all. But I want to play you this because I want you to see what this did to his life. And I also want you to see how mad this law and crime anchor was. Just the look on his face says it all. I hit pause. Why are you talking? So that's old Vinny, whatever.
Happen here right now. You have to watch this. As a rare moment on Court TV. It's a case involving a man accused of murdering his wife. You saw it here on Court TV. Let me remind you the case we're talking about. It's the disappearance and then the murder of Emily Noble, or was it a murder? Take a look.
And they still just keep calling
On May
it that,
24th, 2020, Emily Noble celebrated her 52nd birthday with her husband, Mathew Moore. The couple started the day with a visit to the city of Bucktail. Around noon, they snapped these photos after stopping for a picnic at the Field of Heroes, a memorial site for fallen soldiers in Westerville. And just before 6 p.m., they visited several bars nearby. Moore says they returned home just after 9 p.m. that night. After they went to bed, Moore said he got up sometime around midnight, left the room because he couldn't sleep, and laid down in his son's room. Moore said he texted family members and a friend between 1 and 5 a.m. Moore said that he woke up at around 11 a.m. Emily wasn't there, but her phone, purse, and keys were at home. He waited until 11:30 to check in on her. They were invited by a distant cousin to meet at a party that afternoon. When he hadn't heard from her, Moore says that he called police to report Emily missing just after 6 p.m. 4 months later, in September 2020, 3 women who were foraging in the woods west of her condo found her body hanging from a tree. It would be almost a year in June of 2021 before police arrested Matheau Moore and charged him with murder.
Do not move! Yes, sir.
I mean, look how they arrested
Charged
him.
with murder. You saw the trial here on Court TV, but let me remind you what happened at the end. Here's the verdict.
He's like, I can't believe it.
Verdict on count 1. We, the jury, being duly impaneled and sworn, find the defendant Matheau L. Moore not guilty of murder as he stands charged in count 1 of the indictment dated the 26th of August,
absolutely, it was overkill.
2022, signed by all 12 members of the panel. Verdict on count 2. We, the jury, being duly impaneled and sworn, find the defendant Matheau L. Moore not guilty of murder as he stands charged in count 2 of the indictment dated 26 August 2022 and signed in ink by all 12 members of the panel. Verdict on count 3. We, the jury, being duly impaneled and sworn, find the defendant Matheau Moore not guilty of felonious assault as he stands charged in count 3 of the indictment dated August 26, 2022, signed by all 12 members of the panel.
It's a rare moment. It's a rare moment when someone
be.
charged with murder hears those 2 words, not guilty. And it happened. There's Matheau Moore inside the courtroom. Now let's bring him in. Joining us from Las Vegas, Nevada, author of Emily, a staged suicide in Ohio, the man who was charged and acquitted in the death of his wife, Emily Noble. Matheau Moore joins us tonight. Matt, good to see you. Thank you so much for joining us. This is a rare moment for us. I'll be honest, I hardly recognize you because you look much more relaxed and the hair is growing out. How are you doing tonight?
I'm all right, Vinny.
Okay. I want to go back to what we just saw. And it's rare that we get that actually happens in a courtroom. And we were there. Try to explain to folks at home what the moment just before the jury reads those words, what's going through your mind? What are you thinking about? And then what is it like to hear the words not guilty spoken?
It's a hard feeling to express. I had prepared myself for the worst. I figured I'd be better off if I just prepared myself for guilty than I was for not guilty. So when it was not guilty, it was just, I wasn't prepared for it. And it was just this emotion, like this, it was all this pressure that was built since the day I called her in all the way up until that point was just this 2 years of pressure that was just, it just came out. It just let go. It was just so emotional. It was a rush.
And you had been in jail all this time, right? For more than a year?
I called her in. I was arrested 13 months after I called her in, and I was in jail for 15 months. So over 2 years.
So
in jail for 15.
Right, in jail for 15 months. So
but, I mean, outside I was like being in jail. I mean, it was horrible. The 13 months that I was accused of murder on the outside was awful.
Well, what's it like now? You're in Las Vegas tonight. I don't know if you've moved. Have you moved? Are you still in the same town? And what's it like when you interact with people now that you have been proclaimed not guilty by a jury?
It's surreal. I got out of Columbus as soon as I got out of jail. I just left. I left as soon as possible. I was told to get out of town because it wasn't safe. So I left.
Who's telling you to get out of town?
I mean,
who's telling you?
Family, people just being like, you're better just off getting out of here. Lawyers, sure. Cut your losses and get out of here. Don't sit around here trying to fight things. Just leave, So you got your freedom, man. I mean, just go.
Now, you've written a book, Emily, a staged.
I have, thank you.
Emily, a staged suicide. Let's start with the title. That's the prosecution's theory against you. That you murdered her and staged it as a suicide.
That's what they coined it. It just felt right, like the right name for the book. And when you're accused of something like this, right from the beginning, I was told, right when I first got a lawyer, right in the beginning, you can't say anything to anyone. On the phone, you're being recorded. Your phone calls are being recorded. You can't say anything to anyone. So it was like this entire over 2 years of me not talking and telling anybody my story. As soon as I got out, I knew I had to. I just had to put it down on paper, not really to sell a book, just to get my story down on paper so I don't forget things. And that's basically what that is. It's just me telling my story.
What do you think happened to Emily?
She committed suicide. She went up there it was either when John Kramer saw her in the morning or the evening before when I heard her leaving. If you read the book, it's in the book. There's a lot in the book that wasn't at trial. There's a lot I remained silent, so I didn't tell my story. Not even to my lawyers. The what happened that night is in my book. And she committed suicide. I mean, unless there's something that I don't know about, but I just don't, I can't see it. I can't see it happening. It's too odd.
Now, this is something I've always wondered about. You're accused of a crime, right? You say you are 100% innocent. The jury believes the case was not proven against you. We witnessed it ourselves here. Your demeanor, the way you are, did you want to scream? Did you want to yell at someone? Was there anger? What is it that's going through you? They're accusing you of murdering your wife. Murdering your wife. And
you can't. You can't say anything to anybody. You're literally just waiting. You're just waiting and waiting. It's just
how do you?
It's horrible.
Did you have an urge that you wanted to scream? That you wanted to get angry with someone who is saying you are a killer? You should never be free again.
By the time I was in court being accused of those things, I was so beaten down. I mean, it wasn't anything for me to sit there and take that. It really wasn't. It was, and their case was so weak. I don't know how to, they really didn't say anything that I thought was damaging ever.
Let me ask you this. Let me ask you this, because I cover cases all the time. I'm a former prosecutor. I'm always very transparent about that. I always say there's a difference between someone could be not guilty, but could have committed the crime because there's no evidence that they did it. And then there's people who are not guilty because they are innocent. Now, obviously, you are saying you are innocent. In your book,
100%.
In your book,
100%.
do you express this? Because you don't tell your story to the jury. So is the book the vehicle for you to talk not about them not proving it, but you showing that you are innocent?
It's me showing that I'm innocent. It's me telling my friends and my family, the people I care about, and her friends who I used to care about me and her family, the story about what happened. It's more of like my story to my friends and my family about what happened. If you really want to know what happened, because I get intimate in the book, I tell you everything. There isn't anything I'm holding back from anybody about anything. We actually discuss my trial every Wednesday online with these people, and it's called the Alternate Corner. It's a YouTube page. Every Wednesday we get together during the day and we discuss the trial. If at any point you want to call in or send a message or have a question about any of it, I am there to help answer those questions, because there's so many questions that people have because they don't know. The story that was told by the prosecution just isn't true. I think Diane, my attorney, proved that at trial, I think. I mean, it wasn't really hard for her to point out that their story didn't make sense, because it did, because it's not true.
Is there a level of resentment or bitterness that you have? 15 months, accused murderer? I mean,
I'm homeless. I'm literally homeless. I was wiped out financially by this completely. I mean, they came in and they just destroyed me. I was retired at 49. I had enough money and everything was paid for. and it's all gone. Resentment. I'm happy. I'm free. I'm really happy. But am I upset that they took all my money from me? Sure. Yeah, sure. Who wouldn't be? Under what? Why did they do this to me? You tell me. You probably are around this more than I am. So I mean, why do police and prosecutors knowingly prosecute a guy that's innocent, knowing that they're innocent? Why do they do it? You tell me. Money. I would just think it was money. The guys down at Westerville Police Department, I mean, do they really know what's going on? No. Do they care? No. It's money.
It's okay,
What's
Vinny.
from your perspective, right? So is there something, and this is a big picture question, is there something in our system from your perspective, having gone through what you've gone through, that should be changed? Because you got accused, you got your day in court, and the jury of your peers sent you home. But is there something that the system can do better?
I don't know. I don't know how you fix it. From what I brought up, to think that our system's probably the best, comparatively speaking. I mean, you're going to have collateral damage. There are people that are going to be innocent that's going to get sent away. But for the most part, they're just trying to put as many bad guys away as they can. But you have to know that there are people that are going to get clipped like me that are innocent. And I think it's happening way more often than we think. I think there's tons of people that were in my situation. I had money to get an attorney, but if I didn't, who knows how it would have turned out. How do you fix that? I don't know. It's America, right? I just don't know how to fix it. But I mean, there are people that are in prison that are innocent, that are as innocent as I am, and they're there. It's horrifying to think that. So how do you fix it? I don't know.
So what would you say to people who are like, okay, well, is there something you can say tonight that for people who watch this trial and know the background, that maybe didn't come out in the trial, or maybe it did come out in the trial, that's like, this is why I'm innocent, why it's impossible that I could have committed this murder?
You just have to watch the trial. It's all there. It's easy. The jury was out for literally 10 minutes. There was no evidence against me except circumstantial evidence.
I get it. I get that they didn't have the evidence that you did it, but is there something that says well, listen, this is why I'm innocent. Like I'm not that you can't prove it, that I'm innocent.
John Kramer, my neighbor from across the street, saw Emily after the fact on Monday between 9 and 10. It's undisputed. He saw her. And they say I killed her the night before. She was alive the next day. And there's other pieces of evidence like that all through it. What more evidence do you need? I don't know what else. I mean, there's people out there, it doesn't matter what you show them. They're just going to think I'm guilty. It doesn't matter what you do, what you say.
True.
So are you able to walk around? I mean, the first thing I said is your appearance has changed. Is that on purpose, or is this just the way you like to be, or is it to for people not to recognize you, so you can just kind of live a relatively normal life?
I'm not worried about people. I really am. I'm not. I'm back home. I'm in Vegas. People here know me. I wouldn't want to live in Westerville, but I'm not. No,
so Vegas is your original home.
25 years before I moved to Westerville, yeah. So. And
I mean, do you get it? Do people treat you any differently than they did before? Like, is there like a little?
I've lost a lot of friends, and I've lost a lot of family that just don't know, because they want to believe police, they want to believe government. I don't blame them, but I mean, if you watch my trial, I don't see how anybody could come to any other conclusion that I was innocent. There's no evidence that I did. None. Zero. So because I spoke to her in the past tense 2 days later, that's evidence to you that I killed my wife? That's stupid. That's ridiculous. You can't. And I had a jury that was smart enough to see through all that nonsense.
Did you ever have an opportunity to speak to any of the jurors?
Yeah, I have a really good friend. Her name's Connie. She's going to be on Dateline tonight, actually. She's been a Facebook friend when I came out with the book. She wrote a review for me for my book. She's been she's a sweet lady, and she's become a really good friend of mine. Her name's Connie. Juror number 8.
Juror number 8. Juror number 8.
Juror number 8.
Now,
Sweet lady.
the smile that we're seeing tonight, is that legit? Like, is that like there's
Sure.
there's happiness? It's real.
I'm free, man. I mean, they tried to murder me. I was up against the state of Ohio. Those people are intimidating. That whole thing is intimidating. I've never been up against anything like that. I just thought I was going to go to prison for the rest of my life. I had no idea. And then Diane, my lawyer, I mean, I can't believe that it all fell into place, and they came in and they saved me. So I feel saved.
All right, before we run out of time, I want to
I don't know what happened.
ask you an open-ended question. Again, the name of the book is Emily, A Staged Suicide. Is there anything else that you think people should know or you want to tell people tonight about the book, the trial, your life, our system that I have not asked you?
Well, thank you. Appreciate that. Very nice of you. The media, watch out for the media. Don't always believe everything they're telling you. They're selling something, right? So you have to take that into account. I was guilty as guilty could be in the eyes of the public because of the media, not because of anything else. And so just be wary when you hear things from even court TV, if they might come on and say, push things one way or the other. And the other thing is if you ever get in trouble and your spouse goes missing, you're going to need their help to find her. So you're going to be talking, but get a lawyer as soon as you can. That's just the most important thing, because they're going to take what you say and these little discrepancies here and there, and they're going to use it against you, and they're going to bring a charge against you. So you just get a lawyer as fast as you can, if you can afford one.
Well, Matt Moore, great to see you tonight. I appreciate the time. This is a rare moment for me to speak to someone who's been through what you've been through. The name of the book is Emily, A Staged Suicide, and
All right. I hate that this is a rare moment. This should not be a rare moment. This should be a good moment. This should be we shouldn't he hated that. He hated that. Like, how dare he be found not guilty? I don't know what Vinny thought. But I think he thought he was guilty. Because you could kind of tell when he said the media, Vinny's just like, oh, okay. Yeah, you, Vinny. And your whole network. And the other network. You guys ruin people's lives. This guy lost everything. Can you imagine being retired at 49? That'd be freaking awesome. And now you have nothing. He's homeless. I don't blame him for getting out of Ohio. I would never go back. But they frame these things in such a way, and they know what they're doing. And yes, Kim, you're right. This comment up here. The nickname they give trial says it all. It's awful. They know what they're doing. And Chris, you're right. It is it's to sensationalize everything. It's to get clicks. It's to get views. But at what cost? Like, this guy's life is ruined. I mean, I hope it's not ruined. I really, really hope he, can do something positive with it. But I hate that he just kept saying, this is a rare moment. This is a rare moment. Like, no, it should not be, but it is. A different jury, he's gone for the rest of his life. A different defense attorney, he's gone for the rest of his life. I cannot imagine what that's like. I don't want to ever have, I hope to never have to know. And I don't want anybody else that shouldn't know to ever have to go through it. If you've done something and you deserve to be in prison, then I hope you're there. I mean, but he's right. There's always going to be that camp that thinks he got away with something. They're not even going to, it doesn't even matter. You can show them whatever you want. I think with some people, like talking about like Zachariah Anderson, we could walk Rosario in there, or Rosario, whatever his name is, and be like, here he is. And they still wouldn't believe it. And yes, you are exactly right. She is. And she lies so much. Oh my goodness. That woman is. Ugh. And I used to like her when I was younger. And Court TV was like originally on way back in the day. And it was all of them. And uh, there was her. I don't remember, but I liked her. And my mom kept trying to tell me uh, that I shouldn't. But I was like, I like her. I didn't have anything to compare her to. I didn't have anything to say she was telling the truth or she wasn't. I didn't have anything. Now I have seen enough of her to go, okay, yeah, I don't like you so much. And I think Kim, yes, Court TV definitely got it wrong. Law and Crime got it wrong. The state got it wrong. But I think it hurts him. I think it hurts his heart that he was found not guilty. I really do. Like he just looked. He had just a pain look on his face. Like how? Yes, I felt bad for Nancy Grace because of how her fiance's death was horrible, and I do feel bad for her about that. She is the worst at sensationalizing everything and making a thing out of nothing. I can't watch her anymore. I mean, she would have been just all over him, like all over Matt Moore. She would have just been, "You're guilty, right? You did it, right?" I mean, just make it. I don't know. This trial, Travis Rudolph gave me some faith back in the system because Zachariah Anderson's trial just absolutely wiped it all out from me. And I couldn't actually even watch a trial for a couple months after that because I was like, I can't take any more of this. I can't do this. So yeah. But that one hurt. All of us that watched it was crazy how we all reacted. Um, and there's still just those people that are so dug in. I'm like, on what? What are you dug in on? There's nothing there. There's nothing there. I am not going to watch. I know I'm getting off topic here. I am not going to watch Killer Cases that has his case on there. I'm not going to watch it. I usually kind of like to watch that show because it's an A&E show, so it's the other side of it's. They kind of, Law and Crime. I know that's Dan Abrams, but Dan Abrams does a lot of work on A&E stuff, and sometimes you get to see things that you didn't get to see in the trial. But with that trial, I don't know what they could show that they didn't show in that trial because there wasn't anything to show. So I just don't want to be mad again. It's really hard for me to look back at that trial. So I won't. I know it's set to record, but I will not be watching it. So I'm going to ignore that one. But anyway, so I don't know what I'm going to do next week because with the holidays coming up, there's not going to be a whole lot of trials. I had thought about trying to do the Hannah Payne trial, but that one started way earlier and there's no way I can catch up. So I think I may just try to find some short things to do. So, not all day things and just go from there till after the first of the year. But I'll have to figure it out over the weekend. So, but thank you everybody for being here. I appreciate it. This day was hard for me. It was really hard for me to keep my mouth shut with that, especially those two prosecutors, because she was lying so much. Well, on that Rule 29, like I could not do it. But too bad for them. I wish they would have had Matt Moore's on face over here because I mean that's who you want to watch. But man, when they said that first not guilty, I wish I would have went over here so we could just see the state's reaction, especially the one that stormed out of the courtroom. He looked like he was about to throw up before they even got back, so he probably did throw up when the first not guilty came in. But anyway, we'll figure out what we're doing Monday. You guys have a great weekend. If you haven't already, please hit that like button, subscribe button. If you're on Rumble, it's thumbs up and a follow. I would appreciate it. So I will plan on being here Monday at 10:30 with something. I have no idea what yet, but we'll figure it out. So have a great weekend. I think, Chris, are you already into the weekend where you're at? Is it Saturday there? Are you, I was trying to figure out where you were. Hang on, I gotta wait for the delay if she's still here. Yep, it's Saturday. Okay. I will not forget my grand dogs, Bree. Okay, Australia. I was going to guess Australia. So yes, I have to go feed my son and his wife St. Bernards for the weekend. So that will be fun. Just a fun fact, and then I'll go. My male Great Dane and their male St. Bernard are nemesis and hate each other. So anytime I go over there, their St. Bernard, like, I smell my enemy. And then anytime I come home, my Great Dane's like, I smell my enemy. So it's always great time. Great times. Alrighty. I am out. Thank you guys. Oh, 8:09 a.m. Boy, you were up early. Yikes. That's crazy. It's Saturday morning over there. Under there. You're under. Alrighty, guys. Chris, enjoy the rest of your weekend. Everybody else, enjoy the start of your weekend. And I'll see y'all Monday.